Welcome to the Ada K Show. I'm your host, Ada K, and I am a criminal justice major. I am also a deaf courtroom commentator, breaking down the gripping courtroom drama while providing full ASL interpretation, making justice accessible to everyone. Grab a cup of Java and let's dive in. Don't forget, comment, like, and subscribe. And if you love this channel, please become a member. Good morning, everybody. Sorry, that ended pretty abruptly. Good morning. How are y'all doing this morning? I'm good, but I'm moving slow. Like, how slow can I get away with moving today? Just saying, just moving slow as I go. What in the world? Oh, okay. I hope everybody had a good night's rest. When I went to sleep, I slept like a baby. Problem is when did I go to sleep? Today's Friday. Okay, I didn't miss it. I got a paper due today. Today, we are back into the Dima Tower trial, where he is accused of unaliving his parents, adoptive parents. Before I get into a recap, I want to go over here and say hello to you guys. Good morning, Miss Angela, Turtle Mom, Red Panda Power. How we go? Sarah, thank you for joining one sunny day. Marissa Maroon, I've got an answer for that question. I have an answer for that question. Does anyone know why the defense didn't request a psych eval? I got your answer. That was one. Oh, there you go, Kitty. Okay, you can have it. That is one reason why I came on a minute or two late, because I saw that question and I was diving in for the answer. Perhaps a client objected. Could it be? Is that possible? That is a good question, though. So we're going to dive into that a little bit. So, are y'all ready for good morning? All right, here we go. Ladies and gentlemen, welcome to my channel, where I am in a weird mood. Yesterday in the Sarasota County Courthouse, the courtroom felt silent, and I mean dropped dead, no pun intended, silent, when Dima himself took the stand. It was a chilling moment, and he admitted to the brutal murders of his adoptive parents, Jennifer and Robbie Tower, describing how rage drove him to stab more than 140 times between the two. Today, we are revisiting a little bit of that testimony during breaks, but let's kind of look a little bit into what happened. In the confession on the stand against his attorney's advice, Dima Tower testified in the Sarasota County Courthouse, admitting that he unalived his adoptive parents in their Northport home on August 31st of 2023. He said he stabbed Robbie while he was asleep. He then chased Jennifer to a neighbor's house and then stabbed her to death. The police response that night, the officers, when they responded to the disturbance on Millcott Road, were horrified. Tower had fled in a car, leading police on a chase down I-75 before he abandoned his car and running into the woods. Prosecutors emphasized that Tower's motives were pure rage, citing 140 stab wounds inflicted on his parents equals rage. Tower himself admitted he had thought about killing his parents before, but not to the extent that it has led to believe prior to his testimony. He said he only thought about it once, and the second time he actually did it. Tower became very combative on the questioning on the stand, forcing the judge to intervene multiple times so he would answer the prosecutor directly. Yes, Dima Tower did undergo a psychological eval as a part of this trial, but the defense has not presented it as a formal insanity plea. Instead, his attorneys have leaned on the history of trauma and rage argument for the manslaughter rather than the premeditated red room. And there's your answer. Yes, they did. No, they didn't use it. Obviously, I don't think they used to, because I don't think it helped them, in all honesty. And I'll be honest, sometimes people don't understand. So dry, this lipstick's drying. People don't understand that. How do I put this? It's hard to test somebody that has either mental delayment or like deaf people. People with different abilities or the lack of abilities, like disabilities, are more difficult to test and get an accurate. Oh no, I'm running out. Not today. Have accurate results, in all honesty. And if he was the way he was on the stand while getting tested, I don't think the test results would have been valid. And I would venture to guess if he was the way he was on the stand, the test results are not valid, and thus couldn't use them. That is all my red. I just saw red Panda Power pop up. That is all my speculation, but I do have a little bit of knowledge in this, being that I used to work in a state hospital with a forensically mentally insane. So yes, he did have one. They're just not using it. Angela, yes, Red Panda's on your computer. How else would she get to see me this morning? No, I'm giving you a hard time. Red Panda says, you on my putter? Yes, that's on the putter. I just feel this wasn't handled right. Dima is clearly broken and traumatized. There was a psych eval. They didn't use it. Yep. You got that right. That's a good, yep. There's your answer. Can't imagine Dima would be difficult to evaluate. Yeah. Okay, y'all. So let me get us going in court. I wanted a little, I'll be honest, I wanted a little bit of a lead time, so I've kind of talked a little bit longer. Oh, I forgot. Happy birthdays. We only have a couple. Let me turn it down so it doesn't blow your ears out.
Happy birthday to you. Happy birthday to you. Happy birthday. Happy birthday. Happy birthday to you. Happy birthday to you.
Happy birthday, Christina, Marie, Susan, Elizabeth, Kevin, Eric, Shaya, and Lauren. Happy birthday to all of y'all. May it have a wonderful day. May it be a blessed day. And may you be blessed mightily and feel the love of those around you on this special day. All right, now we're going to get into court. It's going to be interesting today, y'all. I know that much. Thank you, Court TV, for your feed as always. We appreciate your kindness and sharing your feed and allowing us content creators to use it without any fear. What? I know you. What? You're out of food already? All right, I'll feed you in a minute. The cat is like weaving in and out of my feet and won't leave me alone. So what does that mean? The kitty wants food. I have the volume up. Bet those are the same shirt and same pants every day. Good morning, Stephen. Welcome in. All right, I've got to go feed the cat before she tears me a new one. Oh, that's the monkey. Never mind. I got to feed both of them in a minute. I got to feed both my babies in a minute. While we're waiting, I need to address something. Yesterday, I got a little bit pissy about a thumbnail issue where I had created a thumbnail. I had somebody that was making thumbnails and I thought they looked great. And I love the style. And I used that technique in a college assignment for the artwork. I figured it out with minor help. From the person who I contact who created their thumbnails the way they did. I love their style, but they're not the only ones who do it. And I kind of went off yesterday. First of all, I'm not going to apologize, but I am going to say I too am human and get tired of being under attack. For those of you who don't know, YouTube content creators are very thick-skinned people, or most part, because we get so many criticism, so much, let me rephrase that, criticism behind scenes and online, that sometimes we just get fed up and we're just like, I gotta go there. And that was yesterday. But understand this, for all those who are people are new to the content creating world, there are some rules that govern copyright. What I did was not a copyright. Okay, I just wanted to clarify. Somebody was really coming down on me about that, and I just wanted to clarify it. It was not a copyright. Okay? In court. So I didn't get copyright struck. That's what they were worried about. No copyright strike from me. No. Why do we have... Okay, I guess they're going over... I don't know why everything's so low today. They are going over paperwork he's signing. I guess he's signing off on the jury instructions, is my surmise. Y'all, coffee is so good on a morning like this. Angela, yeah, 4 questions. Well, do you know what?
Everybody present?
In this, they're not fighting whether he did it or not. They're not fighting that at all. They're just trying to get him down to manslaughter, which will give him an hope in the future of some freedom. They're going for manslaughter. If he gets anything greater than that, it's life in prison, whether it's with or without the possibility of parole. So we're watching. Oh, come on! I thought you were playing.
This is Peter from IT. He's going to explain to the jurors the jury card, and then Carl, once he's done, can we have someone take Peter into the jury room to drop the card off, and then take him back out and lock the door afterwards? Okay, so we'll do that while
They're doing some housekeeping. While they're doing that, let me give this information to you. I'm going to give y'all some legal, well, not legal information. Give you some information. I should have done this sooner. I didn't think about it. My apologies. Okay, now that I got it up, we're going to let this roll while we go.
Carl, while somebody's taking Peter into the jury room, I'm going to go ahead and start the jury instructions with the jurors. Okay. All right. Let's bring the jurors in.
Okay, the stakes in this trial are monumental. On one side, prosecutors are demanding life or not life for 2 counts of first-degree red room. On the other side, the defense pleads for manslaughter, arguing rage and trauma, which is a 40-year sentence. The jury must decide, was it premeditated or a crime of passion? I hate to say it. I believe it is a crime of passion, but it also believed that the prosecution did get it in there and got it in well, that he thought about doing this prior to doing it. Premeditated is not always days earlier. It's moments or seconds earlier. The charges against Dima Tower are 2 counts of first-degree red room, which is premeditated or intentional killing. Possible sentence, life in prison without parole, or the death penalty, or DP. I won't say that word again. Under the Florida law, fleeing from police after a red room tower led officers on a chase down I-75 before abandoning his car and fleeing into the woods. The possible sentence typically is a felony charge with additional prison time if convicted. Now, the lesser charges proposed by the defense is manslaughter, plea deal attempted, killing without premeditation, often in the heart or the heat of passion or rage. Proposes a 40-year sentence in prison. The status of the prisoner rejected. Prosecutors was that they rejected this offer, arguing the rage does not excuse red rum. Second-degree red room definition in general is the intention to kill without premeditation. Possible sentence for that is up to life in prison without the DP option. Tower was initially, charged with second-degree red room before being indicted on the first-degree red room. That is where we stand on the charges, so everybody knows. Disagree. Well, but he could have gone over some stuff that would have really helped him, in my humble opinion. Putting him on the stand at the state really came down to him. He got angry and upset. You could tell. Actually, that could work for him because I saw a lot of that. That really showed his mental state and the way he behaved. The lawyer could ask more questions and make him look more sympathetic. I agree. Okay, in my humble opinion to all of this, I think it was a double-edged sword. The lawyer did not want him on the stand, so the lawyer is going to ask him just enough questions to get what he thinks he can get and get him off. Unfortunately, he himself kind of did himself in, I think, by his behavior, if you're looking at it that way. Now, on the other side, if you were on the possible manslaughter side and trauma side, and is he really that traumatized and by everything that's happened to him? I think his behavior in court is very telling. I think his behavior yesterday was one of I would really be on the side of manslaughter up until a point. The cat's going crazy. Up until a point. Up until the point to where the defense, the prosecution asked him, "Did you?" "Yes, I thought about killing him once before. The second time I did it." That right there shows premeditation. However, I also believe premeditation with mental illness is a whole nother ballgame. No ideas what the psych report said. That was closed. It has not been a part of court record, so we have no idea. But I tell you, his behavior on the stand shows psych issues. And his disdain for Americans. He's got a very big disdain for Americans. He does not like us very well. That's very obvious. He does not think well of the educational system. He does not think well of anything here. He wants to go back to Ukraine. It ain't happening. I say ship him back.
All right, everybody may be seated. Welcome back, members of the jury. This is Peter. He works in the building here with our IT department. He's going to explain what we affectionately call the jury card. Peter?
This is the jury card. We put it in the jury deliberation room for you. Should you need to review any of the evidence you've seen before. It's set up so that it does not have any network connectivity, but it does have applications which you can use to play video evidence on it. So CD player mounted in here for you to access, and DVD player up here should you need it. When you see it in there, it'll boot up the screen showing the seal of the 12th circuit here.
This is cool. We have never seen this before and love the technology.
Rewind video and that sort of thing. If you run into any technical issues with it, Judge Krug will let you know how to reach out to us, and we'll be down to assist you.
Where's the mouse? There it is. Okay, and the keyboard?
Right here.
Right there. Okay, I couldn't see. Okay. All right, Deputy, if you can please take Peter, and we'll have that plugged in the jury room. Okay?
Turn it on.
Way cool.
Can you just unplug it right away?
That's funny. Judge Krug, you have a good sense of humor.
Folks, what's going to be next for us is I'm going to read to you the jury instructions.
Look.
That was that white packet you have in front of me.
Doesn't he look ex-military?
In front of you.
Angela, where's June?
So you can go ahead and turn to that. As soon as we get Peter out, we'll start with those. Give me 1 minute. All right. Members of the jury, I thank you for your attention during this trial. Please pay attention to the instructions.
Before we get in, June, can you please go to private DM and Discord. Thank you.
Instructions I'm about to give you. Statement of charges.
Angela, sorry.
Dima Tower, the defendant in this case, has been accused of the crimes of count 1, murder in the first degree, victim Jennifer Tower. Count 2, murder in the first degree, victim Robbie Tower. Count 3, fleeing to elude a law enforcement officer, lights and sirens activated. In this case, Dima Tower is accused of 2 counts of murder in the first degree. Murder in the first degree includes the lesser crimes of murder in the second degree and manslaughter, both of which are unlawful. A killing that is excusable or was committed by the use of justifiable deadly force is lawful. If you find Jennifer Tower was killed by Dima Tower, you will then consider the circumstances surrounding the killing in deciding if the killing was murder in the first degree, or was murder in the second degree, or was manslaughter, or whether the killing was excusable or resulted from justifiable use of deadly force. If you find Robbie Tower was killed by Dima Tower, you will then consider the circumstances surrounding the killing in deciding if the killing was murder in the first degree, or was murder in the second degree, or was manslaughter, or whether the killing was excusable or resulted from justifiable use of deadly force. Justifiable homicide. The killing of a human being is justifiable homicide and lawful if necessarily done while resisting an attempt to murder or commit a felony upon the defendant, or to commit a felony in any dwelling house in which the defendant was at the time of the killing. Excusable homicide. The killing of a human being is excusable and therefore lawful under any one of the following 3 circumstances. 1, when the killing is committed by accident and misfortune in doing any lawful act by lawful means with usual ordinary caution and without any unlawful intent. Or 2, when the killing occurs by accident or misfortune in the heat of passion upon any sudden and sufficient provocation. Or 3, when the killing is committed by accident and misfortune resulting from a sudden combat, if a dangerous weapon is not used and the killing is not done in a cruel or unusual manner. Dangerous weapon is any weapon that, taking into account the manner in which it is used, is likely to produce death or great bodily harm. I now instruct you on the circumstances that must be proved before Dima Tower may be found guilty of murder in the first degree of victims Jennifer Tower and Robbie Tower, or any lesser included crime. Count 1, murder in the first degree. To prove the crime of first degree premeditated murder, the state must prove the following 3 elements beyond a reasonable doubt. 1, Jennifer Tower is dead. And 2, the death was caused by the criminal act of Dima Tower. And 3, there was a premeditated killing of Jennifer Tower. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. Killing with premeditation is killing after consciously deciding to do so. The decision must be present in the mind at the time of the killing. The law does not fix the exact period of time that must pass between the formation of the premeditated intent to kill and the killing. The period of time must be long enough to allow reflection by the defendant. The premeditated intent to kill must be formed before the killing. The question of premeditation is a question of fact to be determined by you from the evidence. It will be sufficient proof of premeditation if the circumstances of the killing and the conduct of the accused convince you beyond a reasonable doubt of the existence of premeditation at the time of the killing. Count 2, murder in the first degree. To prove the crime of first degree premeditated murder, the state must prove the following 3 elements beyond a reasonable doubt. 1, Robbie Tower is dead. And 2, the death was caused by the criminal act of Dima Tower. And 3, there was a premeditated killing of Robbie Tower. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. Killing with premeditation is killing after consciously deciding to do so. The decision must be present in the mind at the time of the killing. The law does not fix the exact period of time that must pass between the formation of the premeditated intent to kill and the killing. The period of time must be long enough to allow reflection by the defendant. The premeditated intent to kill must be formed before the killing. The question of premeditation is a question of fact to be determined by you from the evidence. It will be sufficient proof of premeditation if the circumstances of the killing and the conduct of the accused convince you beyond a reasonable doubt of the existence of premeditation at the time of the killing. Count 3, fleeing to elude a law enforcement with siren and lights activated. To prove the crime of fleeing to elude a law enforcement officer, the state must prove the following 3 elements beyond a reasonable doubt. 1, Dima Tower was operating a vehicle upon a street or highway in Florida. And 2, Dima Tower, knowing he had been directed to stop by a duly authorized law enforcement officer, willfully fled in a vehicle in an attempt to elude a law enforcement officer. And 3, the law enforcement officer was in an authorized law enforcement patrol vehicle with agency insignia and other jurisdictional markings prominently displayed on the vehicle and with siren and lights activated. Street or highway means the entire width between boundary lines of every way or place of whatever nature, when any part thereof is open to the public for purposes of vehicular traffic. Vehicle means every device in, upon, or by which any person or property is or may be transported or drawn upon a highway, except personal delivery devices, mobile carriers, and devices used exclusively upon stationary rails or tracks. Willfully means intentionally, knowingly, and purposely. In considering the evidence, you should consider the possibility that although the evidence may not convince you that the defendant committed the main crime of which he is accused, there may be evidence that he committed other acts that would constitute lesser included crimes. Therefore, if you decide that the main accusation has not been proved beyond a reasonable doubt, you will next need to decide if the defendant is guilty of any lesser included crime. The lesser crimes indicated in the definition of murder in the first degree are murder in the second degree, manslaughter. To prove the crime of second degree murder as a lesser crime of first degree murder, the state must prove the following 3 elements beyond a reasonable doubt. 1, Jennifer Tower is dead. And 2, the death was caused by the criminal act of Dima Tower. And 3, there was an unlawful killing of Jennifer Tower by an act imminently dangerous to another and demonstrating a depraved mind without regard for human life. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. An act is imminently dangerous to another and demonstrating a depraved mind if it is an act or series of acts that, 1, a person of ordinary judgment would know is reasonably certain to kill or do serious bodily harm to another, and 2, is done from ill will, hatred, spite, or an evil intent, and 3, is of such a nature that the act itself indicates an indifference to human life. In order to convict of second-degree murder, it is not necessary for the state to prove the defendant had an intent to cause death. To prove the crime of manslaughter as a lesser crime of first-degree murder, the state must prove the following 2 elements beyond a reasonable doubt. 1, Jennifer Tower is dead. And 2, Dima Tower intentionally committed an act or acts that caused the death of Jennifer Tower. Every person has a duty to act reasonably towards others. If there is a violation of that duty without any conscious intention to harm, that violation is negligence. The defendant cannot be guilty of manslaughter by committing a merely negligent act, or if the killing was either justifiable or excusable homicide, as I have previously instructed you. In order to convict of manslaughter by act, it is not necessary for the state to prove that the defendant had an intent to cause death, only an intent to commit an act that was not merely negligent, justified, or excusable, and which caused death. You'll see I'm now moving on to those same lesser includeds for count 2. To prove the crime of second-degree murder as a lesser crime of first-degree murder, the state must prove the following 3 elements beyond a reasonable doubt. 1, Robbie Tower is dead. And 2, the death was caused by the criminal act of Dima Tower. And 3, there was an unlawful killing of Robbie Tower by an act imminently dangerous to another and demonstrating a depraved mind without regard for human life. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. An act is imminently dangerous to another and demonstrating a depraved mind if it is an act or series of acts that 1, a person of ordinary judgment would know is reasonably certain to kill or do serious bodily injury to another, and 2, is done from ill will, hatred, spite, or an evil intent, and 3, is of such a nature that the act itself indicates an indifference to human life. In order to convict of second-degree murder, it is not necessary for the state to prove the defendant had an intent to cause death. To prove the crime of manslaughter, a lesser crime of first-degree murder, the state must prove the following 2 elements beyond a reasonable doubt. 1, Robbie Tower is dead. And 2, Dima Tower intentionally committed an act or acts that caused the death of Robbie Tower. Every person has a duty to act reasonably towards others. If there is a violation of that duty without any conscious intention to harm, that violation is negligence. The defendant cannot be guilty of manslaughter by committing a mere negligent act, or if the killing was either justifiable or excusable homicide, as I have previously instructed you. In order to convict of manslaughter by act, it is not necessary for the state to prove that the defendant had an intent to cause death, only an intent to commit an act that was not merely negligent, justified, or excusable, and which caused the death. The defendant has entered a plea of not guilty. This means you must presume or believe the defendant is innocent. The presumption stays with the defendant as to each material allegation in the information through each stage of the trial, unless it has been overcome by the evidence to the exclusion of and beyond a reasonable doubt. To overcome the defendant's presumption of innocence, the state has the burden of proving the crimes with which the defendant is charged were committed, and that the defendant is the person who committed the crimes. The defendant is not required to present evidence or prove anything. Whenever the words reasonable doubt are used, you must consider the following. Proof beyond a reasonable doubt does not mean proof beyond all doubt. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. On the other hand, if, after carefully considering, comparing, and weighing all the evidence, there is not an abiding conviction of guilt, or if, having a conviction, it is one which is not stable, but one which wavers and vacillates, then the charge is not proved beyond every reasonable doubt, and you must find the defendant not guilty because the doubt is reasonable. It is to the evidence introduced in this trial and to it alone that you are to look for that proof. A reasonable doubt as to the guilt of the defendant may arise from the evidence, conflict in the evidence, or the lack of evidence. If you have a reasonable doubt, you should find the defendant not guilty. If you have no reasonable doubt, you should find the defendant guilty. It is up to you to decide what evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in considering your verdict. You may find some of the evidence not reliable or less reliable than other evidence. You should consider how the witness acted, as well as what they said. Some things you should consider are: 1, did the witness seem to have an opportunity to see and know the things about which the witness testified? 2, did the witness seem to have an accurate memory? 3, Was the witness honest and straightforward in answering the attorney's questions? 4, did the witness have some interest in how the case should be decided? 5, does the witness's testimony agree with the other testimony and other evidence in the case? Whether the state has met its burden of proof does not depend upon the number of witnesses it has called or upon the number of exhibits it has offered, but instead upon the nature and quality of the evidence presented. The fact that a witness is employed in law enforcement does not mean that his or her testimony deserves more or less consideration than that of any other witness. Expert witnesses are like other witnesses with one exception. The law permits an expert witness to give his or her opinion. However, an expert's opinion is reliable only when given on a subject about which you believe him or her to be an expert. Like other witnesses, you may believe or disbelieve all or any part of an expert's testimony. The defendant in this case has become a witness. You should apply the same rules to consideration of his testimony that you would apply to the testimony of the other witnesses. It is entirely proper for a lawyer to talk to a witness about what testimony the witness would give if called to the courtroom. The witness should not be discredited by talking to a lawyer about his or her testimony. You may rely upon your own conclusion about the credibility of any witness. A juror may believe or disbelieve all or any part of the evidence or testimony of any witness. Statements claimed to have been made by the defendant outside of court have been placed before you. Such statements should always be considered with caution and be weighed with great care to make certain they were freely and voluntarily made. If you conclude the defendant made the statement, you must also determine from the evidence whether the defendant's statement was freely and voluntarily made. In making this determination, you should consider the circumstances, including but not limited to 1, whether when the defendant made the statements, he had been threatened in order to get him to make statements, and 2, whether anyone had promised him anything in order to get him to make the statements. If you conclude the defendant made the out-of-court statements, but it was not freely and voluntarily made, you should disregard it. These are some general rules that apply to your discussion. You must follow these rules in order to return a lawful verdict. 1, you must follow the law as it is set out in these instructions. If you fail to follow the law, your verdict will be a miscarriage of justice. There is no reason for failing to follow the law in this case. All of us are depending upon you to make a wise and legal decision in this matter. 2, this case must be decided only upon the evidence that you have heard from the testimony of the witnesses and have seen in the form of the exhibits and evidence and these instructions. 3, this case must not be decided for or against anyone because you feel sorry for anyone or are angry at anyone. 4, remember the lawyers are not on trial. Your feelings about them should not influence your decision in this case. 5, your duty is to determine if the defendant has been proven guilty or not in accord with the law. It is the judge's job to determine a proper sentence if the defendant is found guilty. 6, whatever verdict you render must be unanimous. That is, each juror must agree to the same verdict. 7, your verdict should not be influenced by feelings of prejudice, bias, or sympathy. Your verdict must be based on the evidence and on the law contained in these instructions. Deciding a verdict is exclusively your job. I cannot participate in that decision in any way. Please disregard anything I may have said or done that made you think I preferred one verdict over another. A separate crime is charged in each count of the charging document, and although they have been tried together, each crime and the evidence applicable to it must be considered separately and a separate verdict returned as to each. A finding of guilty or not guilty as to one crime must not affect your verdict as to the other crimes charged. You may find the defendant guilty as charged in the charging document or guilty of such lesser included crimes as the evidence may justify or not guilty. If you return a verdict of guilty, it should be for the highest offense which has been proven beyond a reasonable doubt. If you find that no offense has been proven beyond a reasonable doubt, then of course your verdict must be not guilty. Only one verdict may be returned as to each of the crimes charged. The verdict must be unanimous. That is, all of you must agree to the same verdict. The verdict must be in writing, and for your convenience, the necessary form of verdict has been prepared for you. It reads as follows. You don't have the verdict form. We only have one. I have it here, and I know we're a bit distant, so you can't see it, but it's when you get it, you'll see it's titled State of Florida v. Dima Tower, and as a case number, it's titled Verdict. It gives you instructions to check one as to count one. Check only one, it says, as to count 1, 2, and 3, and a place for it to be dated and signed by the foreperson. Emily, I'll give that to you. This last jury instruction in your packet, you can put that aside. I'm going to read that to you after the closing arguments. Members of the jury, that the attorneys will now present their final arguments to you. Please remember that what the attorneys say is not the evidence nor your instructions on the law. However, do listen closely to their arguments as they are intended to aid you in understanding the case. Each side will have an equal time, but the state is entitled to divide their time between an opening argument and a rebuttal argument after the defense has given its closing argument. State, are you ready to proceed?
Yes.
You may do so when you're ready.
Thank you, Your Honor.
Good morning, ladies and gentlemen. Back on Monday, which probably seems like an eternity to you by now, the judge talked about the two things that the state has to do in its case. It has to prove beyond a reasonable doubt that a crime or crimes were committed in the murders of Robbie and Jennifer Tower and the fleeing to elude. And that the defendant who sits here in the courtroom before you, Dima Tower, is the person who committed those crimes. I think that those things have been proven to you fully during this trial. The only thing that we should talk about today, and that's important for you to focus on, is the defendant's intention. Because in opening statements, defense counsel told you that he was going to argue for a lesser included crime, a crime of manslaughter. So let's think about the instructions that you have in front of you and what they say and why this is not manslaughter and it's not second-degree murder, and it completely and fully meets all the elements of first-degree premeditated murder. Your Honor, I'm having a problem, and I don't know why this isn't working correctly.
All right, let's take a short break. We'll bring IT to try to solve that, okay? Please leave your notepads face down, writing implements on top. Don't discuss anything related to your jury service, okay? Can you call IT to come down? video, Carl, that we're ready to bring the jurors back in when they are? All right, everybody may be seated.
Thank you, ladies and gentlemen. You've probably worn out that carpet by now, going back and forth. But let's continue where I left off. So what we have to focus on are the instructions for law and the evidence in this case. And you have those instructions in front of you, but I have the elements of first-degree murder up on the screen. So to prove the crime of first-degree premeditated murder, the charge that the state has laid against the defendant, actually 2 counts, but I incorporated both Jennifer and Robbie Tower into this instruction. To prove the crime of first-degree murder, the state has to prove the following 3 elements beyond a reasonable doubt. Jennifer and Robbie Tower are dead. There's no question about that. It's uncontested. Their deaths were caused by the criminal acts of Dima Tower. Again, uncontested. Not only do we have all the physical evidence in this case, the knives, the fact that the defendant was covered in blood, the fact that he fled, but we also have his own words. He told the detectives who interviewed him that he killed his parents. So we know that their deaths were caused by Dima Tower, and obviously they were criminal acts because he stabbed them to death. That's a crime. Finally, there was a premeditated killing of Jennifer Tower and Robbie Tower. And how do we know that? We know that because the defendant told us so himself over and over and over. Yesterday afternoon, on the stand, he told you that himself. Repeatedly to the detectives, and then again, right here in the courtroom where you're sitting today. So let's talk a little bit about premeditation and the definition. Now, back on Monday, I was asking you a lot of questions about what factors should you think about when we're talking about premeditation, and you probably thought, what is this woman talking about? Because you didn't have the facts. You didn't know what went on in this particular case. And I was asking you questions about what would a person do before committing a premeditated act? If you didn't know what was going on in their mind, but you had to look at their actions and determine what was premeditation. We talked about what would a person do while the crime was being committed that would signal premeditation. And we talked about what would a person do after the crime was committed to signal premeditation. And let's think about what we learned in the last 3 days. What did the defendant do before he committed this crime? He chose his weapon from the knife block in the kitchen. and he took it into the bedroom. He armed himself before the encounter with his parents. All of that leaves plenty of time for reflection, for reflective thought. And we also talked about if there are prior difficulties between the parties, does that lend itself to thinking about premeditation? If someone is already angry, and as the defendant said, boiling with rage, does that lend itself to premeditation? Is that one of the factors you should consider? And I would suggest that it is. And then what did the defendant do at the time he was committing the crime, when he was stabbing his parents by a conservative estimate 140 times? We talked about, do the nature of the wounds that are being inflicted, do they show that the defendant had a conscious intent to kill? Well, we know the kind of wounds that he inflicted on the tracheas of both parents and on the multiple stab wounds, especially to the face, the head, the back of the neck, especially the throat, the carotid arteries, and the jugular veins, the most vulnerable, tender part of any human being. We also talked about, is it important to consider the number of wounds inflicted? And we know that there were, again, over 140 wounds, 79 to Robbie and, 79 to Jennifer and more than 68 to Robbie. What else at the time that the crime is being committed signals that this was premeditated? What about the fact that when he lost the first knife, he went back into the kitchen and got himself another knife so that he could, as he said, finish what he started? Because he started it deliberately and consciously. He wanted to finish that job. And so he armed himself with another weapon. What else did he do during the crime that shows premeditation? After he killed his father, he walked outdoors, and yesterday he told us that he had the knife in his hand when he went outside. And he led his mother back into the death scene and sat her on the couch, and in his own words, delivered a manifesto. He said it was a monologue. And all the time she's sitting there and he is planning to kill her. There is no other way to think about it. What else did we talk about during jury selection? We talked about what might signal premeditation after the crime is committed. We know that the defendant washed the second knife and placed it back in the knife block because it was collected as evidence, and we can actually see the little bit of blood in a close-up photo. It was also sent to the Florida Department of Law Enforcement, and Ms. Webster told you that there was presumptive blood on both weapons. After he took the knife and placed it back in the knife block after he gave it a cursory wash, he fled from the police. You saw 30 long minutes. It was probably boring, but I thought it was important to impress upon you just how long it took for the police to apprehend the defendant. How long he consciously fled from the police and showed a consciousness of guilt because he knew what he did was wrong. And we know that finally, when he was apprehended, he gave a full admission to consciously deciding to kill. That's premeditation all day long. So let's look at the instructions. Killing with premeditation is killing after consciously deciding to do so. The decision must be present in the mind at the time of the killing. The law doesn't fix the exact period of time that must pass between forming the premeditated intent to kill and the actual killing. But the period of time has to be long enough to allow reflection, long enough for the mind to come up with the idea, the plan, the decision, whatever you want to call it. Long enough to allow reflection by the defendant. And it has to be formed before the killing actually takes place. The question of premeditation is a question for you. It's a question that you have to answer based upon what you heard these last 3 days in the courtroom and the evidence that you've seen. And only you can decide if this was a premeditated act.
Got it. Thank you, love.
It's sufficient proof of premeditation if the circumstances of the killing and the conduct of the accused during the killing convince you beyond a reasonable doubt of the existence of premeditation at the time of the killing. Let's talk about why this is not manslaughter and why this is certainly not second-degree murder. Let's start with second-degree murder because that's the first of the lesser included. That comes right after first-degree murder and is then followed by manslaughter. And if you want to follow along with me with the jury instructions, you have them before you. If not, you can just listen to what I have to say. Second-degree murder has to be proven by the state beyond a reasonable doubt, and it has to prove the three following elements. Jennifer and Robbie Tower are dead. Yes, we know that. The death was caused by the criminal act of Dima Tower, their adopted child. There was an unlawful killing of Jennifer and Robbie Tower by an act imminently dangerous to another and demonstrating a depraved mind without regard for human life. Is that what happened? Of course it is. It goes on to say that an act includes a series of related actions arising from and performed pursuant to a single design or purpose. An act is imminently dangerous, it goes on to define, to another and demonstrating a depraved mind if it is an act or series of acts that a person of ordinary judgment would know is reasonably certain to kill or do serious bodily injury to another. 2, the act is done from ill will, hatred, spite, or evil intent. And 3, the act or actions are of such a nature that they indicate an indifference to human life. All of those are true. That's exactly what Dima Tower did. But in order to convict of second-degree murder, it is not necessary for the state to prove the defendant had an intent to cause death. That is what's missing from second-degree murder. Dima Tower had every intent to cause the death of both Robbie and Jennifer Tower. He told you so himself. Why isn't this manslaughter? To prove the crime of manslaughter, the jury instructions tell you, the state has to prove the following 2 elements beyond a reasonable doubt. First, Jennifer and Robbie Tower are dead. And second, Dima Tower intentionally committed an act or acts that caused the death of Jennifer Tower and Robbie Tower. What's missing? Premeditation. The jury instruction goes on to say that in order to convict of manslaughter by act, it is not necessary for the state to prove that the defendant had an intent to cause death. Only an intent to commit an act that was not merely negligent, justified, excusable, or which caused death. But we know from the defendant's own mouth that he had every intention to cause death. He told us so over and over and over again. So the lesser includeds are statutorily mandated to accompany the jury instructions on first-degree murder. But they do not rise. They don't even come close to describing or meeting the elements of what Dima Tower did to his parents on August 31st, 2023, when he sat in that car and thought about killing them, walked into his house, went into his bedroom, came out, grabbed the knife out of the kitchen, and walked into the bedroom and started stabbing his father. Because this is a clear-cut case of first-degree murder. So he talked to detectives on September 1st of 2023, and Detective St. Jean and Detective Chippendale asked him a number of questions. What did you think about last night? I don't like the situation. I don't like the people I'm with. So I'm just going to kill them. That's what he thought about before he killed his parents. That was his plan. You don't need a diagram. You don't need a journal with your thoughts written down. You don't need a flow chart. You don't need a bullet point list to premeditate the killing of your parents. All it takes is long enough time to reflect, to engage in reflective thought. And that's exactly what he did. I don't like the situation. I don't like the people I'm with, so I'm just going to kill him. Did you guys talk at all? And here, I think Detective Chippendale is referring to what happened when the defendant brought his mom back in from outside when she was trying to alert the neighbor and try to get some help. So the detectives asked, did you guys talk at all? Yeah, the defendant responded. I tried to talk to her. How did that conversation go? It was a monologue. So did you stab her already at that point? After I finished what I had to say. He's giving a monologue, talking to his mother in the house. Plenty of time for reflective thought. Again, during that interview that you watched, and I urge you, ladies and gentlemen, to watch it again. You'll have an opportunity to take the evidence, most of the evidence back with you, and you can listen to that videotaped and audio tape recording. It's available for you. So last night, you're sitting in your car, and you just came up with this, that you're going to do something now. Defendant said, no, it came before that. Detective says, after work? No, it was before that. I had those thoughts before yesterday. What, days, months? No, like recently. Reflective thought. Later on in the conversation, the detectives ask, was last night the first time you actually thought about killing your parents? No. And yesterday, the last question that I asked, when you were sitting in your car on August 31st, did you decide to kill your parents before you walked into the house? Yes.
911, what is the location of the emergency?
Listen, it's not such an emergency anymore right now, but we live at 1200 Malakote Road in Northport. And I was trying to reach Northport Police, and they keep sending me up to this.
Okay, so you got a police issue going on?
No, I was upstairs in bed, and my daughter was sleeping downstairs, and someone screamed, and banged on our door and rang the doorbell, screaming, I need help, I need help. Took me a second to register what was going on, and we were trying to find, our friend upstairs before we opened the door, and the person's gone.
Okay, well, let's connect you to Northport so they can check the area. Let me connect you, please.
Okay, thank you.
911, what is the
And this is what law enforcement found when they got to Jonna Walton's house. A blood trail leading up to her home, and at her door, more blood dripping while she rang the doorbell and screamed for help. And as she was out there, the defendant wanted to finish what he started, so he led her back in the house. And then, after he finished what he started, he came outside, covered, according to Officer Regakis, with blood. And he just nonchalantly got in his car and drove away, covered with his parents' blood. He led the police on a chase for about a half an hour, even at one point endangering other people in the community by going into the northbound lane. And finally, when Sarasota County disabled his car, stop sticks, he ran into the woods. And we had Officer Regakis get on the stand and show you, trace out for you the flight path of the defendant from way down in the southeastern corner of Northport city environs, all the way to I-75, south on I-75, and then he backtracked and drove all the way up to almost the very end of what this map shows in the upper left-hand corner, where he abandoned his car and fled into the woods. This is what the crime scene and the detectives found at 1240 Malakote Road. This is the carnage that they found inside the house. Blood everywhere, on the door, in the foyer, on the furniture, on the walls, on Dima Tower's parents.
Howdy, Joe Schmo.
Where this crime started, in the bedroom where Mr. Tower was sound asleep next to his wife when the defendant attacked them while they were sleeping in their bed. And you can see the signs of struggle. Looks like Robbie Tower put up quite a fight as best as he could. You can see that there was a brief altercation over on that north wall, and again on the wall leading into the living room. Blood everywhere, but the defendant was determined to finish what he started. Even when he lost the first knife, he was determined to finish what he started. So he goes into the kitchen and grabs another knife. and then washes up afterwards. And this is a work product of Dima Tower. This is what he did to his father and to his mother because he didn't like them as people. You also heard testimony that the defendant was finally seen early the following morning after he had been at large for about 9 hours. He was captured on video at the Shell station around about 7:30 in the morning. He actually was blasé enough to walk into the Shell station and buy a bottle of tea. And finally, he was arrested shortly thereafter, around about 8 o'clock, when the Venice Police Department apprehended him, still at the Shell station. And this is what the defendant did to his mother. And I have not put up all the autopsy photos. I think you've seen enough autopsy photos and bloodshed, but this is what he did to his mother after he led her back in the house. Stabbed her multiple times in the face, the throat, and the back. And his father, mutilated to the point where Dr. Vega was able to count 6 separate and distinct perforations, incisions, whatever you want to call them, into Robbie Tower's trachea, his larynx. And you heard the testimony of Dr. Vega yesterday, who told you that the cause of death for Jennifer Tower was perforations of multiple small and large blood vessels, including her carotid artery and jugular vein. Same with Robbie Tower, perforations of multiple small and large vessels, including the carotid and subclavian arteries, due to multiple stab wounds. And Dr. Vega told you about the function of the carotid arteries and the jugular veins, how those are the major vessels that take the blood to the head and back down to the body. And that's where the defendant attacked his parents, in the most vulnerable, fragile places in the human body. Ladies and gentlemen, I'm going to ask you to think about the jury instructions and what you heard on Monday about sympathy. You saw the defendant sobbing here in the courtroom. We had to actually take a break. I think it was on Wednesday during the defense's opening statement. And then again yesterday when the defendant took the stand, he put on quite a display of emotion.
Overruled. Let's move on from this, okay?
He put on quite a display of emotion. Hold him accountable for what he did. You may not have sympathy enter into your deliberations. Your job is to look at the evidence and see if the evidence comports with the law of first-degree murder. You may not have any sympathy for Robbie or Jennifer Tower or the defendant. And that's hard to ask human beings. And you may even have sympathy for all three of those people, but they cannot influence your decision. That cannot influence your decision. You have to compartmentalize that sympathy if you have any. Because the law says that you must judge the defendant on the evidence and the law. Hold him accountable for what he did, ladies and gentlemen. Thank you.
She knew she was getting close to danger. You can't do that. He is an
Like
impossible.
we talked about at the beginning of this case, Mr. Tower's words still hold truth. It has a lot to do with everything that I've been through and everything that I've seen. And you've heard a lot of evidence in this case, and frankly, a lot of it was not disputed. The facts and circumstances of the tragic events of August the 31st of 2023 are not materially in dispute. Robbie Tower is deceased. Jennifer Tower is deceased. Those things occurred because of acts by Dima Tower. That is not in dispute. What is in dispute is whether or not Dima Tower had the rational, conscious intent to commit the homicides prior to them occurring. That is what is in dispute in this case, and that is what we have been asking you to focus on and not get sidetracked into different areas. The judge has instructed you that you have to presume Mr. Tower to be innocent before you start. We kind of dialed that back a little bit and said, look, before we even start this trial, I want to make sure that we're clear about what we're asking of you. And what we're asking of you is to make a decision about one simple thing. And it may not seem that simple, and it may seem very complicated to get inside the head of somebody else. And it is. It's complicated. The state has the burden of proving these crimes beyond and to the exclusion of every reasonable doubt. I know the state will say that most of what we've been talking about is trying to invoke sympathy for Mr. Tower. That is not the case. It is important, if you're making a decision about somebody's state of mind, that you are exposed to them so that you can make an informed decision. There's a lot of talk in the jury instructions about people of ordinary judgment making decisions. And what the judge has instructed you is that it's up to you to decide what evidence is reliable. You should use your common sense in deciding what is the best evidence and which evidence should be relied on in considering your verdict. We talked during jury selection about the fact that you don't leave your personal life experiences at the door. You bring those in because they form your common sense. And you can make the determination as to whether or not it's significant that Mr. Tower couldn't look me in the eye, couldn't look the state attorney in the eye, couldn't look the detectives in the eye at any point in time. That is something that is common for certain people. And when we're talking about individualized consciousness of guilt, every individual reflects differently. Every individual thinks differently. So if we're talking about the fixed time for reflective thought, it's important to consider all of the factors as to whether or not Mr. Tower had sufficient time for him to make reflective thought. Given his history, whether or not the killing was done after consciously deciding to do it. I would submit that Mr. Tower doesn't have the ability.
I'm gonna object to this, and may we approach?
No, I'm going to sustain the objection.
Okay.
Sustain the objection.
Thank
I'll disregard the last statement by defense counsel.
The question of premeditation is a question of fact to be determined by you from the evidence. And the judge instructs you, again, use your common sense. Think about what evidence is reliable and what evidence isn't reliable. As Mr. Tower indicated, when there was discussions with law enforcement, he was concerned that there were misstatements, misunderstandings, which would be something you would understand from somebody who was in foster care in a foreign country, who didn't know the language before he got here, who learned the language himself by small talk, who was obviously awkward and uncomfortable. You can make a determination as far as all of those things, as to what weight you put on each piece of evidence and what weight you assign. Because like we talked about from the beginning, each of you individually has a verdict. And collectively, as a jury, you make a decision. But it is important for each and every one of you to have your voices heard. It's important that you take time to deliberate and make a determination as far as what culpability Mr. Tower has. I would suggest to you that the evidence presented leads to a manslaughter conviction. And we would ask that you come back with that verdict. Thank you.
State rebuttal when you're ready.
Defense counsel argued that defendant told you yesterday, and he did, that this has a lot to do with everything I've been through and everything I've seen. You've heard no evidence, zero evidence of the defendant and what he saw and what he's been through.
You wouldn't let him.
You are not.
Burden shifting?
I'll overrule the objection. I'll just remind everybody, there's no obligation or burden on the defense to do anything. You may continue.
The defense has no burden. But when you hear arguments that defy logic, you can reject the arguments by the defense.
Or the prosecution.
Defendant doesn't have to prove anything in this case. But he did. He proved everything in this case when he took that stand yesterday. And he said, I was sitting in the car
Your Honor.
thinking about it before I went into the house. I thought about killing my parents before I went into the house. So again, does the defense have to prove anything? No. Is it my burden? Yes. And I urge you to hold the state to its burden. But you have heard no evidence, absolutely no evidence about what the defendant has seen and what the defendant has been through. And that is not burden shifting. That is simply a fact. The defendant described this as rage, but not rage that developed suddenly from a sudden event, some altercation with his parents, something that would make an ordinary, reasonable person lose self-control. This wasn't something sudden that happened that made Dima Tower lose his normal self-control and go in there and stab his parents. As I said earlier, his parents were fast asleep in their bed. They posed absolutely no danger to him. They did nothing to upset him or provoke his rage that night. I don't know where his rage was fostered, and neither do you. But he had rage for his parents when he was sitting out in that car, and he acted on that rage. This was not manslaughter. This was not a crime of passion. He sat out in his car and thought about it. And again, you're going to hear instructions about speculation. They're in your jury instructions. On Monday night, you took an oath to well and truly try this case based on the law and based on the facts, not on speculation. In fact, the jury instructions forbid you to speculate about the defendant's past or what he's seen or what he went through when his mother died. That's pure speculation, and you may not do that. Do not let yourself be persuaded because the defendant tried to and was prevented, correctly so, from talking about his past, because that is not why we're here. We're here because the defendant killed his parents. The law doesn't change for people to fit their situations. Whether you're an executive of Coca-Cola or whether you're a kid from a bad neighborhood, whether you graduated from Northport High School or you graduated from Harvard, the law is the same for every single person. And what he went through when he was a kid has nothing to do with this crime that he committed. Don't be persuaded that because the defendant had a horrible childhood and he ended up in an orphanage, that he's somehow justified in doing what he did. Those photographs say everything. There is no justification for that. I'm asking you to think about the facts and think about the law, and only that, because there is no room for sympathy or speculation in your job. I'm asking you to hold the defendant accountable for what he did. I'm asking you to find him guilty of killing Robbie Tower and Jennifer Tower after premeditation. I'm asking you to hold him guilty of first-degree murder on both counts, and also for fleeing to elude law enforcement officer with lights and siren. I thank you for your patience and your attention.
That concludes the closing arguments. Folks, as you might know, I think we talked about this at jury selection. We chose to have two alternates because we were going for the whole week. If someone got sick, we would have them fill in. You folks remember your numbers from day one? Remember you had a paddle in your hand? I'm going to try to see if we can identify our alternates by number. They were number 45, initials SM, is that right? Okay. And juror number 50, JP, where are you? Do you folks have any personal belongings back in the jury room? Yes? While I'm going over this last instruction, why don't you go with Carl, the bailiff, and gather your personal belongings. When you're done, Carl, give me about maybe a minute or two. We'll bring you back in. You can just come over to the side. You've spent a whole week with these folks. You can say bye to them as they're walking out in transition. I'm going to speak to you just for a bit before I send you folks home, okay? The alternates, okay? Everybody can remain seated while the alternates head out with Carl. For the rest of you, you all comprise our jury, so you can turn to that last jury instruction in your packet. I'm going to read that to you. In just a moment, you will be taken to the jury room by the bailiff. The first thing you should do is choose a foreperson who will preside over your deliberations. The foreperson should see to it that your discussions are carried on in an organized way and that everyone has a fair chance to be heard. It is also the foreperson's job to sign and date the verdict form when all of you have agreed on a verdict and to bring the verdict form back to the courtroom when you return. During deliberations, jurors must communicate about the case only with one another and only when all jurors are present in the jury room. If a juror goes to the restroom, the deliberations should stop until that juror returns. You are not to communicate with any person outside the jury about the case. Until you have reached a verdict, you must not talk about this case in person or through the telephone, writing, or electronic communication, such as a blog, Twitter, email, text message, or any other means. Do not contact anyone to assist you during your deliberations. These communications rules apply until I discharge you at the end of the case. If you become aware of any violation of these instructions or any other instruction I have given in the case, you must tell me by giving a note to the bailiff. Many of you may have cell phones, tablets, or laptops, or other electronic devices in the jury room. The rules do not allow you to keep those or bring those into the jury room. The rules do not allow you to bring your phones or any of those types of electronic devices into the jury room. Kindly leave those devices with the bailiff. These devices will be safeguarded by the bailiff while you deliberate. I think what Carl will do is he'll put a cart outside your jury room. If you can just, if you want to make a call to a loved one, let them know you're well. Turn your phone to silent or off. That includes Apple Watches, electronic watches, iPads, any electronics. If you can turn those to off or silent, just put them on the cart outside the jury room, okay? If you need to communicate with me for any reason, send a note through the bailiff. If you have voted, do not disclose the vote in the note. If you have a question, I will talk with the attorneys here in court before I answer, so it may take some time. You may continue your deliberations while you wait for my answer. I will answer any questions if I can in writing or orally here in open court. During the trial, items were received into evidence as exhibits. You may examine whatever exhibits you think will help you in your deliberations. A, some of these exhibits will be sent into the jury room with you when you begin to deliberate. And B, if you wish to see any of these other exhibits, please request that in writing. Both apply in this case. What we decided is we're not going to send any of the knives back to you in the jury room. There was a butcher block, you may recall, with some knives and then 2 other knives. You're entitled to see those if you wish. So that would be a note by a foreperson signed saying we'd like to see the knives, for example. What we'd do in that case, I'd talk about it with the attorneys. We could either have a bailiff just bring them into the jury room, give it, have you have access to those for a few minutes and then collect them, or we can bring you back into the courtroom and have a bailiff walk in front of you with those as well. Okay. But other than the knives, all other evidence will go back with you. Again, you have the jury card back there if you want to view or watch any evidence that's in the form of electronics. In closing, let me remind you that it is important that you follow the law spelled out in these instructions in deciding your verdict. There are no other laws that apply to this case. Even if you do not like the laws that must be applied, you must use them. For 2 centuries, we have lived by the Constitution and the law. No juror has the right to violate rules that we all share. All right, folks, at this time, if you can take your writing implement, your notepads, and your jury instructions, and head on out with Carl, okay? To my alternates, go ahead and just move a little bit so the other jurors can go by. We'll be at recess until we have a question or verdict. Please leave your cell phone with the clerk. Please stay within 15 or so minutes so that we can all get back into the courtroom. Folks in the audience, we're not going to individually, of course, call any of you. If you want to be present, leave your number with the attorneys, and they'll assist you in letting you know when we're back in court. Okay. All right. We'll be adjourned until we have a question or verdict. Folks, thank you. You don't need to tell me if you're upset or happy, but I don't understand why.
I know I'm muted. Oh, I'm getting there, y'all. I'm getting ready to do the corners. I had to change my shirts. What? Why did it turn on? There we go. I had to change shirts. I love that fuzzy thing, but dang it, it's hot. It is hot, hot, hot. Hi, Seeking Justice. Welcome, Seeking Justice in the house. And Dragonfly, welcome, welcome.
Cannot influence your decision. Compartmentalize that sympathy if you have any.
All right, we are going to have to go. We have another trial, but it doesn't start for a few. Let me get to YouTube and let me do the YouTubey thing. I want to thank everybody who have been so kind to me and given me such positive words of congratulations over my graduation, upcoming graduation. Thank you so very much. I appreciate that. It's not easy at my age to do what I've done, or at any age, really. But we're here to talk about the Menendez brothers. I know I'm not in the majority of how people now view that case. All I say is I don't think they should be released. Oh, wow. We're going there, huh? Lack of defense. I am, lack of defense. There definitely is a lack of defense in this case. But in all honesty, I don't think there's a whole lot to defend in this case. Just saying. I don't think there's a whole lot that one can defend. We don't have our other trial does not start until 11 a.m. my time. That's an hour and 15 minutes. So I'm going to find something for us. Not here, Marissa. I don't understand the not guilty when there's not. He's saying he's not guilty to manslaughter. I mean, to first degree redrum or second degree redrum. He's not guilty. He doesn't feel he is guilty for the charges in which they have charged him with. He's not saying he didn't do it, but he believes he's not. He's only guilty for manslaughter. He's guilty of manslaughter, but not the other. In y'all's humble opinion, seeking justice, what's your opinion? Do you believe he should be manslaughter, or do you believe he should be first degree or second degree redrum? What are your opinions? Let me know. I gotta be honest, this girl just wants to crawl in bed. We heard nothing of his life in his countries or anything of his adoption parents. So, yeah, yeah, I definitely believe he's guilty of redrum. Excuse me, but is it manslaughter or is it the other? What is your understanding and belief in this matter? What? Really? That's interesting. That'd be interesting. I don't think we have that appellate issue, or I'd be reading it to you right now. He does have an attitude problem, Miss Dragonfly. Huge attitude problem. Okay, everybody, we're doing a poll. And right now we have only 11 votes, but 11 out of 12 of you is pretty dang good, y'all. Almost 100%. We need one more vote. Maybe that's me. I can't vote. 1 to 3 hours, 4 to 6, or 7+ hours. I'm going to go ahead and put my vote in. I agree with the majority. Definitely agree with the minority. Majority. You know, that's something, let's talk about that, because people think that when you are in a schizophrenic state or something like that, you cannot form logical thoughts and plan. Yeah, you can. As someone who has worked at the state hospital, let me tell you, these little boogers, I mean, they know when they get in a schizophrenic state doesn't mean that you cannot think about doing something, like with what's her name, who took the knife from a resale shop and went to the grocery store and stabbed that child. It's like you're in a schizophrenic state, or you're in a state where your mind is racing and going, and you got to do this and kill, and it's telling you to kill, and in order to do that, you got to have something. So you go, okay, knife, go over there and get a knife. Oh, okay, got knife. Now I need to kill. How am I going to do it? I'm going to stab. They do have some, what I call processing behavior, in order to complete the task. But the reasoning and the clarity as to why and the ability to ignore the voices is the issue. In my humblest opinion. Well, they didn't take up mitigating factors in this sentencing. So let's go over his charges. We went through the charges once. We'll go through them again. Let me get them up. Give me a second. I'm pulling up my notes. Let me see. Thank you, June, so much for posting that poll. No, he's not schizophrenic. I was just using that as an example. I don't believe he's schizophrenic. So we're gonna go over this again because a lot of you were not here at that time. So the stakes in this trial are monumental. On one side, the prosecutors are demanding life or even death for 2 counts of first-degree murder. On the other hand, the defense is pleading for manslaughter. They argue that the rage and the trauma is what caused this young man to do what he did. And that carries a 40-year sentence. But the jury must decide what was premeditated slaughter or crime of passion. So the charges against Dima Tower are 2 counts of first-degree murder, premeditated, intentional killing. Possible sentence, life in prison without the possibility of parole or even the DP under Florida law. Added to that, fleeing from the police after the Red Room. Tower led officers on a chase on I'm sorry, I got to put that up there. Led him on a chase for, Troussell's jury is now deliberating, just say. Abandoning his car and fleeing into the woods. He was later then apprehended and when he was spotted at a gas station. Now, the possible sentences are typically a felony charge with additional prison time if convicted. The lesser charges proposed by the defense is manslaughter, which they did attempt to offer as a plea deal, which was refused. In their definition, the killing is without premeditation, often in the heat of passion or rage. They proposed a sentence of 40 years to the state. The state prosecutors rejected this offer without a wink of an eye, arguing the rage does not excuse Red Room. Second-degree murder, the initial charge, but it was upgraded to first. The definition is intentional killing without premeditation, possible sentence up to life in prison without the possibility or even with the possibility of death. Tower was initially charged with second-degree murder before being indicted on the first. So what are his mitigating factors? The mitigating factors in this particular trial is psychological and emotional background of trauma during childhood. Tower was adopted from the Ukraine orphanage at the tender age of 14. Pause on that. By the time of 14, the trauma and everything he has suffered has already formed his personality, how he thinks, his integrity, his processing. It made him who he is today and will always be. His defense emphasizes that his birth parents neglected him, leaving him with deep emotional scars. Well, that is true, but however, his mother did die when he was at the age of about 6, 7. Then he went and lived with brother and uncle and other family members and orphanages and was in and out of all of them. His lawyer is arguing that Tower's biological family did not want to deal with him, framing his upbringing as unstable and very damaging. Temporary insanity claim. Well, during testimony, Tower stated he was temporarily insane, which was objected and sustained, and the jury was asked to not recount that fact. When he was stabbing his parents more than 140 times, this was not a formal insanity defense, but an attempt to mitigate the intent. So his behavior and domestic violence history prior to coming to the United States, records showed multiple domestic violence incidents after he came here involving the Tower family since 2018. The defense used this argument that he had long-standing behavioral and mental emotional struggles. Emotional breakdown in court. We saw a couple. Tower broke down sobbing during opening statements, which his defense highlighted as evidence of his fragile psychological state. The prosecution objected, the courtroom was cleared, and the judge reprimanded for that behavior. He was given time to go and regather himself and get himself in a better state. They came back about 5 minutes later to resume trial. Now, with the strategy of the manslaughter plea attempts, his attorney offered a guilty plea to manslaughter of 40 years, arguing rage rather than premeditation. As I said earlier, of course, the prosecution rejected this, insisting on life in prison. So the argument of rage, prosecutors themselves acknowledged Tower acted out of rage, but they also argue that the rage does not excuse Redrum at all. The defense is trying to use the acknowledgement as a mitigating factor. And that, ladies and gentlemen, is where we are. Let me see. What's a great point? I got to read y'all's comments. Yeah. Was it premeditated, in my opinion? I believe I'm on the fence about that. I think that it was to the point that if you look at premeditated by just legal definition, it was. But I also know from personal experiences in my work career that you can be in the middle of a mental breakdown and still form a thought and then act on that thought. The thing for me was, where was he rationally? And I feel kind of that his attorney should have gone into it, but they may not have been permitted to because of court rules. As to his mental state, what caused him to flip out? I want more context, in all honesty. Now, if I'm on the jury, what my heart does and wants to do and what my mind says I need to do are two different things. I don't believe this young man should go away for life. I think life made him who he was. I do believe he needs to be in prison for a while. But the sad thing, so I guess what I'm saying is, legally, I have to say it was premeditated. Logically, outside of the legal world, I think it was premeditated with mitigating factors, and that is he was in the middle of a psychotic break and he decided to kill them. So under that premise, I would say manslaughter. So do I go with my heart and go manslaughter? Because under the situation, do I believe he was in a mental break? Yes. In that mental break, do I believe that he decided to kill them? Yes. But that would get me to manslaughter. But if I go strictly with the law and take everything else out, life in prison without the possibility. I hope that answers your question. He is not schizophrenic. Like I said, I was just using that as an example. So he was mentally and physically abused as an orphan that became a psychopath, possibly. He has no ability to feel empathy for others. Definitely. Premeditation can happen in an instant, even in anger is irrelevant. Then his anger is real relevant. Yeah, good point. See, I don't like the legal definition of, in all honesty, premeditation. That premeditation window has shifted over the years. I don't know why. This is a court-appointed attorney, but let's deal with that in a minute. What was the moment that was caught his outrage that led him to the stabbing? That's what I want to know. Dragonfly, I want to talk about that. Give me a minute. We don't know what triggered his rage. Could be. Oh, by far, by far, by far. Oh, I don't disagree with that either. And, if we're wondering this question too, do you think the jury is as well? This is the biggest question. What triggered him? Okay, let's talk about the lawyers. I don't know how it is in Florida, but it's my understanding that when you are a lawyer in in a county or an area, you are basically agree to take so many public defender cases or pro bonos. And you're put on a list, and those attorneys go through, next in line. So it's evenly divided. When all that is said, these attorneys are also paid attorneys. Uh-oh. I've already done it. Thank you, Michael. I'm getting a email concerning my graduation, making sure that everything is correct. I believe that this is, a lot of people give public defenders, some of them are just public defenders, but it just depends. I honestly think that this is a hopeless case. I think that this attorney probably, because he offered a plea agreement to the prosecution did not offer one to him, shows a lot. And that says, we know he's guilty. We just don't agree with your charges. That said, he has a right, even though he is guilty, even though he says he's guilty, we all know he's guilty. This young man has a right to a defense, and that's what he got. Is it a good defense? I don't think so. Why they did not bring in experts to talk about the trauma this child faced, I don't know. I was not there for any pre-sentencing. Could this stuff had been negotiated out in pre-sentencing? Could the judge said, sorry, if you're not pleading, not guilty by reason of insanity or NGRI, if you're not pleading NGRI, then you can't bring any of this in. And that may be why they did not bring some of this in. I'm not a lawyer. I am a criminal justice major, two different things, but that is my surmising. If I'm sitting on the jury and I'm going to wonder why they didn't bring it in, I bet it wasn't allowed in because they did not take the NGRI claim all the way to trial. Yeah, I kind of got the same Marissa from him, that he almost couldn't be bothered. I just think he was like, this is a lost case. This is hopeless. I'm not going to put more time into it than I don't need to. Sometimes at the same point, regardless of whether the defendant fault is the way he is the way he is, and that doesn't change the present circumstances. Yeah. He is dangerous. I believe that this young man has no control over his emotions. Psychopath is probably a good place to start. But here's the problem. When he gets into prison, he's only going to get worse. He's already what we call somewhat institutionalized from the orphanage and foster care and all that mess. So in my humblest of opinions, this guy is going to become institutionalized real quick. And I see him as this little fireball that's going to be out there to prove himself. And he's going to be doing a lot of fighting, and he's going to cause a lot of fights. He's going to cause a lot of problems for those people in the prison system. I got to be honest. I really believe he is. I really believe he's going to cause a lot of problems for them. Yep, I do. And it's going to be something that they're going to have to deal with, because this young man has no control over his anger. He has no control over his emotions. And it kind of reminds me of my twin brother. And my twin brother, even to this day, we don't speak. And part of that is because of his anger and the way he's behaved. When you've been institutionalized like my twin and I were, and what happened to us in our first foster home, is so horrible and you've been impacted at such an early age. We were from 7 months to 13 months old in that foster care. I went through it the other day. You go 2 days back and watch that live. It's an evening live if you want to know the deets about that. But I guess what I'm trying to say is that it becomes a part of your DNA. I mean, you are so damaged. You are damaged to the core. And that's one thing I tried to explain to somebody. When you go through a lot of trauma at such a young age, it becomes a fiber of your makeup and who you are. And it's just absolutely sad. You have to make a conscious choice as a more mature person, whenever that hits for you, to go back and deal with those things and work on yourself and become a better person in spite of it all, which is what I hope I have done. Yes and no. It's a limited restraint in the state hospital. When somebody would go ballistic, as I call it, you couldn't grab them. You could not take your hand and grab their arm and do that. That's illegal restraint. There is a certain restraint method that you can use, but it has to be in the presence of an RN and a physician, and it has to be ordered by them. And it is not pretty, but it is. But to me, it is kind of like the people doing the restraints have a higher risk of being harmed than the person being restrained. It sucks to work in a facility like that when you are not allowed to no longer restrain people because it is against their rights. And I'm like, what point do your rights outweigh my safety and my life? And that's a very fine line in those institutions. There will be GGs in prison that want him, and he will be utilized as a weapon. He can use his psychopathic behavior to his advantage in there, and that is true. I believe that this young man is redeemable. I believe you can redeem this young man. Everybody is redeemable, but first of all, you have to want it. Second of all, you have to have the opportunity and the resources to do so, and that he does not have. He will not have that in prison. He will become bait, and they will eat him up. They will chew him up and spit him out, or he will become a predator in his own right. In my humble opinion, I think the latter will be the case with this guy. I believe that he is little and mighty. He reminds me of a mighty mouse. He's little, but boy, you don't want to cross him. And that is the impression I got. I do believe that his unwillingness to look at people in the face is a part of his damaged soul. It took a long time for me to be comfortable looking people in the eye after all the abuse and trauma I suffered. And when I was going through my healing process and therapy, that is something I really had to work on. Ada, so while I think he should be in a mental institution, while I think he should be in a mental institution, I think the staff of said institution would be at risk. Maybe prison is the best place. No, I don't agree with that. And here's why, Ari. Number one, it doesn't matter whether you're in a prison or in a mental institution, the staff in either place is at the same risk. I believe, though, that under certain medication and therapy and guidance and counseling, I believe that there is hope for him. There's hope for anyone who wants it, unless you are so mentally ill due to physiological mental illnesses, chemical imbalances that they can't work on. You should never come out. But in him, with his situation, I think he's so severely damaged, he needs to be in one or the other and be there for a long time. I believe he will get more help and have a better opportunity for some healing in a mental hospital. And understand, in prison, they only give certain medications and they don't have them the management of the mental issues. They just give a certain blanket form of prescriptions to try to control some of these situations with some of their psych patients dash inmates. I believe in I believe that in a mental hospital, they would manage it a lot better and that they would have a whole lot more available to them to help him. You say that it depends on the state, it depends on the institution. My friend works as a psych nurse and they do physical restraints. I said yes and no. We can physically restrain, but it is a very scripted process for that. So, like, here's the person. I cannot walk up and take them by the shoulders. You take the palms of your hands and you run it down their side and you cross your hands in front of their bodies, pulling their arms in up here. So this is still flailing, but your arms are like this. And then there's a takedown process, which I had to learn. In all honesty, I call it bullshit. Because they expect a woman my size. And I had to do it. I had to pass the test. I had to take down my instructor who was 6'5". Big man. And I had to be able to take him down. But you couldn't just walk up and take him by the arm and say, let's go. You can't do that. You can't, if they're sitting there stabbing somebody with a plastic fork, if you physically grab them and throw them away from the victim, they can sue you and you can be held up with charges yourself. That's right. They will charge you as well. You will be brought up on charges. Well, I don't disagree with that. I don't disagree with that at all. In my opinion, he's criminally insane. Joker level mental illness, he needs to be locked up ward. I'm not saying he should be free. I'm just saying, which way do we go? Do we send him away to jail and let him be fed to the piranhas and either he's going to be destroyed even more or he's going to become a predator? Either way, he's in the system, right? Either way, he's in the system there. Or should he go to a mental facility where they can have some hopes of reversing some of the damage that he has suffered and stabilize him and get him into a better state to then put him in a facility where he's more able to mentally handle it? I don't know. There's no magic pill that's going to fix this. There's nothing. And I know people will agree to disagree with me. And I've already deleted a comment, and that's fine. No, I'm not an expert. I am not a psychologist, psychiatrist. I have to say this, though. Sometimes, and I'm not trying to be mean, I'm going for my doctoral in my field of study. I'm going to be a PhD. But I will tell you, sometimes you graduate high school, go to college for 9 years, you get your PhD, and you go out in the real world and have no real life experience in what you're doing. And then you turn around and you put them up with somebody who's been working the field for 10, 20 years. Who knows more? I'm just saying, you gotta give credit for experience is all I'm saying. You gotta give credit for experience. And do I want to sit there and be the one writing the prescriptions for this guy? Absolutely not. But do I understand the workings of a unit and the reality of how they want us to restrain people is stupid? Because I've had to do it and I have watched it. Yeah. It's like, it's one thing being in corporate making a rule for somebody who's down on the floor, who's never been on the floor. How many of us have ever watched Uncover Boss? I loved that show, where you have the people, owners and managers of these companies and of all kinds who go undercover and go to the most remedial part of their business and work with their employees to find out the truth of what's happening. And then they realize, I don't know how to make this ice cream sandwich. I don't know how to break the machine down. I don't know how to do this job. And I couldn't do this job. I have a whole new appreciation. See, just because you have book smart doesn't mean you got work smart. That's all I'm going to say. All right. So we are on the verdict watch. Oh, I have to create a thumbnail for this. Duh. I've been too busy yapping my mouth. We are in a verdict watch. So I think the consensus definitely is everybody's 100% guilty. I mean, that's no question. But June, we've already got our poll done. Do you want to start another one for me? And can that be just jail? Well, I mean, he's going to go to jail no matter what, but just for our giggles and grins, do you believe he should be in jail or a psych hospital or mental institution? However you want to word it, but it was fine. I don't care. But what do you believe? I really want to know. What do you believe? I really wish this country would get a better grip on the mental health of the people in this country and the issues that arise from mental health and criminals. I wish there was a facility that I wish there was a facility that would be a state hospital type facility that then you could, that marries or is in conjunction with a prison. So basically, you go from, you are put in this psych ward or hospital, psychological hospital, and then you are transitioned into an intermediate between the psych hospital and jail environment. There's an in between, a transition unit, and then there's the jail. And I think that's something that is really hard because they don't have separate facilities for the psych. A lot of prisons do have a medical ward, and they are starting to have medical and psych wards within the prison system, which is good. But I don't think there's enough transition, and I don't think there's enough help, and I don't think that there is enough physicians, counselors, therapists out there to handle the workload. I think this is an epidemic, and I think this is out of control. We have punitive justice system, not a restorative one. That is true. But he's someone who should have gone to a mental hospital. I don't disagree with you at all. I don't. I think that I think his situation deems him mental, not. And here's the other thing. People say, well, what happened to the test? Didn't they do a test on him? Didn't they do a psychological eval? Yeah, they did. But the problem with the psychological eval is that it's only good as the person participating. And I don't believe that for him, he participated very well, in my humble opinion. I really don't think he did, in all honesty. I don't think he participated well at all. And it was not very valid. What are you doing? My cat is gone 8 nuts. I'm not used to just wearing my hair down. We are at 35 minutes, 35 seconds into it. And also the Iowa versus Truesdell jury deliberation is in 4 hours, 4 minutes, and 53 seconds. So I don't know anything about that trial. Let me do a looky-loo into that if you don't know. I do know we have notes on it, but I don't know much about that trial. Forgive me. We did not follow that trial at all. I don't know what the cat's playing with, but it's funny. What do you got? Oh, she's got one of my little pink Christmas trees. Lord have mercy, child. Lord have mercy. She's playing with that. I don't know where she got it. I haven't seen it. Thanks, Angela. Hope you had a good stretch. So I'm going to be talking about the Luke Trudell trial in just a second. I'm just going to give you a quick rundown. Nothing major. We may want to start watching that just for giggles and grins. I don't know. I don't know how many days it was in trial. Let's look at this. Okay. The Luke Trudell is on trial in Lynn County, Iowa for the brutal quadruple red room of 4 people in June of 24. We missed that. He is charged with 4 counts of first-degree red room, which carries a possible sentence of life in prison without possibility of parole. His defense has argued for lesser charges, including second-degree or even manslaughter, but the prosecution insists the killings were premeditated and deliberate. Here we go, another one of these cases. So here's a quick trial recap and the timeline of events. So June 5th of 2024, 4 victims: Amanda Parker, 33, Romadus Cooper, 44, Romadus, Keona Ryan, 26, Brent Brown, 34, were beaten to death with a metal pipe on a rural property near Merriam, Iowa. The body camera footage and the police interview shows Trudell admitted to striking the victims with the pipe. He later told investigators that drug use and past trauma contributed to the violence. DNA evidence, the recorded red room weapon, metal pipe, and Trudell's own statements formed the backbone of the prosecution's case. The charges of 4 counts of first-degree red room is defined as premeditated intentional killing, life in prison without parole. Iowa does not have a DP, so that's the most he can get. The lesser charges considered are second-degree red room, which is defined as intentional killing without premeditation, sentence up to 50 years per count. Manslaughter definition, killing in the heat of passion or reckless disregard, sentence 10 to 25 years per count. So it's a lot less than Florida. The defense sought to reduce the charges by arguing rage, drug influence, and trauma, but prosecutors rejected these insufficient to mitigate the premeditation. So prosecutors presented body cam footage and DNA evidence. Witnesses described the crime scene at Trudell's confession. The defense strategy highlighted Trudell's drug use, meth provided by victim. One of the victims was his dealer, and traumatic background argued his diminished capacity. In the closing arguments, November 13th to 25, prosecutors emphasized that the brutality and deliberate nature of the red room defense urges jurors to consider lesser charges. Jury status and deliberations are right now underway, making this one of Lynn County's most significant red room in decades. So that is the information on that. Yes, we are. Yes, we are, unfortunately. So right now, let's look at the poll. We only have 9 votes. We have 13 of y'all watching. Y'all please go and vote in the poll. If convicted, where should he be sentenced to? And it's really tied all the way across. We have 3 votes for mental health, 3 for prison, and 3 for hospital first and then prison. This cat is like it's on crack. But the problem is he ain't going to get any of that but prison. He will go straight to prison. Unfortunately, that is the only option they actually have. But I just wanted to get y'all's opinion on it. Yes, I have a heating pad on my chair at all times. My back loves it, but I'm hot flashing, so it's kind of like, yeah, what do you do? What do you do? I really would love to hear some professional opinion on, I want to hear some psychological, babble about what they think about this guy. I'm looking for video. He's going away for life to prison, in my humblest of opinions. But do I believe? What the heck? Oh, we've already seen that. I'm looking up some stuff, but do I believe that he should receive help? He is so broken by the system. I firmly believe that. I understand where everybody's going with this. I understand a lot of people don't agree with me on this, and that's fine. But, it's one thing if you've never been in the system, you don't know what it's like. And the system that's there now just destroys and tears people apart limb by limb. And if you look at the statistics, and I mean, really look at the numbers, how many children who've been in the foster care system or who are adopted at a late age, such as 14, actually have a successful, I can't say it, successful, there it is, family unit and a successful integration into the family that's actually adopting them. I don't see a lot of that. I don't. And I'm not trying to be negative and all that. I'm Ken Ross. Hey, chat, I missed yesterday and the closing, but I watched the replay of his testimony and I agree with you too. Well, thank you very much. Thanks for agreeing. But what? I'm going to members only and court TV and see what they got there. 8 months ago? You don't have anything quicker, sooner? Oh, that's all old stuff. Never mind. I don't want old stuff. I want new stuff. Give me the new. We do have Ian Mitchum, which we will be watching his trial. That's going to be starting a little later today. Ian Mitchum is an interesting case in and of itself, but let me see when he starts. I think Ian Mitchum. Why? Which case was? Okay, Ian Mitchum doesn't start again until Monday. They are off until Monday, so that's why we're not watching him today. But we do have the Devin Michaels Day 7 Triangle beheaded Red Room trial. She is the ex-porn star that beheaded her husband. Well, no. I don't think they were actually married. That was a question I need to get answered because I had somebody jump my goat big time yesterday about my calling marrying her stepson is not real. She was never married to the man. And I don't believe she was. But my whole thing was so she was okay. So no, Devin Michaels was never married to the victim, Jonathan Willett. She was his girlfriend and the mother of 2 of his daughters. But the marriage connection was to the son, not Willett himself. So here's a breakdown. Jonathan Willett, age 46. Let me move all this. I need to move it because I can't read it from here. And my mouse is doing that swirly thing again. There it goes. I have to just manhandle it. You know, what can I say? It is what it is. So I'm going to talk about the relationship between the victims. Oh, okay. So breaking down the relationship between Jonathan Willett and Devin Michaels. Now, Jonathan was 46 years old and he had 2 daughters with Devin Michaels. He and Michaels had an on and off again relationship, but they were never actually married. The twist to the married, instead of marrying Willett, Michaels later married his son, Devin Willett, age 29. Shocking 18-year difference. She's a cougar. The details did come out during trial testimony where Deviere confirmed he had been in a relationship with Michaels, his quote, in facto stepmother, for years before marrying her. Prosecution narrative is the prosecution's argued that Michaels killed Jonathan Willett in August of 23 because she wanted him out of the picture after marrying his son. In the legal proceedings, Michaels initially pled guilty to second-degree murder, but later, oh, June, that's what I want to do. I can play that video. Later withdrew her plea, leading to the jury trial. So far, the jury takeaways is that in the case, the aspects of the case is that Michaels married her victim, but that is untrue. It was the son of the victim. The marriage is central to the prosecution's theory and motive, painting the crime a part of a twisted love triangle. Oh, June, did you put that in the private chat to me, or where did you put that video? There they are. Found them. We're going to watch these videos. The first one is last, and the last one is first. Okay, I got to pause these. Okay, so here is the first video. Let me switch modes. There we go. Let me turn on the sound. This is a video where she loses her shite.
Yeah. He's not going nowhere. Nobody's going.
Mark, you know that airplane you mentioned?
We're just gonna. Goldfield? Yeah.
Remember.
There is an airplane right there. It's an abandoned like Cessna. Like, sitting there on the side of the road.
While we're listening to this, I want to let you know that in this poll, if convicted, where should he be sentenced to? Or the 9-month trial, you guys it's not what I expected. Mental health hospital, 36%, prison, 27%, hospital first, then prison, 36%. I am shocked.
Right outside. No, there's a sign. There's a plane and there's a sign. Oh, yeah. I used to make that drive like multiple times.
And look at her hair. It looks like she almost doesn't have any. Look at the thinness. Look at her, and look at her in court. Almost, I wonder if she got extensions. But she's an ex-Pone star. Yes, she's a Cone star, and she has connections to the Monica Simitilli trial. She was married to Baker, the one who read from Monica Simitilli's husband. Yes, this is interesting.
Up north. Not to the rock.
She was one of his Pone stars.
For the record. I actually like that drive. People get really down on it because there's a whole lot of nothing, but I kind of think it's fun. If you're in meditation, it's fun. Otherwise,
I told her that.
like a better I did it once from across interstate or across 50. I did it from Highland all the way to Utah. We were going to did it, my Utah, usually we do that. Goes along with it. And so it's like an extra 2 hours.
What about second you doing?
And that's the other that road trip. These guys, yeah. We were over half the room in here.
Right next to Ralph, she all the way down there.
Yeah.
Wind down. Ladies.
I bet that woman sitting next to her with those broom weaves is just oh so happy to be on TV next to this little twig.
I did not mention the name.
That's probably
You're ranting about me not going to Piper for a case that wasn't mine.
Now, y'all, this judge talks about 100 freaking miles a minute. I can't ever understand a word she says. I have to read.
All right, Mr. Patrick, oh, we need Mr. Leventhal. As soon as he gets there, I'll call you.
Okay.
Mr. Meningo, you're arguing information by affidavit, I'm gonna wait.
Yeah.
Do a couple of cases, Mr. Troiano, do you have anything wrong?
Co-counsel with Mr. Altig, Murphy, he said he's walking up
Okay,
now, so he should be here shortly.
all right. Mr. Horvath, Mr. Draskovich, are you guys ready
Yes,
on both your cases?
yes.
Okay, let's go to, let's do Michael's, because Mr. McNeil isn't here. So, page 10, C, 377-239, Tate Matter versus Devin Michaels. May the record reflect that Ms. Michaels is present in custody. Mr. Draskovich, Mr. Horvath are here on her behalf. Mr. Giordani is here on behalf of the state. This is the date and time set for appointment of counsel. Mr. Draskovich, are you able to confirm as the attorney of record?
Yes.
Okay, and then will it be you in, Mr. Horvath?
Yes.
Okay. Mr. Justice, I indicated to Ms. Bush that I wanted to move this case and I wanted to set it for trial. Are you guys prepared to set the trial today?
We are.
Did you have any discussions with Mr. Giordano about when you wanted it set?
Yeah, we briefly discussed it. Mr. Horvath mentioned October, November this year. I can't do November. I can do October. Otherwise, it would have to be.
Your Honor, I do have a firm setting trial October 14th. So if we, I mean, I would prefer if Your Honor is able to do it January, February. I know that is not as quickly as you'd like, but we do have several ones going.
The problem with those dates is I have one that's firm in January, and when you set that capital one.
The capital was going to get it, but what firm date do you have in January?
Iola, use, and that's firm. According to the judge,
What is it though? What about the beginning of January?
it's January 5th.
Oh, it is?
I can do November,
Your Honor, I know we've got some moving in November.
Okay,
like middle November, Judge.
all right, I can do it November 10th. Does that work for you guys?
Actually, can we do the following weeks?
Sure.
We have Sarate.
That's December. December of the month, yeah.
Yeah, because that's in here.
Yeah.
Zarate is December 1st. So November 17th,
November 17th.
okay, that work for you guys?
Your non-default date will be November 6th at 9 a.m. Your pre-trial conference will be November 30th at 9 a.m.
No, can't be November 3rd.
I'm sorry, October 30th. The US session. Yeah.
Late.
Your staff check will be September 25th at 9 a.m.
Okay. All right, and as soon as Ms. McNeil gets here, I'll call your other case. Okay.
Mr. Altig's here.
Okay. You guys get ready on Murphy. Let's go to page 6. It's gonna see 388-015, State Nevada versus Lucius Murphy. Make the record reflect that Mr. Murphy is present in custody. Mr. Altig and Mr. Troyano are here on his behalf. Mr. Pesci is here on behalf of the state. This is the date time set for national trial readiness. However, there was a plea agreement filed on August 1st. Is it your intention to go for one count of voluntary manslaughter with use of a deadly weapon and one count of battery with use of a deadly weapon? As to counts 1 and 2, the state will retain the right to argue with revocation of sentence. As to both count 1 and 2, the state agrees to cap the argument at 10 to 25 years between the 2 counts in the Nevada Department of Corrections. Is that your understanding of the deal?
Yes.
Sir, what is your?
Okay, so we go from that.
State's present, defendant is present with counsel. Ladies and gentlemen of the jury, if you reached a verdict.
May the record reflect that Ms. Michaels is present in custody. Ms. Patrick is here on her behalf. Mr. Giordani and Ms. Griffith are here on behalf of the state. Mr. Dave comes up for sentencing. Are both parties prepared to go forward?
Yes, Your Honor, yes, Your Honor.
All right, state, this is a stipulated sentence. Anything you want to add?
I do just a couple of things, Judge. First, we have 3 victim speakers. I asked if they permitted me to speak last.
Okay.
We obviously went to a settlement conference. We stipulated this sentence. I think that the life tale reflects the gravity and the haunting nature of the facts. As you know, the defendant not only murdered her ex, but then desecrated his body by decapitating him and putting chemicals on his body, causing it to burn. The defendant admitted to the fatal blow. She never admitted to the decapitation portion, but the evidence was overwhelming that it was obviously her who did it. Another haunting fact, and something that should be concerning, which supports the life tale, is that the defendant had a corollary child abuse case that pre-existed this. We reviewed, Ms. Griffith and I reviewed the minutes in that case, and it appears that 2 days after she murdered and decapitated her ex, she appeared in court in front of another judge in this courthouse and made representations that she was staying out of trouble, and obviously had that on her conscience at the time, walked right back out of the courthouse, and then ultimately was developed as our suspect and arrested. We take this case very seriously, obviously the family does as well. We believe the sentence reflects the gravity of the crime, so we will submit it. We do have some updates on CTS, which was wrong in the PSI.
Correct. I calculated the credit at 455 days as of today.
Okay, that sounds correct.
Because I calculated it in regards to she was on probation when this offense occurred. She then got that sentence imposed. She was released on that sentence, so she started accumulating the credit on that day. And I have it at 455 days as of today.
Yes, and we also have restitution requests. We've now received documentation.
Actually, I did not receive documentation.
Right, we just received it this morning. We showed it to Mr. Patrick. It's supposed to be 5,000 to VOC.
I have that.
1,923 to James Willett.
Hold on just one second. $1,923
Yes.
to whom?
James Willett,
Okay.
and $2,500 to Yoko Willett.
How do you spell the first name?
Y-O-K-O.
Mr. Patrick, have you seen this?
I have, Your Honor.
Okay, what's your position in regards to the restitution?
They had the documentation, we're okay with it.
Okay, State, I'm gonna need you to file that documentation. Just pursuant to the new case law, I can't order restitution without documentation.
Yes, ma'am.
All right? Ms. Michaels, what, if anything, would you like to say before I pronounce sentence against you?
There's so much I want to say. Jonathan was very special, very unique, and I know no matter what I say at this moment, I know right now, no one in the family is going to believe me. I know right now, no one in the family feels that I am innocent at any point, and I understand that, but I can actually prove my innocence. I actually can, and
I'm not gonna stop fighting to prove my innocence. I have more than enough, and Jonathan deserves to have the actual person who's guilty behind bars. I was helping Jonathan. I can show that I was trying to help him, and this, I know, is hurting the family, and I can see it in your faces, and I know your hearts are angry, and they should be, and I'm angry for you. And this is not fair to you. This has been dragging out for almost 2 years. It's not fair to you. And it's not fair to his children. And
We're going to stop here. We got something that we need to watch. Okay, guys. Hold on. I got a static coming from somewhere.
Alternatively, the defendant seeks an order. And then once I do this, I'll certainly turn it over to you. We're going to have our formal, really today's purpose was to address the competency. But to the extent that I could pick off issues that aren't technically motions in limine, but other important motions to the parties, I focused on those today. And I am prepared now to make a ruling on the change of venue paper. That's paper number 219, and I'm going to read that into the record now. Mr. Walsh has moved for a change of venue on the grounds of extensive and prejudicial pretrial publicity that he asserts has tainted the jury pool so as to deprive him of his right to a fair trial by impartial jury. Alternatively, the defendant seeks an order that prospective jurors be selected from outside of Norfolk County. In support of his motion, the defendant has submitted evidence of extensive national and local media coverage of the case, beginning on January 6, 2023, after Anna Walsh was reported missing, and continuing till the present day, as well as evidence of social media engagement with this case. After careful consideration of the defendant's motion and the exhibits provided to the court, I'm denying the motion and the request for alternate relief for the following reasons. The court may order a change of venue where there exists, quote, it exists in the community where there is a prosecution is pending so great a prejudice against the defendant that he may not there obtain a fair and impartial trial. And that cites back to Massachusetts Rule of Criminal Procedure 37 and Commonwealth versus Clark, 432 Mass 1 at 6, a 2000 case. A judge has substantial discretion to transfer a case to another county based on pretrial publicity. And according to Commonwealth versus Gaynor, 443 Mass at 245 at 259, pretrial publicity, even even pervasive adverse publicity does not inevitably lead to an unfair trial. A change in the place of a trial should be ordered with caution and only after the defendant has established, based on a, quote, solid foundation of fact, that the pretrial publicity has created presumptive prejudice. And to that I cite to Commonwealth versus Hart, 493 Mass 130 at 141, and Commonwealth versus Tulin, 460 Mass at 452, pinpoint site 462, 463, a 2011 case. Presumptive prejudice exists only in truly extraordinary circumstances where the trial atmosphere is utterly corrupted by media coverage. And, quote, the entire venire may be presumed prejudiced regardless of specific voir dire procedures utilized. This standard is only met if the publicity is both extensive and sensational. And to that I cite to Commonwealth versus Who's, 467 Mass. 395, 406, a 2014 case. In assessing whether pretrial publicity precludes a fair trial, the court should consider additional factors such as, quote, the size of the community, the length of time between the peak media coverage and the date of the trial, and whether the news stories contained a confession or smoking gun rather than merely being unkind.
Coming up, we're going to have more from the competency hearing for Brian Walsh. And also, you will notice that verdict clock in Florida v. Tower has stopped. We have a verdict in that case. We'll take you there when we come back.
What?
Walsh, and also, you will notice that
hour, 30 minutes. And by the way, I Googled Devin Michaels and her torn horn corn pictures popped up. Holy crap. Don't Google her name. She doesn't look here at all like she looked before. I'm just saying.
verdict clock in Florida v. Tower has stopped.
Verdict. We have verdict, everybody. We got verdict. An hour and 30 minutes. That does not shock me at all. At all. I'm back just in time, Miss June. I'm going to call it Dima Tower guilty. I'm not laughing at the situation. I am just laughing at how you did that. But yeah, I was Googling Devin, but she spells it a little differently, to get pictures for updating her little thumbnail. Holy snap. I don't want to look. Don't want to see that. No. Thank you. Can't get that out of my head. She don't look the same, boo. I mean, you know, it's her. Especially with a profile of the face. But that don't look like her now. Oh, Lord have child. We'll be back over here until they come back.
And it's not right. It really isn't. It's not. I've seen so much that it's just terrible.
You're terrible, boo. Okay. He is prepping his client. He's probably telling his client under no circumstance. No! I'll be right back. I've lost audio. I got to recycle. I don't know why the sound is telling me, so I went ahead and just recycled it, y'all. It just tells me that my server has lost connection with sound. It's glitchy. The gremlins, go away, go away. Verdict is in. Looks like he's already been crying. Just saying. How's my hair look? I normally don't wear headbands. I normally don't wear headbands. Of course, we do not have any sound at this point. Yeah, we all know he's guilty. Yeah, we all. So I'm going to come back over here until the jury comes in.
The way that they manipulated and altered and deleted things is wrong. They should not be able to do it. And they have. And for you to be able to look me in the eye knowing that the things are altered and
You pled guilty, man.
Mr. Michael, you are not to address the state. You are to
I'm not
address me.
addressing
You are.
the state. I
You're addressing Mr.
apologize.
Giordano. You are going to address me. What do you want me to
apologies.
say? What do you want to say to me?
My apologies. I wasn't trying to address the state directly. It's just, I was told. I just told one thing after another. And I truly believe that we were going to do the right thing, and it just didn't happen.
Okay, this is Devin Michaels. We are following her trial. We're waiting for her day 3 to start, or day 4, whatever day we're on. She'll be starting shortly. This is a trial that she is alleged to have unalived her ex-boyfriend, baby daddy, and she married her She dated this man, and she married his son, 18 years younger than her. And he had 2 daughters with this man, not the son. And she unalived the man and chopped off his head. The head has not been found. Decapitation. Decapitation.
Everyone, good afternoon.
At his finest.
2 more minutes, I guess. All right, Deputy, I'm told we have a verdict. Is that right?
Yes, Your Honor.
All right, we have everybody present or both sides.
I'll
ready
explain
to
it in a
bring the
minute.
jurors Back in.
Yes, Your Honor.
All right, let me just caution everybody in the audience, we're going to respect the verdict, whatever it is, by this jury. So please, similar to what we talked about earlier, no outward signs of emotion or comments. We need to be professional, respect the jury. So if you can't handle it, then I need you to remove yourself kindly, okay? All right, let's bring the jurors in.
We'll ring the jury. Look at that. I use his to clean the off of my keyboard and such. Yeah, if you buy a Cadillac, a Lincoln, a Lexus, they're going to give you one of these, and they're just going to have their little emblem on it, and they're going to charge you $100 for this little brush. I kid you not. A friend of mine got a card, and when she got home and looked at the receipt, it was $100 for that brush. It was $3 online. Yeah, she should have kept the plea deal in our humblest of opinions. I don't disagree with that at all. This is really good for dusting things like fans and things that you can't normally get into. It's basically a makeup brush, but it works great.
All rise, jury entering.
I just dusted my fan while it's blowing now.
All right, welcome back, everybody. Everybody may be seated. Members of the jury, I'm told that you reached a verdict. Is that correct?
Yes.
Can the foreperson hand it to the bailiff? I take a look at it next to make sure that it's executed, signed, and dated, etc. And then I'll hand it to the clerk. Can you please hand this to the clerk? And the clerk is going to publish the verdict.
In the Circuit Court of the 12th Judicial Circuit.
Get on the mic.
Sarasota County, Florida. State of Florida versus Dima Tower. Case number 2023 CF 8812 NC. Verdict. We, the jury, find as follows as to count 1, victim Jennifer Tower. The defendant is guilty of murder in the first degree as charged. We, the jury, find as follows as to count 2, victim Robbie Tower. The defendant is guilty of murder in the first degree as charged. We, the jury, find as follows as to count 3. The defendant is guilty of fleeing to elude a law enforcement officer as charged. So say we all this 14th day of November 2025, signed 4%.
Members of the jury, there's something we do after every verdict. It's called polling the jury. So what I'm going to do is I'm going to start in the back. I'll go left to right, then I'll come forward and go left to right. Okay?
Yeah.
So to the gentleman in the back left, is this your verdict and the verdict of the jury as a whole?
But understand, the lawyer did not want him to take the stand, and he did it anyway. That's all on Dima.
Yes. To the gentleman next door, is this your verdict and the verdict of the jury as the whole?
Yes.
Ma'am, is this your verdict and the verdict of the jury as a whole? Ma'am, is this your verdict and the verdict of the jury as a whole?
Yes.
Young lady on the far right, is this your verdict and the verdict of the jury as a whole? To the gentleman in front, is this your verdict?
Yes.
Next gentleman, is this your verdict? Yes. Sir, is this your verdict?
Yes.
Sir, is this your verdict?
Yes.
Ma'am, is this your verdict?
Yes.
Ma'am, is this your verdict?
Yes.
And ma'am, is this your verdict? Folks, on behalf of everybody, I want to thank you for your service. We have different types of trials. This was a longer trial, although as I mentioned, not terribly long. We do have those that are longer. We asked a lot of you. You came in Monday on a week with a holiday. You were here all week, early in the morning. So we all truly appreciate your service. The system cannot function without you folks. And I talked a lot about that on Monday. So thank you. You have a right as a juror not to discuss your jury service with anybody. That's a right you have as a juror. It would take a court order to compel it. I haven't seen it in my career done. You also have the ability to speak to whoever you want. That's a right you have as a juror as well. No one can prevent you from speaking. I know it's a big ask, again, Monday through Friday. I hope the experience was good for you. We try to be as efficient as possible with your time and not get you in and out as efficiently as possible. So again, thank you. Your service is done. What I'm going to do after you leave is I'm going to talk to the parties. We'll discuss setting a sentencing date. I don't know if we're going to do that today or if we're going to do it down the road. You're welcome to stay. You're welcome to leave. You have no further obligation to the court. I think it gets you out of jury service for a year. So there's some good news. But again, thank you. Make sure you take all your personal belongings with you when you leave. If you want to find out what happened or what happens, you can give my judicial assistant a call, Jennifer. Her number's on the board, I believe.
To hell with giving a call. Just go on YouTube.
In your jury room, you can give her a call later today and find out what the next steps are. Okay. Thank you so much, everybody, for your service. Can everybody please stand? Our jurors are now exiting the courtroom.
I think there were some motions in limine and there was very limited amount that he could share because they did not take on the NGRI plea. And because they didn't have the not guilty by reason of sanity or mental capacity or whatever they, depending state calls it, he couldn't bring that up. That was not the defense that they took. And the fact that we don't know what happened with the psychological evaluation that was held, whether it was conclusive or not. So there's a lot of what in this trial. He did offer a defense. He wanted guilty of manslaughter.
All right, let's take I'm going to take a 2-minute break. I'm going to go thank the jurors for their service in the jury room. Why don't let's leave Mr. Let's handcuff him. Let's leave him in here for now. Why don't you talk among yourselves when you want to do sentencing, how you want that to take place. I'd also like the attorneys to please approach and take a look at the verdict form before it's filed. Okay. I'll be back in a couple of minutes.
Okay, while they're doing that, we're just going to hop back over here. All right, what is going on with her? This is the plea hearing that she took. She took a plea deal. She's getting ready, literally. Let me do this. Let me switch over here. She is literally getting ready to undo the plea deal. This is going to get juicy. You don't normally see this, where they take a plea and they get up before the judge to accept the plea and get sentenced, and then they revoke it.
I'm so sorry for all of this, but I'm so sorry. But I didn't do this, and I didn't know this would end up like this. I really didn't. And I will forever apologize to the family that I don't know how to fix any of this anymore. I don't. I keep listening to what everyone tells me is the best thing to do. Just do this and it'll work out this way and follow this advice and we'll do this. And I keep listening to the people because they keep saying this is the best advice. It doesn't turn out the way they tell me it will. And it just gets worse and worse. And I don't know what to do anymore.
Judge, I'm not comfortable with this record. I'm willing to let her out of her plea if the court's inclined.
I don't know how to fix this.
All right. It's just, this wouldn't be appropriate.
I completely understand.
Let's go to trial.
All right. Ms. Michael Judge, Mr. Giordani says that he's willing to let you out of your plea and he's willing to try this case. And you understand that he's willing to try this case on an open murder. So a jury can convict you of a first-degree murder. You understand that? Or do you want to talk to Mr. Patrick about it?
I don't want to talk to Mr. Patrick. He didn't listen to anything I
Miss
said.
Michaels, I need you to understand what I'm saying to you and answer my question. Do
Yes.
you want to withdraw your plea and go to trial?
Yes, please.
All right, this plea is going to be withdrawn. Ms. Patrick, I need you to have some discussions with your client
Your
about.
Honor, I've moved to withdraw at this time. This case needs to go back to the appointed counsel.
Ms.
I will-
Michaels, hold on just one second. Ms. Michaels, you need to conduct yourself like this is a courtroom. If you cannot do that, then they're going to remove you because I still have business to conduct.
Yes.
Do you understand? Mr. Patrick?
Judge, respectfully, I move to withdraw and have this case sent back to Office of Appointed Counsel. I am not in a position to accept appointment on this case should it go to trial at this time.
All right. All right, I'm gonna have to reach out to the Office of Appointed Counsel and get her a lawyer that's going to be appointed with the understanding this case is 2 years old. This case is not going to sit stagnant and wait around for a trial. So I'm going to reach out to Ms. Bush myself and have a discussion with her in regards to the appointment of counsel because this is not going to be, this case has been delayed extensively, and this case is not going to further be delayed so that there is no justice for everybody.
Yes, Your Honor.
And Your Honor, if I may, that's one of the other reasons, because with Barry Edwards, it would be late next year before I would even consider putting this on as a trial.
So I'll reach out to Ms. Bush,
Understood.
July 31st, 9 a.m.
And Your Honor, do you grant my motion to withdraw, please?
Yes, I'm going to grant your motion.
Thank you.
Yes, we do have the bingo card. Let me pin that for you, Missy. I'm pinning it. There we go. We do have the Devin Michaels bingo card. I do have the other ones from yesterday. So what's happened basically here is that she reversed her plea. Her attorney was like, boo, I ain't taking her to trial. See ya. And now she's got the new attorney. So whatever the deal was, it wasn't less than what she's going to get. I think it was 30, 40 years, something like that. I don't remember. I can Google it. Let me Google it. Okay, let me see what the plea deal is. Thank you, Google. Devin Michaels originally accepted a plea deal, which she pled guilty to second-degree murder in the death of Jonathan Willett. The deal would have made her eligible for parole after serving 15 years. Holy crap, girl! You should have taken the plea, boo. She later withdrew that plea, protesting her innocence, and chose to go to trial instead. Yeah. So in 2024, she admitted to guilt under the plea deal on July 25. During her sentencing, she emotionally withdrew that. We just saw that. Oh, so she's been in jail for a while. Ooh, y'all, she's been in jail for a while. Seriously, and my monkey's going nuts. She must be out of water, so I need to go get her some water in a minute. So we are waiting for them to come back in the Dahmer trial. I need to see if the
that on
trial has
some
started.
occasion, Mr. Boileau was alleged to have discharged a firearm from a vehicle into a wooded area. All right.
What is this?
Very good.
Okay, I guess we're not coming back. So I guess they're done in that case. So I'll keep that running and see if they pop back. Give me a minute, if you don't mind, please. We got to go see if we can get into the other trial. Is this live yet? Nope, it was supposed to be live. So we are waiting for the Devin trial, Devin Michaels trial. And yep. Yeah, I couldn't believe that. He was begging to withdraw. Yeah, he was like, I'm out. I'm like so out of here. Hold on a minute. The monkey is just rattling the cage in there, and my son's ignoring it. I think he's asleep. He worked late. He worked real late last night. But okay, so they got the seal up, so we're not out of court yet. Oh, we are. Let's see. Did they finish? I think that's it. I think they're going to come back another date. Yep, Court TV has ended the feed, so that'll be it on that. So now we are switching gears. We are now switching to the Devin Michaels trial. Should I switch my lives? Should I create a new live? That is my question. That is the question, y'all. Let me go here. Okay, I think what I'm going to do is we'll just stay here. I'll relabel it. We'll put verdict. I'm just going to relabel all this. I know my monkey is not happy. I will go take care of her in a minute. Can y'all hear that? I need to go take care of her because she is not a happy little girl. I'll redo this in a minute. Y'all, let's take a stretch break. Everybody get up. We're going to, let me put up the little break thing. I'm going to put up my little yogi guy. We'll be right back. Sorry about that, guys. I needed a little comfort break. Didn't realize how bad I needed one. So thank you so much for that opportunity. And everybody's back. Yay! We're all here. Woohoo! And while I took that comfort break, got me something yummy. It is lunchtime here for me. It is 11:24 and court still has not started, although they were slated to start at, there it is. That's when it was supposed to start. 11 o'clock my time. So we are waiting for that to happen. So we're going to try and get back to the motion hearing that was, or the hearing that was happening that we were watching. I apologize. We got diverted. Diversion. We got diverted due to the verdict that came in. No, I don't want your channel stats. I want that motion hearing. Where's the motion hearing? Where's the motion hearing? I can't find the motion hearing now. Oh, yippee. Let me see if they have it. Everybody's going off about the verdict. I get the verdict is important, but I also want to hear that motion hearing. And why can't I find it? Mod, can a mod help me out and see if we can find that motion hearing? Let me get back into here. I've got somebody in Discord that will not leave me alone and take a hint. So just got here. The verdict is in. Yes, hello, breach. The verdict was guilty on Redrum count, both counts, Redrum in the first degree and evading arrest. He got all of it. He got all of it. Yep, he did. Every bit of it. They didn't believe him. Okay. What are we doing now? Okay, I'm going to share this. Let me get everything up and running so you guys can see what I see. Do that. Okay.
Members of the jury, there's something we do after every verdict. It's called poll.
Okay.
Are they going to want to be?
We're back in court. Courtroom ended their feed. I don't know why. So they're back in court. Let's see what happens. I'm going to take a few bites.
We have everybody back in the courtroom. Thank you for your patience, folks. All right. Did the attorneys have a chance to come up and look at the verdict form?
Yes, Your Honor.
Okay. All right. What are your thoughts on sentencing?
Your Honor, as all the interested parties are currently present and the court does not have discretion based on the jury's verdict as far as what the sentence can be, we would prefer to go forward today.
Okay. State, are you prepared to go forward?
Yes, Your Honor.
Okay. Are you prepared to go forward now through the lunch hour?
Yes.
Yes, Your Honor.
Okay. Okay.
The state does have some family members that would like to speak to you briefly.
Sure. Are you ready? Do you know how you're going to proceed and what order? Okay.
Whenever you are, Your Honor.
Okay. I'm ready.
All right, thank you. I'm going to first call Phil.
Let me stop you for one moment, Ms. Frabling. I did, folks, have Zoom open for the entirety of the trial. I was always letting folks in. I'll note that they were good in the sense that they would come in before 9. I didn't have to let them in throughout the day because they were all on time. So there are folks that are also on Zoom. I don't know if these are folks that you want to be heard as well. Can I, Deputy, Carl, can you turn this TV around? The jurors are gone, so I don't mind turning that around now so that the state and the defense can see who's on Zoom. This- Oh, they might have unplugged it? Okay. Let me have the state and the defense come up. You can take a look at the names that are on here.
Ms. Torres, may I get her back into the courtroom?
Sure.
Ms. Torres? Please come up to the moment.
Yes. Let's leave it where it is. Yeah, thanks. All right, why don't you come take a look and write down the names, and then you could find out if these are folks that want to be heard.
I just ate my egg.
It says Warren Rhines on this one, and it looks like two people are there. Do you know who that is? All right, are they going to want to be heard? Okay, there's someone with the name Sean Tower. Is that someone that wants to be heard? Why don't I find out who these folks are, and let's okay. All right, if I can have Warren Rhines, please unmute. All right, you're unmuted. Can you please tell me who you folks are?
And I am the uncle of Robbie Tower.
And I am Darlene Rhines, the aunt of Robbie Tower.
All right, so we have aunt and uncle. Do you wish to be heard today, this afternoon at the sentencing hearing?
I do not.
No, thank you.
Okay. All right, so we have an aunt and an uncle that have been here on Zoom but do not wish to be heard. All right, can Sean Tower please unmute and turn your video on?
Sorry, Your Honor, I don't have a camera hooked up. No, I'm Robbie Tower's brother. I don't wish to be heard.
Okay. All right, how about, there's someone with the name Gladys that's on the Zoom.
Hi, I am a friend of the family and I do not wish to be heard.
You were in the courtroom this week, weren't you?
Yes.
Okay. All right, friend of the family does not wish to be heard. So we have no one on Zoom that wishes to speak. I have no preference on order. Why don't we, any objection to the state proceeding first, Mr. Gilman?
No, Your Honor.
Okay, state, please call your first witness up or person up to the, why don't we use the witness box, okay?
Yes. State calls Phil Tower.
Stand here, you're going to face the clerk. No, face this clerk. Raise your right hand.
Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
That's okay.
Thank you.
Yeah.
Give this to Mr. Tower. Thank you. Good afternoon, Mr. Tower. Can you please tell us your full name and spell your last name?
Philip Tower, Tower.
Okay. Would you like to address the court?
Court,
And
not
Ms.
particularly.
Right. You're
Whatever
gonna
it is
address,
that you
yeah.
want to say, sir.
Oh, I just want to talk to Dima.
Hold on.
No.
Whatever it is that you wish to say, direct it at me.
Oh, okay.
You can tell me what you want to say and what you want me to know. This is a sentencing where you can give the court input, okay?
Okay,
Of course, Mr. Tower, the defendant is the courtroom and will hear what you have to say, okay?
right. I just wanted the court to know that Dima didn't just You didn't just kill Robbie and Jennifer. Killed a part of all of us. And there isn't a person over there that doesn't hate him. And we want him to suffer. And I'd just like one more thing to say. I have a lot of things to say, but you probably wouldn't like it. I want him to, when he's Dima, look at me.
No, sir, you go ahead and direct your comments to me, okay?
I would like him to change his name while he's in jail. I don't want him to use my name anymore. I don't want him to be associated with us. And a lot of things I want to say to you, to him.
Take your
I
time.
don't believe you'd allow it, so I'm just gonna leave it at that. I don't think I could go any further.
I don't know, Ms. Fablik, if you wanted to ask him any questions?
No, Mr. Tower, this is really a chance to talk about your loss and what Jennifer and Robbie meant to you and the loss in your life. So I think that's better than right now retribution, because the judge will take care of that.
Yeah, I can't put into words.
Why don't you tell me this, how is Jennifer or Robbie related to you?
Robbie's my son.
Your son? Tell me about your son and your daughter-in-law.
Well, they were just great people. They were honest. They were religious. Cared about everybody. They would give you the shirt off their back. They'd help you. They were big in the church. They went on pilgrimage. You know what I'm saying? They went to different pilgrimages, whatever. They went, and that's how they met Dima. They just wanted to help somebody. They couldn't have children of their own. They saw Dima, they figured they'd give him a chance at life. And that's how we repaid them. There wasn't anybody that didn't like them. And it's just a total waste of good people. I don't know what else I can say that build them up any more than that. I don't have to. We'll miss it.
Thank you, Mr. Tower.
Thank you very much, Mr. Tower.
Take your time.
Thank you.
The state would like to call Michael Burgoon.
That's horrible, y'all.
Do you need this? Okay, thank you.
You solemnly swear or affirm that the testimony you're about to give will be the truth and whole truth.
I do. Okay, so come this way.
Good afternoon, sir.
Good afternoon.
Will you tell us your full name and spell your last name?
Michael Burgoon, Burgoon.
And how do you know Robbie and Jennifer Tower?
Jennifer Tower is my sister, and of course, Robbie was my brother-in-law.
Okay, and is Jennifer younger or older than you?
Couple years older.
Couple of years older,
Yes,
so
ma'am.
she was your big sister?
Yes, ma'am.
Okay. Would you like to talk to Judge Krug about how your life has been affected by the loss of your sister and brother-in-law?
Yes, ma'am.
Thank you.
Your Honor, I'd like to thank the court for allowing me to speak today. My name is Michael Burgoon. Jennifer Tower is my sister, and Rob Tower is my brother-in-law. For just over 2 years, I've had to try to process daily that my sister Jennifer and Rob are no longer here. Jennifer was much more than my sister. She was my #1 supporter and best friend. Growing up together, we would play video games, hang out on Venice Beach and Siesta Key, and often race go-karts at Pelican Pete's in Inglewood, or just simply hang out. As we grew older and moved on in life and got married, daily one of us would call the other or send a text just to say I love you. There wasn't anything I went through in life that I didn't reach out to her for her thoughts or her advice or how she thought I should handle it or what she may do if she was in my shoes. Even through my 20s to just over 2.5 years ago, I'd call her because I knew she would always answer the phone. And even if I didn't like what she would say, she would answer with honest and loving. I would also reach out to Rob daily. Rob was the very definition of what a brother-in-law is. We shared the same sense of humor. Jennifer would often get on us for acting like teenage boys. I would often call Rob just to get some advice from a guy's point of view, or if he had a question about the Bible. Rod had a very vast knowledge of it and would talk to me, or if I was struggling with something, he would often tell me a verse in the Bible that dealt with what I was going through and would help. Rob was the person who officiated my second wedding. There has been no greater hurt or pain in life than losing them. There isn't a second of the day that goes by that I don't think about them. Nobody should have to go through the hurt, emotional burden, grief, and just loss of direction in life that losing them has caused. They were the true north and the compass of my life. They were full of so much love, not only with me and their family. Jennifer loved our two older sisters, Lori and Lisa, and her mother, Cindy, and her son. Rob always spoke about the love for his parents and family and the love he had for his son. Our lives were much better because they were in ours. Sadly now, because of the events of October 31st, 2023, they were selfishly taken from our families. That void can never be filled, and for me personally, going through 2 counseling professionals still has not helped me out. Daily, I feel a pain and hurt that can't be described. I want to believe that they're just busy, and any second, my phone will ring and I'll hear that, "Hey, Michael, what's up, brother?" that Jennifer would so lovingly say, knowing full well that night, hearing that will never happen again. It's an emotional trauma that for the rest of my life, I'll have to work through and try to process with the help of counseling and family because it's not something that will go away. I hope and pray that today brings some closures for our families. Grief is a journey with no time limit. And Jennifer and Rob, I love you and will live daily to honor your memory. Thank you.
Thank you very much, sir. The state calls Rich Pollock. Good afternoon, Mr. Pollock.
Good afternoon.
Will you tell us your full name and spell your last name?
Richard Pollock, Pollock.
Will you tell Judge Krug how Robbie and Jennifer were part of your life?
Yes. I wrote a brief statement. At the beginning of this trial, we were told and we heard that the defendant say that this was all an act of rage. By saying so, he may feel that this helps to alleviate his responsibility in some way, but it doesn't. What he calls rage is nothing more than a pitiful attempt at an excuse to try to explain away the atrocities that he committed. This wasn't rage. This is all the result of a series of calculated decisions that he made that night. Robbie and Jennifer Tower, or as we affectionately called them, Rob and Jen Towerski, or Robbie and Miss Jen to our girls, had a huge impact, not only on mine and my family's lives, but countless people here and around the world that they ministered to and share the love and teachings of Christ with. Rob and Jen were show-up people. The people that showed up to help and weren't afraid to get dirty or put in the work to help a friend or anyone really. They were people who loved fully, and we loved them for it. It was Rob and Jen who showed up to teach my daughter Gigi to ride a bike. When I couldn't. It was Rob who showed up to put my Christmas lights up after I fell off the roof and Jen volunteered him to. The list goes on. They had a light in them that burned brightly for Christ, for each other, and for people. They were truly the people who would give you the shirt off their backs if you needed it and expected nothing in return, and not just their shirts. I remember them once giving one of their cars to a family that needed it. That's who they were. They offered the same gift to Dima, a gift of agape love. They gave, and he took and took. He was unwilling to receive it unless it was on his terms. He says he holds in such high esteem the way of life in Ukraine, and that the man should rule over his family with some sort of an iron fist, and that his wife must be subservient to him. But I would like to remind him in the court that the same way of life relegated him ending up in an orphanage where no one cared. As he put it, a nobody from nowhere. Rob and Jennifer chose to put Christ first and to love him above each other, but then to love each other above all and second only to that. They treated each other equally after only God and each other. They chose to love Dima and to bring him into their lives. They wanted to make him a somebody and gave him their name. I remember they were so excited. I remember how proud Rob was when Dima first became an American citizen. So many things that he did that he was so proud to be able to share that his son accomplished. But Dima didn't see it that way. If it wasn't his way and exactly the way he wanted or perceived it to be, he didn't want it or it was wrong. This wasn't just an issue that he had with Rob and Jen. He had problems with authority at school and rules. He couldn't handle it if another kid had got attention and took out his anger on those younger and smaller than he was. He's a coward. He showed it when he beat up on little kids, and he showed it the night that he made the choice to brutally murder Rob and Jen while they were asleep because he was too afraid to face them awake. He made a series of choices that night that changed the world for so many of us. There were multiple times that he could have stopped, but he made the choice to continue this brutality. He said he decided to kill them when he was sitting out in his car for no real reason. Even in his video statements, he said that they never hurt him. He simply didn't like them or had hatred in his heart. He could have made the choice to drive away that night, but he didn't. He went inside. He stated that he went in his room and drank and thought about it some more. He could have stopped then, but he didn't. He walked into the kitchen and picked up a knife. He still could have stopped, but he didn't. He continued into their bedroom. He stated they were asleep and it was dark. Again, he could have stopped and left, but he didn't. Instead, he brutally began stabbing my precious friend. The man who gave up everything for him, and the man that was like the older brother that I never had. In this struggle, he also stabbed Jennifer. These two people who loved each other so much, and him as well. Sometime during this attack, he lost the knife, and Jennifer was able to get out and try to get help. He could have stopped then, but he chose not to. Instead, he went in the kitchen and retrieved another knife to, in his words, finish what he started. He then made sure he had taken all the life out of poor Rob. Again, he could have stopped, but he chose to go out and find Jennifer. He then forced her back in the house where he forced her to listen to his rantings. Again, he could have stopped, but instead he chose brutality, again in his own words, to finish what he started. Now he truly gets to finish what he started. When he killed our precious friends and robbed this world of the love and light that they shared. For the rest of his life, he will be a nobody whose name means nothing. Instead, he will be assigned a number due to his own actions and be forced to suffer this alone, more than likely without any visitors. He killed the only two people in this world who would have been there for him. He has to live with that for the rest of his life, and I pray that one day he will accept that responsibility for his actions and repent and accept Christ into his heart. That's all.
Thank you very much.
Thank you, Mr. Pollock. Careful stepping down, okay?
Thank you.
Thank you. The state calls Talitha Pollock.
Do solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth.
Good afternoon, Ms. Pollock. Will you tell us your full name and spell your last name?
Talitha Pollock, Pollock.
Would you like to talk to Judge Krug?
Yes, please. I tried to write something too. Probably not as good at it as my husband.
Take your time. There's no rush.
When we first met Jen and Rob, we became fast friends. We met them serving at church, and the next thing you know, we were doing everything together. Our now grown daughters were young at the time and absolutely adored them. If you're a parent, you know that it's really important who you leave your kids with. And my husband and I take that very seriously. We don't let them do sleepovers or things like that at anybody's house. But we trusted the Towers, which is like putting them like at such a high level, you know, to trust them to keep our kids. So when my husband and I would go on mission trips to South America, we would leave our girls with them and they had a blast. They loved going to Robbie and Miss Jen's house. We, without hesitation, trusted them. They were amazing. And they were also amazing with any other kids they ever came in contact with. They served in church with like the kids ministry. They would really serve anywhere anybody asked them to because they never said no, and the kids loved them. Losing Jen and Rob has been a huge loss, not just for the families and the friends, but for countless individuals and also our community. They always had the best smiles, and they never said no to helping anyone in need, but they also never wanted any recognition. They did it because they just wanted to. I only know because I saw them in action countless times when they thought nobody was looking. We'd be doing a food drive at church. They didn't just bring in a handful of cans or something from their pantry. They'd go grocery shopping at Publix and bring in multiple bags. If they found out someone had a need, whether they knew them or not, that they could meet, they would jump right in and do it. When we first met them, they were young professionals and could go on luxury vacations if they wanted to, but instead they spent both their vacation time and all their resources on mission trips to Russia and the Ukraine. They had a love for the Ukrainian people. And so I was not completely surprised when Jen told me about Dima. She beamed. I can promise you that she could not have loved you more, Dima, than if she gave birth to you herself. She loved him so much. I have children that I have given birth to, and I have children that I've adopted. You love them the same, and Jen loved him just like she gave birth to him. She loved him unconditionally. You were a nobody from nowhere, but two amazing people from somewhere came to save you. What you did by repaying them, by cowardly killing them because you don't like rules, authority, or you can't handle consequences. You decided our country is a crap hole, in your own words, and you wanted to go back to the Ukraine. I think of all the kids in orphanages that would be grateful to be brought here and given the life that you were, but not you. You were only grateful when you were getting what you wanted. I think it's ironic now that hopefully he can spend the rest of his measly existence in a prison in the land that he hates so much. The truth is that he was used to picking on and beating up anyone smaller than him. He couldn't do that with Rob. Rob was bigger, but he wasn't violent at all. Rob could maybe hold him back. So he waited till they were asleep. And like a thief in the night, you snuck in and you started your evil rampage. My daughters miss Jen and Robbie so much. I miss Jen. I miss Rob too, but I miss Jen more than words. She had the most beautiful smile, the kindest heart, a great laugh. And one thing no purely evil thief in the night could steal are all the memories that they gave us. And that's all.
Thank you, Ms. Tower.
Thank you.
Thank you. The state calls Lisa Huff. Ms. Huff, before you start speaking to the judge, would you just identify yourself for the record? Tell us your full name and last name and spell your last name.
My name is Lisa Huff. My last name is Huff.
Thank you. And will you tell us how you know Jennifer and Robbie Tower, please?
Jennifer is my youngest sister. Robbie is my brother-in-law.
Thank you very much.
Thank you.
Oh, Lord have mercy.
Take me a minute. Okay. I had to type mine out just today, so I'm just going to go ahead and read it. Your Honor, thank you for allowing me to speak today. I can't begin to express the depth of loss and pain that this tragedy has brought to our family and all who knew and loved Rob and Jennifer. They were two of the most wonderful people you could ever meet. My sister Jennifer was the most loving, caring, and compassionate person. Even when she was struggling, she had a wonderful sense of humor and a strong faith and belief in God. I was blessed to have her as my youngest sister and thankful for all the good memories we shared together. Rob was also an awesome person and was always willing to lend a helping hand. He was also a fun-loving guy and had a great sense of humor. Rob and Jennifer did all they could to help Dima have a better life. No, they were not perfect, but no one is. There was absolutely nothing they did to deserve being brutally murdered and so carelessly and senselessly ripped out of the lives of my family and everyone else who knew and loved Rob and Jennifer. I will never understand or comprehend what drove Dima to commit such a heinous act against two of the people who gave him or gave so much of themselves and did all within their power to give him a better life. I guess evil simply cannot be understood. As a Christian, I know that the Bible commands me to forgive Dima. That is something I will have to fully rely on God's help and strength to do. I can't do it on my own. Dima has shown no remorse for his actions, and it has been said that he may not have the capacity to do so. Though some may not understand, I pray that Dima will one day feel the weight and guilt of what he has done and ask for God's forgiveness. By saying this, by no means am I stating that Dima should not be held accountable and pay for his actions. He definitely should be. His horrible actions against Rob and Jennifer demand justice. However, as Rob and Jennifer were also Christians, I believe that this is what they would want for Dima, even though he did what he did to them. Though some may not agree with me or understand, as a Christian, I believe that even in horrific tragedies such as these, that God would want something good to come out of them. It is my firm belief that Rob and Jennifer would want Dima to ask for forgiveness and join them in heaven one day. Although it seems impossible in our eyes as human beings, I pray and have faith that this can happen. Although I am still angry and sad for what has happened, it is my belief that God died for all sins, including the ones committed by Dima on that terrible day in August of 2023. Dima is my nephew, and though mine and my family's lives will never be the same, part of me still cares for him. I pray he will make the right decision and ask God for forgiveness for what he has done. Once again, I believe this is what Rob and Jennifer would have wanted for Dima. Thank you again for giving me the chance to speak, Your Honor. Thank you.
Thank you. Your Honor, I'm going to read a statement from Jennifer's other sister, Lori Ely, who's here present in the courtroom. And then we have one final statement from Debbie Tower. So this is the statement from Ms. Ely, and it reads as follows. Her name is Lori, last name Ely. Your Honor, thank you for allowing me to speak on behalf of my sister, Jennifer, her husband, Rob, and our grieving family. No words can fully capture the depth of loss and devastation that this crime has caused us. Jen and Rob were two of the most generous, hopeful, and loving people I have ever known. Their greatest dream was to build a family. After years of struggling to have children, they made the selfless decision to adopt. Their Christian missionary work in Ukraine inspired them to open their hearts to a child in need, and they welcomed their son Dima into their home with love. Adoption was not easy. It was emotionally, financially, and spiritually very demanding. They emptied their savings, they took loans, and they relied on the kindness of others to make their dream of parenthood possible. Despite every challenge, they remained deeply committed to giving Dima a stable, nurturing home and every opportunity to thrive. I have never seen my sister as happy as she was when Dima arrived. She was radiant, excited, fulfilled, and hopeful about motherhood. Rob shared her joy, and together they dedicated themselves to building a loving family. They celebrated milestones, faced setbacks, and consistently placed Dima's welfare and well-being above their own. Their commitment to him never wavered. Their journey, however, was extraordinarily difficult. They worked tirelessly to support Dima through anger, defiance, and destructive behavior. They sought help for him, guidance, and healing. They endured emotional and physical harm while trying to help him overcome his struggles. Even in the face of rejection and escalating violence by Dima, they continued to try because they were driven by love, faith, and the belief that every child deserves a chance. Despite their extraordinary efforts, Jen and Rob's lives were taken from them in a violent, senseless manner. The pain of losing them is indescribable. Their deaths shattered our family and left a void that can never be filled. My sister's warmth, kindness, and optimism are gone. Rob's humor, steadiness, and generosity are now only memories. We never had the chance to say goodbye. What I wouldn't give for one more conversation, one more holiday together, or just one more hug. Every day I'm confronted by reminders of what was stolen from us. I lost two of my closest friends. My faith in the goodness of people has been shaken. I now live with symptoms of PTSD. I return to work while simultaneously navigating the unimaginable task of settling my sister's estate, repeatedly explaining their deaths to banks, to creditors, mailing their death certificates, and reliving the trauma each time I read their names on those documents. I had to walk through their home and sort through the pieces of their lives. I found my sister's wedding dress. I found hundreds of photos of their lives together and two people deeply in love. Those moments broke me. The grief is relentless. I will never be the same person I was before, and no therapy or counseling will ever fully mend what has been taken. Jen and Rob's deaths touched more than just our family. Their community lost two people defined by selflessness and generosity. They opened their home and their hearts not only to Dima, but to many others. As Christians, they lived their faith through quiet acts of love and compassion. Their reward for this kind of selflessness was a brutal death at the hands of the child they devoted their lives to. I can't escape the tormenting thoughts of their final moments. How frightened and betrayed they must have felt. Our family is left to carry the weight of this tragedy every day, emotionally, mentally, and spiritually. Holidays, family gatherings, and even small joys are marked by their absence. Your Honor, as you consider sentencing, I ask that you remember who Jennifer and Rob were. Decent, selfless people who dedicated themselves to giving a vulnerable child a better life. They believed in second chances and in the power of love. Their lives were taken in a horrific way, and the hole left in our hearts will never be filled. Since their deaths, I have tried to understand how Dima could have committed such a crime. I am not an expert, but I have learned about psychopathy and antisocial personality disorder. I do not know whether he was born this way or shaped by trauma. In many ways, the situation is a tragedy for everyone, including him. I believe my sister would have forgiven him. But forgiveness does not erase danger. From what I have come to understand about psychopathy, it cannot be cured. If Dima were ever released, I firmly believe that he is a risk to society and that he would harm or kill again. While compassion and faith may allow us to pity his past, society also has a responsibility to protect others from someone like him who demonstrates violence, lacks empathy, and cannot regulate dangerous impulses. For the safety of the public and in honor of Jennifer and Rob, I ask that you impose a sentence that ensures no other family will face the pain we endure every day. Thank you, Your Honor.
Where is Laura? And well said.
Finally, the state would call Debbie Tower, please.
Do you solemnly swear or affirm the testimony you're about to give will be the truth, the truth, and nothing but the truth?
Hello, Ms. Tower. Can you tell us your full name and spell your last name?
Debbie Tower, Tower.
Would you like some water?
No, I'm okay. I'm okay. Robbie was my son. Robbie was my son. And Jennifer was my daughter-in-law. And I can't, what he took away from us is beyond what you can imagine, because Robbie was my friend, my son. He thought he was the father of my other two kids. He helped raise them. And then when my daughter died, we were left with two little boys, and he helped raise them. He acted like their father, and he did everything with them, and he took them places, and he took care of them. And he could not have ever been a better father than he was to my boys, his nieces, his nephews, and him. He spoiled him. He did everything that he could. And Jennifer, the two of them did everything to make him happy. And every time something would happen, they would fix it. And I just want people to know that he wasn't neither one of them were a bad parent. They were excellent. They couldn't do enough to take care of our children. Now my boys want to know, where's Robbie? And I can't explain it to them because they don't understand heaven. And I'm sorry, this is so hard. I just wanted people to know that they both were good. They were good to him. He can't say things that aren't true. And he really was good to everybody. And I miss him so much. I'm so sorry. I just want people to know how good they were. I brought them with me so they could see what we're doing for them. He destroyed so many people. I just don't know how he can live with himself. You're gonna have to think about this for the rest of your life, what you did. You didn't just murder Robbie and Jen, you murdered all of us. That's all I can say. I can't say any more.
Thank you, Ms. Tower. Be careful getting down.
There are no further statements, Your Honor. Thank you.
Okay. Can we put up, do we have a second podium in here? You don't need to plug it in, but can you bring one in? Mr. Gilman, do you have anybody that wishes to speak from the defense?
The defendant would like to address the court, Your Honor.
Okay.
Oh!
Does he want to take the witness stand and speak?
I don't mind.
Okay, wait, I'm sorry?
I don't mind taking the witness stand.
Okay. Let me just make sure you understand. I'm not going to allow any disparaging comments related to Robbie and Jennifer Tower. Do you understand that?
What do you mean?
I don't want a single negative comment or disparaging, meaningful, harmful contact.
There will be no such words.
Okay.
There'll be only the story.
Mr. Gilman, have you spoken to him at all about what he wishes to say?
No, Your Honor.
Okay. Can you please explain to him what I just ordered? I will not permit Robbie and Jennifer to be disparaged in any way in this courtroom.
I understood what you said. I will only tell our story. I will be rational. I will be making sense. I'm not gonna be speaking meaningless words that have no reason to say.
This is an opportunity for you to show remorse, if you have any, to apologize if you wish to, and it's sincere, and to express your gratitude for the opportunity that Robbie and Jennifer gave you, if you wish, to apologize to the family and the community for which you tore apart and destroyed. This is that opportunity. Do you understand that, Mr. Tower?
I understand.
And the opportunity is limited to that. Do you understand?
I understand.
Okay. All right, let's have the defendant take the witness stand, please. You want to assist?
I'll do what I can. Can you please just state your name for the court reporter?
Dima James Tower.
And given what the court has talked to you about, what is it that you want Judge Crew to know prior to imposing a sentence?
What I have to say is our feelings block out our intellect, so I must ignore the irrational testimonies I heard about the life that I had with adopted parents of mine, and prior to that, I must only speak the truth. However, I've been told that I have limited time, and there's much to say that I expect these adults to understand me talking to them as adults to adults. I had 2 years and 2 months of dwelling on this. And the conclusion I have come to is not only that everything evolves around God, that we must understand that we live in an unmanly world. And what this means is,
Mr. Tower, I'm not concerned about what world you believe in. Do you wish to offer an apology and remorse to the victims?
yes, I am. I'm getting to that. Yes.
All right, cut right to it. I don't want to hear what world you think you live in.
Well, I'm gonna cut right to it.
Thank you.
The remorse that I have for my adopted parents is, it might be unshown. That doesn't mean it's not felt. Because when I committed these acts of crime, I lost my mind, and somebody might think that I knew what I was doing. I did not know what I was doing. It was.
Tower, do you wish to offer an apology?
I am on offer an apology. I'm explaining an apology. I'm explaining an apology. I'm in the middle of apology. Apology is that the truth is that there are a lot of fatherless children out there, and my apology in this is that nobody want to be held accountable for their actions, and I'm being held accountable for the actions of grown men. So my apology is that I have to be responsible for what Oscar did to his children and what Phil did to his children. And how can I apologize for the mistreatment that Oscar, as a stepfather.
All right, I'm going to have the defendant removed from the stand. He's choosing not to give an apology. I'm sorry to the family in the courtroom. I wanted to give an opportunity for you to hear from the defendant, to perhaps hear an apology and remorse. I think that is not forthcoming, as we all saw. Mr. Gilman, anything else from the defense?
Nothing.
Okay, let's hear from the state what you're seeking and want.
Thank you, Robert. As to count one, The state is seeking the statutorily mandated sentence of life in prison without the possibility of parole. As to count 2, the state is seeking a consecutive mandatorily, well, that's not mandatory, consecutive life without parole sentence for the death of Jennifer Tower, as well as the death of Robbie Tower. And as to count 3, 5 years in the Department of Corrections, concurrent with count 2. Thank you.
Mr. Gilman?
Did not go for GP,
Anything
but
you wanted to add?
go get it.
I don't disagree with the state that the sentence is statutorily mandated. I would just ask that the court to impose the sentences on counts 1 and 2 concurrent rather than consecutive.
All right, thank you, councilors. You can be seated. All right, to the family, I know law enforcement is here who worked hard on this case. I want to thank you for your courtesy throughout the trial. I know it can be very hard to sit in a long trial where you have loved ones that were viciously and brutally murdered, as your loved ones were in this case. You respected the process, you respected the role of the judge, the jury, the witnesses, and you allowed for the trial to go through properly, efficiently, lawfully, which is our roles in the judicial system. You know, we serve a function and we need to make sure that happens. And so I appreciate your role in that. As the judge, I don't know the folks that are murdered or injured in cases. You realize I come into the story much later at a trial often or at a sentencing hearing. I can tell you that the role of a judge is very difficult sentencing most days. I anguish over sentencing decisions I have to make. I do it on a daily basis, 5 days a week, handling all types of different cases and have to make decisions as to whether someone goes to jail or not, or goes to prison or not. If so, how long? And I think you can imagine in many cases, most cases, that can be difficult. You see the human compassion in people, and you see mistakes can be made. Today, obviously, is not one of those days for me. Sentencing today is very easy, and I think it was Miss Lisa Huff, or actually, no, it might have been Laura Ely, I'm not sure, maybe both, who had a great insight in their statements that there's a role that the court has, and that is to punish and also to provide for the safety of the community. What I enjoyed this afternoon was, even though it was brief, learning about the terrific lives that this, I'm going to call them Robbie and Jennifer, lived. They seemed, and many of you used these words, that they were selfless. Some of you said that they gave the shirt off their back for others. They ministered to children and others, going as far as Ukraine and Russia to help those in need in South America. They were babysitters. They were a happy husband and wife. They were children to the parents we heard from, brothers, aunts, uncles. They just really seemed like terrific people. And it is a shame that in this great country that we live in, that we lost 2 shining stars. I hope that, and one of you mentioned this, that they live on in your hearts, in your memory. And I hope you realize that. I know you do. The grief, the anger will continue for time. But I hope you cherish, and I know you will, those memories, and lean on each other and the love and support of your family, and celebrate what seems to be amazing lives of 2 great people. And they can be beacons for how you teach your children and how you continue to move on. Mr. Tower, I don't know what else to say. You seem to be an evil spirit, an evil person.
Evil spirit because you're talking foolish.
who doesn't seem to have any.
I'm full of remorse. I'm not showing it because
I will at this time,
Professor.
Mr. Tower, sentence you as to count 1. This is for first-degree murder of, count 1 was Robbie, is that right?
Yes.
Of Robbie Tower. I will sentence you to life in prison. You will serve the rest of your life in prison without the possibility of parole. Count 2, and often I do run them concurrent. I know that the defense requested that. We have a unique and clearly a special life in Jennifer Tower as well. I spoke about that earlier. I'm going to adjudicate you guilty of count 2, first-degree premeditated murder on Jennifer Tower. I will run this sentence consecutive to count 1. I will sentence you, Mr. Tower, to life in prison without the possibility of parole. Count 3, the fleeing or attempting to elude law enforcement with lights and sirens. I'll adjudicate you guilty. Let's see, this is what degree felony? State third. Sentence you to the maximum of 5 years in prison to run concurrent with count 2. I will order that you have no contact whatsoever with Robbie and Jennifer's family, aunts, uncles, cousins, nephews, parents, siblings. I will order restitution and reserve as to the amount. I'll order as a civil judgment against you court costs, prosecutor fee, and public defender fee of $100 each. Are there any other statutory terms that I'm leaving out, State?
No, Your Honor, but I do have a score sheet for count 3, which is the only count that requires a score sheet.
Mr. Gilman, anything I left out?
No, Your Honor.
All right, Mr. Tower, you have 30 days to appeal the judgment and sentence of this court. If you cannot afford an attorney for that appeal, one will be appointed to represent you.
what about the truth?
Good luck to everyone. Court will be adjourned.
Okay. Here's the fingerprint process. Don't we just love watching them getting fingerprinted? I'm surprised they did not go for DP. They could have gone for DP on this case. Surprised they did not. But is what it is. The family now can try to move forward. There's no true closure, to be honest with you. You just try to move forward. And I really like this judge. I may put him up for the Judge of the Year award. We do have that in Discord. Go to my Discord. We have a Judge of the Year award. We will be voting on in December, and the judge will receive a certificate from us as the YouTube Judge of the Year for this particular channel, that is. What a heartbreak. What a heartbreak. Give me a second to lock in this stitch. And then we're going to switch to another trial. With that, rest in peace, you two. May the Lord bless and keep them, their families. Heartbreaking. And I'm hot flashing. Let me look at your comments. Hey, Sunshine Twins. Thank you. XO Nicole. Thank you. Just Fan 1. Thank you, guys. I didn't want to interrupt. I want to welcome all of you in. Thank you, thank you, thank you so much for hopping in. We appreciate you. I'm looking at the comments. I'm looking at comments real quick. Hello to all the new people. Yeah, he'll definitely be in solitary confinement for a while in prison. Me too, Josephine. See you next week. What's next week? Welcome to all the new people. The Cat Hid 71. Thank you so much, Miss Just Fran 1. Sorry, I need new glasses and I'm struggling. Hello, thank you guys for joining in. We appreciate.
Are on the record in the Adair County case of competent.
To the new teachers, to the new people. Thank you, thank you, thank you. No, it is not easy dealing with adoptions, and I'm sure there was heated moments. Nobody is perfect, but that said, it is a horrible situation for all involved. And my heart goes out to them. For those of you who don't know me, hi, I'm Ada K. Welcome so much to the channel. I am your deaf courtroom commentator. I'm graduating college and I'm beating my graduation hat. This is what I needed to do for my mental health on this case. It was a little bit difficult for me in some areas. So I had to do that for my mental health, but I really appreciate everybody here. You can say with the experience of adopting a child, issues are very challenging. It is, but thank you so much for what you have done. It is amazing. Adoptive people, your hearts are pure, and I thank you for that. Now, we're going to move on to another case. This is one where the woman unalives the father of her 2 daughters and decapitates him and gets rid of the head never to be found again. This is also, this woman is an ex-corn star, and she was married to Mr. Baker, who was found guilty in red rooming Monica Simitili's husband. She was found guilty as well. So there is a very interesting love triangle in this particular case. Don't go anywhere. Let's dive in. First witness of the day. By the way, this judge talks about like this fest, everything she says about this fest and everything but event. So if you need captioning, a captioning is available.
Brooke, have any follow-up based on the jury question?
Of course, indulgence.
Okay.
Oh, Angela, I am proud of all of you. So proud of all of you. Oh my gosh, that does my heart good. Does my heart good. Yep.
My question at 2:04 when the Armada leaves Paladerma or Paladura, it goes to the pharmacy, correct? That's what you reviewed?
Yes, that is correct.
And then it goes straight home.
Yes,
That's it.
that is correct.
No other stops.
Not that I saw stood up now.
No further questions.
State any further questions based on the jury question?
Just briefly, you'd agree with me that the Nissan Verla data is specific to the car, correct?
Yes, that is correct.
Nothing about that or the phones is going to show whether the defendant got out of her car with a basket, with a head in it, walked over to the neighbor's house and dumped it in the trash, correct?
Potentially, Barilla could pull information about weight distribution and like, you know, how if you're in your car and it says, hey, there's something in the back seat, make sure to check it. Potentially that could be there. I didn't see any, only information I got was location data.
So human head weighs about 8 to 10 pounds, we agree?
Sure.
If a doctor testified to that, we can agree.
Sure.
Are you saying that the Burla would show an 8-pound differential? Or
Not really sure. I mean, it's dependent on the car. So I don't know what the setting is on the car, but it's possible.
so you have nothing to suggest that the defendant's car stopped anywhere else?
That's correct.
We've already talked
CVS and then.
Yeah. And she can, whatever she did after she got out of the car, you have no evidence of that.
That's correct.
Thank you. Pass it.
Just real quick, in cars, seatbelts, some in the newer cars, this car looks like it's a newer car. Sometimes when someone is less weight,
it says buckle the seatbelt, or they shouldn't be there. You've seen those mornings, right?
That's correct.
Do we know if this car had this?
I don't know. I was not
Didn't have
provided
the
that
full-
information.
And then just like the car, if you don't have your cell phone on it, you can't track that person if it's that person's phone, if they're supposed to have it on them.
Say one more time, please.
You can't track a person by their phone if they don't have their phone on them.
That's correct.
No further questions.
Any follow-up statements? No, thank you. Do the ladies and gentlemen, do you have any further questions for this witness? Okay, seeing no response, we'll go to you. Thank you very much for your testimony here today.
Thank you, ma'am.
All right, ladies and gentlemen, we are going to take one brief recess for the morning. During this recess, you must not discuss or communicate with anyone, including fellow jurors, in anything regarding this case or its matter, either by voice, phone, email, text, internet, or other means of communication or social media. You must not read, watch, listen, use, or media accounts and content about this case. You must not do any research, such as consulting dictionaries, using the internet, or using references. You must not make any investigation, test the theory of the case, recreate any aspect of the case, or in any other way investigate or learn about the case on your own.
I don't know why they went into a recess, y'all. Are you kidding me? You were live all of 5 minutes, not even, and you were already in recess. What is going on in this courtroom, y'all? I got to count these beats. 5, 5, 5, and 4. I'd use, let me. Sorry about that, guys. Yeah, this is very interesting. Why are we already on a court break when you just started 5 minutes ago, boo? This court is driving me a little crazy. It has not been fun with this court. Yes, I'm getting ready to go there. Right now, we also, let me get it up, y'all. Got to see through microphones. Woohoo. There it is. We also have a bingo card. On that bingo card, accredited DNA lab evidence, familiar DNA sideboard, DUI, DWI, Allison Freeman interview video, smells, fire department body cam, Scottsdale, Arizona bloody crime scene. May I approach photo, Scottsdale Police Department, strangulation or strangulate, objection to the jury, outside jury's presence, pass the witness, search warrants, exhibits, any juror's question, cleaning supplies, and swab stick. Those are everything on the bingo card. It's so simple. It's linked up above. Go up top to the top of the links. It's pinned. Just click on the link. It pops up this card here. If you want to get a different card, you come down here. Please receive a random new card. I click right there. Hit OK, and I get a random new card. There are 30 to choose from. And if it is said in court, or I say it during the trial in and of itself, not my recaps or you don't do any of that. Only while trial is happening. So that's our bingo card. Please join us at the end of every trial. Holy crap, that was loud. Thank God the needle wasn't in my hand. Wrong card. Oh, you're right. Well, that's what's pinned at the top. Let me go get the right card. Give me a second. That's fine. Is it under bingo cards, boo? June, love you, but that nearly blew my hearing aids. Going to bingo cards. Okay, never mind. Why is it? Okay, June, I need you to look at this. Is this the correct one, boo? Let me get it up. My apologies. Is that the right one? I think so. Pass a witness objection. Motion to dismiss. Overrule sustained. For the record, jury instruction hearing. Fair say outside the jury presence. Sidebar. Description of a person. Yes or no. I do not remember. Defendant. Interview. Jury questionnaire. Beg the court's indulgence. Defense rest correct or right. Where is the head? Article of clothing. No witness. Follow-up questions. Memory loss. No objection. End state rest. Thank you so much for that. I apologize. Whew, that whistle was loud. Yeah, my apologies. I clicked on it. I must have accidentally clicked off of it. So thank you so very, very much. looks like they're getting ready to come into court any minute now. You can see the camera doing a little wiggle, wiggle, dance, dance. Wow, wow. Yes, I'm in a weird mood. I didn't go to sleep till 2 a.m., but at least I did get a full, I got a full 5 hours sleep. Whew. Wow. I mean, I would love to do 8, but I'll take a good strong 5. I'd rather do a good strong 5 than a intermittent 8. So, and I got coffee on board. I'm taking my second cup of coffee. So yeah, we're good to go, y'all. Thank God we're not going to be doing trial until 8 p.m. tonight, 9 p.m. tonight. So I was wondering, should we do a movie night, Miss June? What are your thoughts, beloved? Should we or should we not do a movie night tonight? They're going to be in for 5 and then be going. Yeah. This court has a lot of breaks. I don't understand why, but they do. That was an interesting little thing. I think we spend more time waiting on court than court is actually in session. Thanksgiving is coming up. I know everybody has plans. What are your plans? I want to have a Thanksgiving recipe competition. We have a recipe section in our Discord. And what I'd love for you to do is to please put in your favorite recipes. When you do that after Thanksgiving, for those of us who attempt or try these recipes, which I will be doing most of them probably, depending on what it is, we're going to have a vote on the best recipe. And then that person will win something. I don't know. I'll figure it out. But I would love to do a recipe competition. Now, when I say recipe competition, I don't mean you just go and Google the fanciest recipe. I would prefer it to be something that is something of a tradition for you in your home, something that is not necessarily normal for everybody. Like, don't copy and paste the typical green bean casserole. You have a favorite bread recipe, you have a favorite side dish recipe that is not of your norm. That would be fabulous if you guys could potentially put that in. That would be great. We'd appreciate it. So go to our Discord. Let me put I got to put the Discord thing up. I love the new QR code. Where's my Discord? There you go. There's my Discord. You may go to my Discord at any time. I'm doing the corners on this beaded hat, which are not easy to do. I don't like doing corners. Corners are hard. And they never perfectly line up like they're supposed to, but that's okay. I get them close and then I fudge them. Like, that's a corner. It looks great on both sides, but it was a lot of finagling. I also do make these for people. So if you have a child graduating and you want to do something cool for them, I do bead graduation. I got to mute. Can't do it. That physically is hurting my ears. No, I don't hear it. For those of you who don't know, I am deaf without my hearing aids. I have the biggest, baddest hearing aids in the market. That makes me be able to somewhat hear. But in reality, I go by mostly feeling and reading. I read everything. I have closed captioning up on every single monitor, and then I have one down here on my phone so I can follow along when I look down. That way I don't lose Okay, here we go. I had to do that because there was some craziness going on in court and I needed to get that. It was y'all, it was shaking camera, loud, it was obnoxious. Very obnoxious. I spared y'all. I spared you. I just spare you.
You solemnly swear or affirm the testimony about to give in this action to be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Thank you. Please be seated. Please state and spell your name for the record, please.
My first name is Larry, spelled L-A-R-Y. My last name is Sims, spelled S-I-M-M-S.
Thank you. Dr. Sims, if you could tell us a bit about yourself, beginning with your education.
Well, I graduated from high school in 1970. I graduated from college in 1974. I went to medical school at Oklahoma State University and graduated from there in 1978. I did a rotating internship as a physician in Dallas from 78 to 79. And I was a general practitioner for 10 years, 3 years in rural America and 7 years in Detroit. I had about 55,000 patient contacts, delivered about 100 babies. Then I went back into training at Michigan State University in pathology for 4 years. Then I did a 1 year forensic fellowship at Cook County Medical Examiner's Office in Chicago. Stayed on there for some years, and then I came out here and was at the Clark County Coroner's Office for 19 and a half years. I maintain a licensed medical license in Nevada, and I'm board certified in anatomic pathology, clinical pathology, and forensic pathology.
He's smart.
Doctor, so you were a coroner here in Clark County?
Yes.
19 and a half years?
Yes.
Would often be called by the state of Nevada in prosecutions of murder cases?
Oh yeah, I would. I probably testified over 500 times during that period of time.
You were contacted and were ultimately retained by the defense in this case, the state of Nevada versus Devin Michaels, correct?
Correct. Yeah, I was contacted by the Special Public Defender's Office. It's been over a year ago.
Okay, and just for the record's clean, I mean, I'm not part of the Special Defender's Office, nor is Mr. Horvath, but that was who was initially on this case.
That's who initially contacted me.
After being contacted, were you provided with certain materials, specifically an autopsy report and other things of evidentiary concern, photos and the like?
Yes.
To your knowledge, was it the entire file?
Well, what I was provided, which is all the forensic important stuff, yes.
Have you had an opportunity to review the autopsy report prepared by a Dr. Stephanie Yagi?
Yes.
And that autopsy report is dated August 8th of 2023.
Correct.
Did you review the pathologic findings in the autopsy report?
Yes.
And what are they?
Well, okay, have you got a copy of the autopsy report? I can go.
Absolutely. May I approach with the copy? State any objection? Not at all.
So the main two findings is she classified the death as homicidal violence, and then she noted that he had a fatty liver.
And those were the two findings.
Correct.
Now, are there certain standards of practice that are employed by pathologists, specifically coroners?
Yes.
And what are those? And if you could please describe those to the jury.
Well, there's a number of practice standards, but there's a specific published practice standard in relation to using homicidal violence without any specific cause. It was published in 2010, and it has 5 separate criteria that all 5 have to be present before you use a non-specific cause of death, such as homicide by unspecified means or homicidal violence.
And doctor, what are those 5 criteria? And if we could just have you break them down, please.
Well, the one of the important ones is that there can't be any other cause of death present. In other words, there can't be any natural disease present. There can't be any toxicologic explanation of death. There can't be any environmental explanation of death, such as drowning or cold. And there has to be an indication that the body was altered in some way. And there's one other criteria. I can look at the paper. I can't remember what it is.
Okay, if I may approach the witness.
And then a specific cause of death can't be brought out of the whole entire data set, which means all the findings that are available.
So from the get-go, we have this pathological examination done, and we have these pathological findings. The first being homicidal violence. And you had discussed these 5 criteria. Let's focus on 2 of them, specifically no atomic cause of death. How is that a concern, and how did this examination and this opinion not follow the standard practice?
Oh, well, there are, in this particular case, that he actually has 2 natural diseases that could cause his death. His heart was enlarged, and he had a fatty liver.
And those are obviously borne out through Dr. Yagi's analysis and review of the body, correct?
Correct.
There's another criteria I'd like to draw your attention to, and that's no toxicologic cause of death. If you could please explain that and the significance in this exam.
Well, there has to be drugs can be present, but they have to be at low enough levels not to cause the death. Is kind of the main thing to take away from that. Or there can be drugs present that are not known to cause death, like a medicinal type of drug.
So in this case and on this examination, there was a toxicology report, correct?
Correct.
And what were the findings of this toxicology report?
Well, the main findings, he had a low level of alcohol below the legal limit for driving. His marijuana level was substantially above the legal limit for driving. And he had quite a bit of alcohol in his stomach, but not really very much in his blood, which indicates just that he had drank a significant amount of alcohol just prior to his death before he died.
Let's break that down just a little bit, and let's start with the alcohol where you just left off, doctor. Are there different places where these draws are taken in order to arrive at the alcohol content of the body?
Correct. It's very important to, without going into a lot of explanations, to take the blood from a certain region, because that region is more characteristic of the level of whatever drug prior to death. If you take it some other regions, it could actually be higher or lower.
So in this case, was there both a blood draw and from the stomach?
Yes, they did both of those.
If you could please explain those processes and the findings to the jury.
The blood was taken appropriately, and so I have good confidence in the alcohol level of the blood and the. Have you got a toxicology report, just so?
Yes.
I'll make sure I don't say anything wrong.
I believe, oh, absolutely, doctor, I believe it's attached
Part
to
of this?
the back of the report.
So the alcohol and marijuana was done on peripheral blood, which is the appropriate thing. They also took urine and gastric fluid And they did take heart blood, and they did measure the gamma, the GHB level in the heart blood rather than the peripheral blood, which is not a good thing to do. It should have been done on the peripheral blood. Those are the main things.
And focusing in on the alcohol content, you had testified that in the blood, it was not particularly high, correct?
Correct.
But then you made reference to the alcohol in the stomach. If you could please explain the significance of that. Did that denote recent drinking, heavy drinking? What would that indicate?
Yeah, so it was about 30 times higher in the stomach fluid than in the blood. So he had drank, a couple of, some significant alcohol that had not been absorbed yet into his blood.
Now, if the THC content, it was significantly above the legal limit, correct?
Correct. Yeah, the legal limit is 2 and his was 26.
So over 10 times the legal limit.
Correct.
Breaking news. A gentleman died of a fatty liver. Then his head fell off and disappeared. Who did it?
Sorry, couldn't help it. Oh, that is so funny. Wait, he had fatty liver. He died from fatty liver and his head fell off and disappeared? Dude, 90% of Americans have fatty liver.
THC. So if an individual were to have ingested alcohol, as we have evidence of, and smoked marijuana, could you opine, was that person intoxicated?
Oh, definitely, yes.
If we had heard testimony that this person had gone to sleep or shouldn't be driving, a family member was concerned about him driving, would that be consistent with the findings of this pathological report?
Yes.
In reference to the GHB and the drawing from the heart, you had said that was of concern. If you could please explain why.
Well, because heart blood is notorious for being inaccurate as far as a true level of the antemortem
We're at the medical examiner.
prior to death level. I'm not saying it's completely inaccurate, but it would be better to do that on the peripheral blood, which is what the other toxicology was done on, than the heart blood. But even given that, the DHB level wasn't into any significant toxic range.
Turning your attention back to the findings concerning cause of death, manner of death, and specifically the standards of a practice, these 5 criteria. Is it fair to say that homicidal violence is an incorrect designation?
Yes.
What should it have been?
The practice standards are clear about this. If those 5 criteria aren't met, then you classify the death as undetermined.
As we've covered cause of death, manner of death, it states homicide. Is that incorrect?
Correct. Yes, it's not correct. No.
What should it have been?
It should also be undetermined.
So based upon the science, the examination of the body, fair to say that this was an inaccurate pathological conclusion, homicidal violence.
Yes.
Finally, I'd like to address, there's an issue concerning obviously a missing head. Fair to say that that complicates matters.
Oh, definitely.
And how so?
Well, if you have incomplete remains, it's very risky to make conclusions about something that you haven't examined. You don't really know. Worst case scenario is the head turns up and there's no cause of death with that either. So in this particular situation, that would preclude you from scientifically, objectively assigning a cause or manner of death.
Now, obviously, one of the criteria concerns death under suspicious circumstances.
Correct.
And I don't know if you have had an opportunity to review the file because we haven't discussed it all that much, but obviously we have some fairly suspicious circumstances surrounding this death, correct? And is it fair to say that Dr. Yagi perhaps relied upon that outside the practice standards, but relied upon that in finding a cause of death and a manner of death?
Probably so.
Okay. I mean, we're humans. We make mistakes, fair to say.
Definitely, sure.
In a strictly scientific sense, okay, doctor, and based upon the data, the empirical data, is it possible that this gentleman died of natural causes?
It's definitely possible. That's why you would classify it as undetermined. Before you come to a conclusion, especially one of homicide, which is going to have significant effects, you want to base it on provability. You want to be able to prove it. And in this particular situation, he actually had, in the body that was examined, he actually had causes of death that could cause his death. And the fact that the head is gone precludes you from making a scientific determination.
And again, we've discussed somewhat in this jury's heard for a week and a half, perhaps suspicious circumstances, but from merely the science, he could have died.
Correct.
Natural death.
Correct. As a forensic pathologist, that's the role that we're talking about. That's the role I play. You have to base your conclusions on objective evidence, not just suspicion.
Finally, in reference to the decapitation, you obviously reviewed the photos, you reviewed the examination of the body. It was clear that this body was decapitated.
Correct.
Any opinion was it post-mortem? Does he indicate that this happened after death?
Definitely. It was examined by an anthropologist or an anthropology team, I guess it was. And they concluded that it was a post-mortem decapitation, which I don't disagree with.
Based upon the circumstances, you reviewed the evidence, fair to say it probably happened close in time of death and decapitation.
That's an excellent question. It might be very, very difficult to say that. There's no doubt that the blood was still liquid, but that would be liquid for a number of hours. So it's more likely that it was, but as far as being able to objectively prove it, you'd have to do a substantial number of kind of uncommon tests to do that.
And in reviewing Dr. Yagi's report, in fact, she enlisted an anthropologist to do further analysis on C2 and C3, correct? The findings of that anthropologist was that the head was severed using two instruments, correct?
Correct.
A handheld knife and a mechanical powered saw.
Correct.
Do you take issue with those findings?
Yeah. Well, after reviewing all the pictures and looking at them, there was an area in the skin that had in my experience, the characteristics of a chainsaw. But it was only in an area of the skin, which that would be enough for me to be concerned that was part of what was used.
A chainsaw.
Correct.
What do you think a chainsaw is? It is a powered saw. It's got electricity. It's not a handsaw. Chainsaw is a powered saw.
So while we have the anthropological findings on the bone, did you view any follow-up evaluation or analysis on the skin that you're referring to?
No.
In reference to this idea concerning the cause, the undetermined cause of death, and we have a post-mortem decapitation and the time of death, we agreed that it's fairly close in time. You'd made reference to the blood, and there's been several questions last week asked concerning witnesses and this idea of cast off. Would you anticipate there having been cast off given the evidence that you reviewed?
Oh, especially if there was a motorized weapon used. Yeah, you would expect substantial cast off also on the people or the person that did it.
So would you expect, based upon your evaluation of the evidence, for that person to be covered with blood?
Well, there would be a lot of blood splatter. Yes.
Okay. We had heard testimony concerning,
I would be objecting right there because he is not a blood splatter expert. He is a ME. He is not CSI. He could not definitively sit there and testify to that fact, just like he was saying, if there's no head, you cannot scientifically close this case out. So why are you testifying on facts that you have no reason to be testifying on?
Bodies are dissected in the morgue. There's not a great deal of cast off. We're obviously talking about different circumstances here, correct?
Yes, that would be different circumstances, yeah.
Here, we're not talking about a refrigerated body.
Correct.
Here, we're not talking about a specialized instrument that may be used, let's say, in a coroner's office to dissect a body.
Yeah, we don't use chainsaws, but, so no, that's a whole different thing.
Okay. There had been questions asked concerning the arteries, carotid arteries, and you'll agree with me, the anatomy of the neck is fairly complex in reference to a decapitation.
Yes.
I mean, we have obviously the muscle system, we have the vascular system, we have the spinal cord with all the vertebrae we've heard are complex and quite strong.
Correct.
We have the thick ligaments, cartilage. Would it be, can you give an opinion as to, would it be difficult to effectuate a decapitation?
Oh, yes. Especially if you're just using a handheld knife, would be very, very difficult.
And in this case, we've made reference to a handheld knife and a mechanical powered saw. Again, it's an undertaking.
Correct.
We would expect to see cast off and blood, correct?
Correct.
Would you expect to find cast off and blood at the scene where this had occurred?
Wherever it occurred, yes. Unless somebody cleaned it up or something. But yeah, you would, during using a motorized type thing, you would expect a large amount of blood splatter.
So we're not talking about a morgue, we're talking about perhaps in a bedroom, correct?
Correct. Yeah, I've never even considered a morgue anything near a scene of a crime like that.
So that would be inappropriate to make comparisons to what happens in the morgue as opposed to what happens at perhaps the scene of a crime.
Well, I've never done that. I've never heard about that because it's a completely different environment. And so I don't even, there's not even an analogy there. No.
We could have the court's indulgence just one moment. Thank you very much for your testimony, doctor. I pass the witness.
Yes. How are you, Dr. Sims?
I'm okay. How about yourself?
Good. Good to see you, sir.
Not going to disagree with you too much. I just want to clarify a couple things. We're in agreement. Sounds like that it's difficult to determine cause of death when the head is missing, correct?
Yes.
We're in agreement that it's a postmortem decapitation.
Yes.
We're in agreement. You weren't at the scene. Nobody here was at the scene. Well, maybe except one person, right?
That is, yeah, I definitely was not at the scene. No.
Yeah. So you don't know if someone covered it up while they're doing the sawing with the knife or the saw. We can agree there.
That's a good point. And I was not at the scene, nor did I've never visited the scene.
Yeah.
And so, no, I don't know that.
Fair enough. And you mentioned cleanup. Goes without saying. You can't say whether the person may have gotten blood on them, took a shower, any of that.
That's correct.
Use chemicals to clean up or anything like that.
That's correct.
Okay. Are you familiar with the term hesitation marks?
Yes.
What does that mean?
So those are primarily in relation to sharp force injury, and they can occur in somebody trying to kill themselves or when they're going to kill somebody else. And it's a mark where you're considering making a cut and you become afraid, or there's some reason that you don't. And so you leave just a superficial injury.
And you mentioned some of the cuts to the back of John's neck.
Correct.
You're not telling this jury that it was in fact a chainsaw used, correct?
No, I just talked about one area that was that I picked out, seeing the photographs, that was concerning to me.
Sure. But you'd agree there are hesitation marks.
Definitely.
Looks like somebody who went to do it was like, oh my God, I can't believe I'm doing this kind of thing.
Definitely. There were multiple hesitation marks. Yes.
And with regard to the tools, that was sent out to a forensic anthropologist, and there's tool mark experts, et cetera, right?
Correct. Yeah, that is a specialized type of analysis. And I thought they did a pretty good job.
Okay, and that was going to be my next question. Are you calling into question Dr. Burns and her associates' work?
No, I read it. They took very good photographs. They made the proper, in my opinion, the proper descriptive statements. So if that report would have came back to me, I would have adopted the report.
Sure. And it's a report. You didn't prepare a report, I've been told, in this case.
No, I didn't. I was never asked to prepare a memorandum or an email or anything about anything. I was just the reason I was originally contacted with this from the special public defenders. They were puzzled about the cause of death. They didn't quite understand it. So.
We are in agreement that the decapitation is not the cause of death.
That is correct.
You would agree with me. We've had cases together before back in the day. You would agree with me that a single blow to the head with a large blunt object can kill a man.
Yes, they can.
And you've probably seen lots of those cases.
Blunt force injury is a common mechanism of death. Yes.
And there is a difference between the terms homicide and murder, correct?
Definitely.
Homicide is a medical legal definition, and you know it better than me. I think it's death at the hands of another.
Correct. It basically talks about a mechanism. Murder is a legal conclusion because there can be justified homicides.
Sure.
Or unjust. Murder is an unjustified homicide.
Right. Gotcha. My point is you're talking about whether or not it's a homicide. You're taking issue with Dr. Yagi's terminology.
Based on the published practice standards, it did not follow that. I wouldn't have came to this conclusion at all.
Okay, fair enough. And I'm not arguing with you about that. I'm just trying to say you're not saying to this jury that John was not murdered.
I don't know.
Okay. Murder can be proven by other means, not just your narrow medical legal determination.
Oh, definitely it can. The jury can come to whatever conclusion they, based on all the data.
Yeah, phones, video, even confessions.
Correct.
Murder and homicide, two different things.
Correct.
Pass the witness. Thank you, sir.
Yes. Suffice it to say that based upon the evidence available, you could not say this person died of a blow to the head.
No.
That would be reckless.
No head.
Yes, there would be no evidentiary basis for that, so I wouldn't say that.
Something I'd like to address on my redirect of you is we've heard from other witnesses involved in the investigation of this case that this was the first time that they'd investigated, been involved with a case involving a beheading.
Okay.
Have you had experience with beheadings?
Yes.
Multiple?
As far as in the general term of dismemberment, it's probably around 24 out of my whole career since doing forensic cases starting in 1991.
Thank you. Finally, I've got a follow-up question that I'd like to address, and if you don't have any specialized knowledge concerning this, we completely understand, but there's been some discussion of chloramine, the mixing of bleach and ammonia. It was referred to in the autopsy report concerning smoking body, things like that. First of all, can you give testimony concerning chloramine?
No, I don't. That's a criminalist. A criminalist gives testimony about that. I mean, I've definitely been in cases involved in that, and they've talked to me about it. I mean, I can tell you what they told me, but I have an independent. That's not something that I include in my reports or in my estimations because there's somebody that are better experienced and better knowledgeable than I am.
So you have no opinion as to how long this chloramine may exist? Let's say you put bleach and ammonia together, it's on a body, no time frame, how long that'll be, nothing, can't give any testimony concerning that.
No, I mean, you can tell that it caused discolorations in the skin from a pathologist's point of view, but I don't have any opinion about that, no.
Thank you, doctor. I have no further questions.
No, thank you.
Ladies and gentlemen, the jury have any questions for this witness? Do you write a question on a full sheet of paper with your name and your address number? Counsel Hirsch?
My second corner looks better than the first, although when I'm done, they'll look the same. It's just easier People don't realize the corners are not really square. They're really round. The material is square. So, yeah. And my monkey is getting under my skin. Do you hear her thudding around?
If the handheld knife were described to you as a meat cleaver, would it be better to understand that the head could be removed easier than using a knife?
Yes.
Okay. I'm sorry, Mr. Baxter, any follow-up, please, on yours?
But in addition to this knife and again, the findings were of a handheld knife, correct?
Correct.
Would you expect a cut to be different from a handheld knife versus a meat cleaver?
No.
Similar?
Yes.
However, in addition to a blade, based upon the findings, we're to understand that a mechanically powered saw was used.
That is correct. Yeah, whether it was a reciprocating saw or a rotary saw or whatever, they didn't go any further than that. But it was some kind of powered instrument.
Thank you. I have no further questions.
No, thank you.
Ladies and gentlemen, any further questions for the witness? Yes, and these right questions, on the sheet of paper with your name and your journal number.
Okay, next witness. Sidebar. Buys, that's on the bingo card. Don't forget to hit the bingo card. Y'all, we have fun playing bingo. Bingo, bingo, bingo. Bingo. Oh, that's a nice looking corner. Much nicer than the other one. So I was saying is some corners are rounded. The cardboard is more rounded. And then they put the material over it and it looks square and pointy. But in reality, it is not square and it is not. So it's difficult for me to do the corners, but I think I've got this one done. I think said the putty. I see said the putty. Said the putty kitty. Okay, so I'm going to delete those 3. I got to go wash my hands because this beeswax has got me so sticky. And yes, we're still on sidebar. Y'all don't forget to subscribe. Hit that bell for notifications so you know when I'm going live. Also, we do have memberships. Don't forget to come join our membership. I'm going to be launching a bunch of new stuff next year. I cannot wait. I am working behind the scenes on a few things. And when they're ready, I'll be happy to share. But until then, I ain't. Oh, dang it. That's not what I wanted to do, but I guess I did it.
Okay, Dr. Sims, is it a regular practice for the medical examiner to call in a criminologist when chemicals are used?
It would be if that is an issue, a recognized issue in the case. It's not some just minor finding, and that is correct.
If alcohol is in the stomach and not absorbed in the bloodstream, does it affect the person's ability to function?
No.
When you talk about natural causes, would you expect to see physical signs of a heart attack or cardiac enzymes?
That's a very excellent question. Because there was no microscopic
Someone's got medical knowledge.
analysis of the heart. There was no microscopic analysis of the liver to actually fully assess the amount of pathology and whether there was something acute or long, which should have been done in this particular case.
In terms of the liver, if fatty liver disease progresses, would you expect to see signs of jaundice or bad enzyme levels?
That's also an excellent question. So in his particular case, it had not progressed to cirrhosis as yet, but without getting into a lot of pathology, the storage of fat in the liver disrupts the liver's ability to function, and the function is the main metabolic organ that takes care of all toxins in your body, whether they're drugs or anything else. And so when you lose that, then you allow a higher level of those toxins to be in your bloodstream, which can cause death. And that's how it operates.
Yes, just briefly in reference to the question, the alcohol, based upon your test in the stomach, based upon your evaluation of this person was clearly intoxicated.
Well, the marijuana was really high, and it also worked with whatever little alcohol was present. Both of them are central nervous system depressants. So there's what's called a synergistic effect.
So we would expect then alcohol in conjunction with the THC, this person was pretty loaded.
It was definitely under the influence of marijuana for sure. Yes.
Finally, in reference to this cast off post-mortem, you'd expect under the circumstances of this case for there have been significant cast off.
If there was a motorized, there can be cast off even with a handheld knife, depending on how the person is using, but it's going to be very small compared to the cast off from any kind of motorized cutting instrument.
Thank you. I have no further questions.
Any final statements?
No, thank you.
Do the ladies and gentlemen here have any further questions for this witness? Okay, seeing no response, sir, you are excused. Thank you very much for your testimony here today.
Thank you.
Does the defense have any further witnesses they wish to call?
We have no further witnesses that we are going to call. We are going to arrest. However, we do have a housekeeping matter. Did we get those other exhibits? Okay. We'll stipulate the defense rests.
Okay, what are the exhibit numbers? E4 through N4 are going to be admitted pursuant to stipulation. The defense will rest at this time. State you have in your running.
No, thank you, Your Honor.
All right, ladies and gentlemen of the jury, we have now reached the conclusion of evidence in this case. We have now reached the portion of the case where I'm going to read you the instruction from the law that applies to this case. You guys are the fact finders, so it's very important that you understand what I'm reading to you. So we are going to give you your own packet so you can follow along as I read them to you, just in case I read too fast and you guys, we don't want you to miss anything.
Boy, she runs a tight ship, y'all. She's all like, get over there, boo.
All right, ladies and gentlemen, instructions to the jury. Instruction number 1, members of the jury. It is now my duty as judge to instruct you on the law that applies to this case. It is your duty as jurors to follow these instructions and to apply the rules of law to the facts as you find them from the evidence. You must not be concerned with the wisdom of any rule of law stated in these instructions. Regardless of any opinion you may have as to what the law ought to be, it would be a violation of your oath to base a verdict on any other view of the law than that given in the instructions of this court. Instruction number 2, if in these instructions any rule, direction, or idea is repeated or stated in different ways, no emphasis thereon is intended by me, and none may be inferred by you. For that reason, you are not to single out any certain sentence or any individual point of instruction and ignore the others, but you are to consider all the instructions as a whole and regard each in the light of all the others. The order in which the instructions were given has no significance as to their relative importance. Instruction number 3, a third amended indictment is but a formal method of accusing a person of a crime and is not of itself any evidence of her guilt. In this case, it is charged in a third amended indictment that on or about the 7th day of August 2023, the defendant committed the offense of murder with use of a deadly weapon. Count 1, murder with use of a deadly weapon. Did willfully, unlawfully, honestly, and with malice aforethought kill Jonathan Willett, a human being, with the use of a deadly weapon, to wit, a wooden stick and or other unknown object, by striking the said Jonathan Willett with the said wooden stick or other unknown object, and or through other means, the said killing having been 1, willful, deliberate, premeditated, and or 2, committed during the perpetration or attempted perpetration of a robbery. It is the duty of the jury to apply the rules of law contained in these instructions to the facts of the case to determine whether or not the defendant is guilty of the offense charged. Instruction number 4. In this case, the defendant is accused in a third amended indictment alleging an open charge of murder. This charge includes and encompasses murder of the first degree and murder of the second degree. The jury must decide if the defendant is guilty of any offense and if so, of which offense. Instruction number 5, murder is the unlawful killing of a human being with malice aforethought, whether express or implied. The unlawful killing may be effected by any of the various means by which death may be occasioned. Instruction number 6, malice aforethought means the intentional doing of a wrongful act without legal cause or excuse or what the law considers adequate provocation. The condition of mind described as malice aforethought may arise not alone from anger, hatred, revenge, or from particular ill will, spite, or grudge toward the person killed, but may result from an unjustifiable or unlawful motive or purpose to injure another, which proceeds from a heart fatal event on mischief or with reckless disregard of consequences and social duty. Malice aforethought does not imply deliberation or the lapse of any considerable time between the malicious intention to injure another and the actual execution of the intent, but denotes rather an unlawful purpose and design in contradistinction to accident and mischance. Instruction number 7, express malice is that deliberate intention unlawfully to take away the life of a fellow creature, which is manifested by external circumstances capable of proof. Malice may be implied when no considerable provocation appears or when all the circumstances of the killing show an abandoned and malignant heart. Instruction number 8, the prosecution is not required to present direct evidence of a defendant's state of mind as it existed during the commission of a crime, and the jury may infer the existence of a particular state of mind from the circumstances disclosed by the evidence. Instruction number 9, murder of the first degree is murder which is perpetrated by means of any kind of willful, deliberate, and premeditated killing. All 3 elements, willfulness, deliberation, and premeditation, must be proven beyond a reasonable doubt before an accused can be convicted of first-degree murder. Instruction number 10, willfulness is the intent to kill. There need be no appreciable space of time between formation of the intent to kill and the act of the killing. Instruction number 11, deliberation is the process of determining upon a course of action to kill as a result of thought, including weighing the reasons for and against the action and considering the consequences of those actions. Instruction number 12, a deliberate determination may be arrived at in a short period of time, but in all cases, determination must not be formed in passion, or if formed in passion, it must be carried out after there has been time for the passion to subside and deliberation to occur. A mere unconsidered and rash impulse is not deliberate, even though it includes an intent to kill. Instruction number 13, premeditation is a design, a determination to kill distinctly formed in the mind by the time of the killing. Instruction number 14, premeditation need not be for a day, an hour, or even a minute. It may be as instantaneous as successive thoughts of the mind. For if the jury believes from the evidence that the act constituting the killing has been preceded by and has been the result of premeditation, no matter how rapidly the act follows the premeditation, it is premeditated. Instruction number 15, the law does not undertake to measure in units of time the length of the period during which the thought must be pondered before it can ripen into an intent to kill, which is truly deliberate and premeditated. The time will vary with different individuals and under varying circumstances. Instruction number 16, the true test is not the duration of time, but rather the extent of the reflection. A cold, calculated judgment and decision may be arrived at in a short period of time, but a mere unconsidered and rash impulse, even though it includes an intent to kill, is not deliberation and premeditation, as will fix an unlawful killing as murder of the first degree. Instruction number 17, there are certain kinds of murder which carry with them conclusive evidence of malice aforethought. One of these classes of murder is murder committed in the perpetration or attempted perpetration of a robbery. Therefore, a killing which is committed in the perpetration or attempted perpetration of a robbery is deemed to be murder of the first degree, whether the killing was intentional or unintentional or accidental. This is called felony murder rule. The intent to perpetrate or attempt to perpetrate a robbery must be proven beyond a reasonable doubt. In order for the felony murder rule to apply under the robbery theory, the intent to take the property must be formed prior to the act constituting the killing. Instruction number 18, robbery is the unlawful taking of personal property from the person of another in his presence against his will by means of force or violence, severe injury, immediate or future to his person or property, or the personal property of a member of his family, or of anyone in his company at the time of the robbery. Such force or fear must be used to 1, obtain or retain possession of the property, 2, to prevent or overcome resistance to the taking of the property, or 3, to facilitate escape with the property. In any case, the degree of force is immaterial if used to compel acquiescence to the taking of or escaping with the property. Such taking constitutes robbery whenever it appears that although the taking was fully completed without the knowledge of the person from whom taken, such knowledge was prevented by the use of force or fear. The value of property or money taken is not an element in the crime of robbery, and it is only necessary that the state proves the taking of some property or money. Instruction number 19, robbery may spread over considerable and varying periods of time. All matters immediately prior to and having direct causal connection with the robbery are deemed so closely connected with it as to be part of the occurrence. Thus, although acts of violence and intimidation preceded the actual taking of the property and may have been primarily intended for another purpose, it is enough to support the charge of robbery when a person takes the property by taking advantage of the terrifying situation she created. Instruction number 20, it is unnecessary to prove both violence and intimidation. If the fact be attended with circumstances of threatening word or gesture, as in common experience, and is likely to create an apprehension of danger and induce a man to part with his property for the safety of his person, it is a robbery. It is not necessary to prove actual fear as the law will presume it in such a case. Instruction number 21, while a verdict must be unanimous, you need not be unanimous on the means or the theory of first-degree murder in arriving at your verdict. Instruction number 22, murder of the second degree is murder with malice aforethought, but without the admixture of premeditation and deliberation. All murder which is not murder of the first degree is murder of the second degree. Instruction number 23, when it is impossible to commit a particular crime without committing at the same time and by the same conduct another offense of lesser greater degree, the latter is, with respect to the former, a lesser included offense. If you are not satisfied beyond a reasonable doubt that the defendant is guilty of the offense charged, she may, however, be found guilty of any lesser included offense, if the evidence is sufficient to establish her guilt of such lesser offense beyond a reasonable doubt. The offense of murder, which actually charges the defendant with first-degree murder, necessarily includes the lesser offense of second-degree murder. If you are convinced beyond a reasonable doubt that the crime of murder has been committed by the defendant, but you have a reasonable doubt whether such murder was of the first or second degree, you must give the defendant the benefit of that doubt and return a verdict of murder of the second degree. Voluntary manslaughter is a lesser included offense of both first and second degree murder. Thus, you may only return a verdict of voluntary manslaughter if you first rule out both first and second degree murder. Instruction number 24. Voluntary manslaughter is the unlawful killing of a human being without malice aforethought and without deliberation or premeditation. It is the killing upon a sudden quarrel or heat of passion caused by a provocation sufficient to make the passion irresistible. The provocation required for voluntary manslaughter must either consist of a serious and highly provoking injury inflicted upon the person killing, sufficient to excite an irresistible passion in a reasonable person, or an intent by the person killed to commit a serious personal injury on the person killed. For the sudden violent impulse of passion to be irresistible, resulting in a killing, which is voluntary manslaughter, there must have been an interval between the assault or provocation and the killing sufficient for the voice of reason and humanity to be heard, or if there should appear to have been sufficient time for a cool head to prevail and the voice of reason to be heard, the killing shall be attributed to deliberate revenge and determined by you to be murder. The law assigns no fixed period of time for such an interval, but leaves its determination to the jury under the facts and circumstances of the case. Instruction number 25. The heat of passion which will reduce the homicide to voluntary manslaughter must be such an irresistible passion as naturally would be aroused in the mind of an ordinarily reasonable person in the same circumstances. A defendant is not permitted to set up his own standard of conduct and to justify or excuse himself because his passions were aroused unless the circumstances in which he was placed and the facts that confronted him were such as also would have aroused the irresistible passion of the ordinarily reasonable man in a likewise situation. The basic inquiry is whether or not at the time of the killing, the reason of the accused was obscured or disturbed by passion to such an extent as would cause the ordinarily reasonable person of average disposition to act rashly or without deliberation or reflection, and from such passion rather than from judgment. Instruction number 26. You are instructed that if you find the defendant guilty of murder or voluntary manslaughter, you must also determine whether or not a deadly weapon was used in the commission of this crime. If you find beyond a reasonable doubt that a deadly weapon was used in the commission of such an offense, then you shall return the appropriate guilty verdict reflecting the use of a deadly weapon. If, however, you find that a deadly weapon was not used in the commission of such an offense, but you find that it was committed, then you shall return the appropriate guilty verdict reflecting that a deadly weapon was not used. Instruction number 27. A deadly weapon is any instrument which, if used in the ordinary manner contemplated by its design and construction, will or is likely to cause substantial bodily harm or death, or any weapon or device, instrument, material, or substance which, under the circumstances in which it is used, attempted to be used, or threatened to be used, is readily capable of causing substantial bodily harm or death. Instruction number 28. The state is not required to have recovered the deadly weapon used in an alleged crime or to produce the deadly weapon in court at trial to establish that a deadly weapon was used in the commission of the crime. Instruction number 29. To constitute the crime charge, there must exist a union or joint operation of an act forbidden by law and an intent to do the act. The intent with which an act is done is shown by the facts and circumstances surrounding the case. Do not confuse intent with motive. Motive is what prompts a person to act. Intent refers only to the state of mind with which the act is done. Motive is not an element of the crime charge, and the state is not required to prove a motive on the part of the defendant in order to convict. However, you may consider evidence of motive or lack of motive as a circumstance in the case. Instruction number 30. The defendant is presumed innocent until the contrary is proved. This presumption places upon the state the burden of proving beyond a reasonable doubt every element of the crime charge and that the defendant is the person who committed the offense. A reasonable doubt is one based on reason. It is not mere possible doubt, but is such a doubt as would govern or control a person in the more weighty affairs of life. If the minds of the jurors, after the entire comparison and consideration of all the evidence, are in such a condition that they can say they feel an abiding conviction of the truth of the charge, there is not a reasonable doubt. Doubt to be reasonable must be actual, not mere possibility or speculation. If you have a reasonable doubt as to the guilt of the defendant, she is entitled to a verdict of not guilty. Instruction number 31. The evidence which you are to consider in this case consists of the testimony of the witnesses, the exhibits, and any facts admitted or agreed to by counsel. There are two types of evidence, direct and circumstantial. Direct evidence is the testimony of a person who claims to have personal knowledge of the commission of the crime which has been charged, such as an eyewitness. Circumstantial evidence is the proof of a chain of facts and circumstances which tend to show whether the defendant is guilty or not guilty. The law makes no distinction between the weight to be given either direct or circumstantial evidence. Therefore, all the evidence in the case, including the circumstantial evidence, should be considered by you in arriving at your verdict. Statements, arguments, and opinions of counsel are not evidence in this case. However, if the attorney stipulates to the existence of a fact, you must accept the stipulation as evidence and regard that fact as proof. You must not speculate to be true any insinuation suggested by a question asked the witness. A question is not evidence and may be considered only as it supplies meaning to the answer. You must disregard any evidence to which an objection was sustained by the court and any evidence ordered stricken by the court. Anything you may have seen or heard outside the courtroom is not evidence and must also be disregarded. Instruction number 32. The credibility or believability of a witness should be determined by his manner upon the stand, his relationship to the parties, his fears, motives, interests, or feelings, his opportunity to have observed the matter to which he testified, the reasonableness of his statements, and the strength or weakness of his recollections. If you believe that a witness is lying about any material fact in the case, you may disregard the entire testimony of that witness or any portion of his testimony which is not proved by other evidence. Instruction number 33. A witness who has special knowledge, skill, experience, training, or education in a particular science, profession, or occupation is an expert witness. An expert witness may give his opinion as to any matter in which he is skilled. You should consider such expert opinion and weigh the reasons of any given for it. You are not bound, however, by such an opinion. Give it the weight to which you deem it entitled, whether that be great or slight, and you may reject it if in your judgment the reasons given for it are unsound. Instruction number 34. Although you are to consider only the evidence in the case in reaching a verdict, you must bring to the consideration of the evidence your everyday common sense and judgment as reasonable men and women. Thus, you are not limited solely to what you see and hear as the witnesses testify. You may draw a reasonable inferences from the evidence which you feel are justified in the light of common experience. Keep it in mind that such inferences should not be based on speculation or guess. A verdict may never be influenced by sympathy, prejudice, or public opinion. Your decision should be the product of sincere judgment and sound discretion in accordance with these rules of law. Instruction number 35. In arriving at a verdict in this case as to whether or not the defendant is guilty or not guilty, the subject of penalty or punishment is not to be discussed or considered by you and should in no way influence your verdict. Instruction number 36. You are here to determine whether the state has proven beyond a reasonable doubt the guilt of the defendant from the evidence in the case. You are not called upon to return a verdict as to the guilt or innocence of any other person. So if the evidence in the case convinces you beyond the reasonable doubt of the guilt of the defendant, you should so find, even though you may believe one or more persons are also guilty. Instruction number 37. You have seen trial exhibits that have been redacted. Those redactions have occurred either by agreement of the parties or by court order pursuant to Nevada law. You are not to consider the fact that an exhibit has been redacted for any purpose whatsoever. Instruction number 38. It is a constitutional right of the defendant in a criminal trial that she may not be compelled to testify. Thus, the decision as to whether she should testify is left to Ms. Michaels on the advice and counsel of her attorneys. You must not draw any inference of guilt from the fact that she does not testify, nor should this fact be discussed by you or enter into your deliberations in any way. Instruction number 39. When you retire to consider your verdict, you must select one of your members to act as a foreperson who will preside over your deliberation and be your spokesman here in court. During your deliberation, you will have all the exhibits which were admitted in evidence, these written instructions, the forms of verdict which have been prepared for your convenience. Your verdict must be unanimous. As soon as you have agreed upon a verdict, have it signed and dated by your foreperson and returned with it to this court. Instruction number 40, during the course of this trial and your deliberations, you are not to, 1, communicate with anyone in any way regarding this case or its merits, either by phone, text, internet, or other means. Read, watch, listen to news or media accounts or commentary about the case. 3, do any research such as consulting dictionaries, using the internet, or using reference materials. 4, making an investigation, test the theory of the case, recreating the aspect of the case, or in any other way investigate or learn about the case on your own. Instruction number 41, if during your deliberation you should desire to be further informed on any point of law, or hear again portions of the testimony, you must reduce your request to a writing signed by the foreperson. The officer will then return you to court where that information sought will be given to you in the presence of and after notice to the district attorney and defendant and her counsel. Playbacks of testimony are time consuming and are not encouraged unless you deem it a necessity. Should you require a playback, you must carefully describe the testimony to be played back so that the court reporter can arrange her notes. Remember, the court is not at liberty to submit the evidence. Now you listen to the arguments of counsel who will endeavor to aid you to reach a proper verdict by refreshing in your minds the evidence and by showing the application thereof to the law. For whatever counsel may say, you will bear in mind that it is your duty to be governed in your deliberation by the evidence as you understand it, remember it to be, and by the law given to you in these instructions, with the sole fixed and steadfast purpose of doing equal and exact justice between the defendant and the state of Nevada. All right, ladies and gentlemen, we do not want to break up the closing arguments for you, so we're going to take our lunch recess now, and then when you guys come back, we will have the closing arguments by the parties when you return from the lunch recess. During this recess, you must not discuss or communicate with anyone, including fellow jurors, in any way regarding this case or its merits, either by voice, phone, email, text, internet, or other means of communication or social media. You must not read, watch, or listen to news or media accounts or commentary about the case. You must not do any research such as consulting dictionaries, using the internet, or using reference materials. You must not make the investigation, test the theory of the case, recreating the aspect of the case, or any other way investigate or learn about the case on your own. You must not express an opinion regarding this case that was constant to you. Ladies and gentlemen, it's 11:40. We'll be in recess until 1 o'clock.
All rise for the jury.
My God, I don't think I have ever heard jury instructions read like that before in my life. What do y'all think? Oh my gosh, y'all, that was insane. Oh, messed this up. Gotta fix it.
Please, court, Your Honor. Standing before you is Victoria Tippett. She's represented by Hunter Bluen and Greenville Bar. She has been indicted on 3 charges, 2025 GS 0400, 737, 738, 739. Those charges are obstruction of justice, misprision of a felony, and accessory after the fact to a murder. Your Honor, the victims in this case is Cecilia Barrow. Her daughter was murdered in this incident. Her name is Jessica Barnes. As a brief background, Your Honor, this occurred on or about August 1st and 2nd of 2024. Brandon Barnes, who is he's charged with murder, he was living at a residence in Pendleton with Miss Tippett, who had just recently moved there, but they were living in a house owned by, I believe his name is Mr. Herron. Mr. Herron has a granddaughter, Miss Mims, who's a co-defendant in this situation. There's 3 co-defendants. Brandon Barnes is charged with murder. Miss Tippett is charged with the 3 charges that I've already stated, as well as Kendall Mims as well. Jessica Barnes disappeared on August the 1st or 2nd. As way of background, like I said, Ronald Herron is the grandfather of Miss Kendall Mims. Mims and Barnes were in a prior relationship, and they actually had a young child together. Brandon Barnes and Miss Mims drove 2 vehicles that Mr. Herron had a financial interest in, and so he was concerned about the vehicles, and he ultimately put a GPS tracking device on these 2 vehicles that was driven by Mr. Brandon Barnes and then by Miss Kendall Mims. Mr. Herron turned over that login information to SLED about September the 18th, 2024. Jessica Barnes was reported missing about 10 days prior on September 10th or 11th. But again, this occurred on August 1st or 2nd, 2024. When SLED and law enforcement started looking at those GPS tracking records, they saw that one of those vehicles went to a location on Twin Lakes Road about 9 different occasions between August the 2nd and August the 4th of 2024. And that location's in Pickens County, but close to Lake Hartwell. Law enforcement, once they saw that, they went out with some canine unit that was capable of detecting human remains. And they found off of a dirt path going down towards the lake, that dog did alert for human remains. After sifting through that burn pile, they did find items what appeared to be human remains. They obviously sent those off for DNA testing and talked to an anthropologist that works at Clemson, and they were able to determine that it was human remains. As they went back and started again kind of digging into this case, as they got more and more information, they saw that vehicle that was used go to several different locations, to different places, different hardware stores and grocery stores. They were able to see these individuals, all these individuals, all these co-defendants at these stores purchasing different items like shovels and different items, cleaning materials. And they ultimately determined that they used these materials to dispose of the victim's body out on Twin Lakes Road, and then to clean up the crime scene where this murder occurred in the city of Pendleton at the home of Mr. Herron. I guess during the course of this, like I stated, Miss Barnes, Jessica Barnes, the deceased in this case, was reported missing to Pendleton. She was reported missing by Brandon Barnes, Miss Mims, and Miss Tippett. And then over the course of the next week or so, that's when they put all this together. On September the 17th through the 21st, Miss Tippett and her co-defendants went on a cross-country excursion, which plays into bond, Your Honor. They went to several different states: North Carolina, Tennessee, Kentucky, Tennessee. They went all the way out to Colorado. And after 4 or 5 days, they ended up coming back to South Carolina. Law enforcement put up a trail camera because of the activity at this particular location. They did see on that trail camera on September the 22nd, all these co-defendants returned back to that location where Jessica Barnes' body was burned. Ultimately, they did speak to all the co-defendants and did ultimately get several different stories from these co-defendants. Law enforcement determined that Miss Mims, she wasn't present when this murder occurred. She'd actually gone to work, but when she came back home, that's when she saw the body. And then at that point, all 3 of them decided to dispose of the body. Miss Tippett was at home when this occurred. She gave law enforcement a couple different stories on October the 1st. First story that she gave was that Jessica Barnes just left the house and never saw her again. Then she changed her story and said that Jessica had committed suicide. She OD'd on something. And then she changed her story and said that it essentially was an accident, that Jessica had attacked Brandon. And then at that point, Brandon defended himself and choked her. And then she died. So she did ultimately admit to being there and I guess observing this. She does not have a record, Your Honor, but she's been in jail for some 400 some odd days when she was arrested, I believe, on October the 1st. Again, her mother is here. The victim's mother is present. She does have a statement that she would like to have my victim's advocate read for the record, Your
Honor. She'd like for me to read it out loud in court, Your Honor. Your Honor, today, as I sit in this courtroom, my heart carries the unimaginable weight of losing my daughter, Jessica. Words alone cannot convey this. Jessica believed in friendship with her whole heart. She saw Miss Tippett not just as a friend, but as someone she could trust completely, someone who was supposed to care for her in moments of joy and in times of need. Yet, when Jessica reached out for help, she was met with indifference. She was treated not as a cherished person, but as someone whose life didn't matter. My family and I have been left with wounds that are invisible to the eye, but unbearable to endure. Every bond hearing is not just a legal proceeding. It slices through our grief and breaks open the pain we desperately want to seal. There are moments in the night when I wonder if my family will ever be able to mourn Jessica and begin to heal. We still do not have all that is left of her, and her absence goes through every part of our home. My children ask for her, and I must find words to comfort them, even when I cannot comfort myself. Your decisions affect so much more than a case file. They touch lives forever changed by tragedy. I plead with you, please deny this bond and let my family finally begin to grieve without the fear and pain that each hearing brings. Jessica was not just a victim. She was a person whose life had value, love, and meaning. Please honor her memory and help us find peace. Respectfully and with a grieving heart, Cecilia Guevara.
And please, the court.
I think Mr. Bloom will get into this, but Mr. Barnes, currently his bond is denied. Ms. Mims does have a bond. She is granted a $75,000 bond with standard conditions with GPS. And Ms. Tippett had a bond hearing in the spring with Ms. Mims, and her bond was denied.
The two, who is more, who's 0 and 10?
As I stated, Judge, the investigation yielded that Ms. Mims was not present when the murder happened. She had gone to work and then returned home. And then obviously the investigation shows that she took part in taking the body, Jessica's body out, disposing of the body. The investigation yielded that Ms. Tippett was present when this happened. She was at home with Ms. Barnes. So she was in the residence when this did occur.
May it please the court, Your Honor. As the solicitor stated, co-defendant Kendall Mims was granted a bond on April 14th of 2025, which was $75,000 GPS.
Okay, so let's do a quick little thing on Miss Tippett. Give me a second while I transfer information. And let me do this. We're going to do, because nobody knows anything about this case, or I don't know anything about this case, so this is all news to me. So let's talk about Miss Victoria Tippett is awaiting trial in South Carolina for her alleged role in covering up the red room of Jessica Barnes. She has been repeatedly denied bond due to considering a danger to the community and a flight risk. Key trial details are the charges against Tippett: accessory after the fact to red room, obstruction of justice, misprision of a felony, failure to report a crime. Victim is Jessica Barnes, 20, Pendleton, South Carolina, red roomed August of 2024, allegedly strangled by her husband, Brandon Barnes. Co-defender Brandon Barnes accused of strangling his wife, Kendall Mims, another roommate charged with related offenses. Tippett and Mims allegedly helped dispose of Jessica's body. Bond hearing, Tippett was arrested on, my mic's not moving, on October 2nd of 2024. Judge has denied bond multiple times, April 25 and then again today, citing community danger and risk of flight. Mims was granted a $75,000 bond earlier, but Tippett remains in jail. Prosecution case alleged that Tippett helped conceal Jessica's body after the fact. Evidence suggests that Brandon Barnes had secret relations with both roommates, including fathering a child with one of them. Tippett's defense argues she was a victim of Brandon's abuse manipulation. Tippett is being held in Anderson County Detention Center. Her trial date is yet to be set, but will remain behind bars until the proceedings begin. The case continues to draw attention due to its disturbing mix of domestic violence, secrecy, and betrayal. That is who we are listening to at this present moment.
No contact with the co-defendant or any of the victim's family. My client's 21 years old. She has a CNA certificate as a nurse that she received from Greenville Tech. She also, previous to moving in with Mr. Barnes, worked at McAllister's. She has no prior, McAllister's Deli, a little bit. She has no prior record. Your Honor, I'm going to pass up, and the solicitor has this. We did have her have a psychological evaluation. The reason I'm handing it up, Your Honor, is on page 4. Page 4 of that evaluation under his opinions and conclusions.
I just read your note. Oh my God, give her a hug for me and tell her congratulations.
She had a high salient score and a low PRA, which we would argue goes to danger to the community, that she would not be a danger to the community if she were granted a bond. She had only been involved with Brandon Barnes for about a month and a half prior to this incident, and had only lived in the home for approximately 3 weeks with Mr. Barnes and Miss Mims. She did not have a vehicle. I guess Mr. Barnes had picked her up and brought her to Anderson, and she wasn't working at that time. Her job apparently was to take care of Mr. Barnes and Mrs. Mims' child while Miss Mims went to work. That was kind of what her duty was. Looking through discovery, it is apparent that Mr. Barnes was both physically as well as psychologically and potentially sexually abusive toward all of these women. It's our position that Ms. Tippett, once she got involved with Mr. Barnes and moved to that house, she had nowhere to go, and then he became abusive as he was to all of the women involved. Like I said, physically, sexually, and psychologically. If granted a bond, she would live at 235 Miller Road in Belton, so she would stay here in Anderson County.
Who lives at that address?
Jamie Shaw lives at that address. He's a family friend. I pulled his prior record history as no pending charges. The only sort of charge he ever has that he convicted of was a 2017. It looked like a pill case. He got 2 days time served. But since then, nothing. I don't even think any traffic tickets since then. She would have to, because of a warrant related to all of this, have to go to Pickens County, obviously first, to get served with that warrant, have a bond hearing there. The actual disposing of the remains, since Twin Lake Road was in Pickens County. So, Your Honor, I do not believe she's a flight risk. She's been in South Carolina for approximately 18 years. Like I said, she's worked as a nurse. She's educated. She's got no prior record. So we would ask, and the co-defendant charged with the same offenses was previously granted a bond. So we would ask, Your Honor, for a reasonable bond in that matter.
Are you going to say anything?
She is not a nurse. She's a CNA. Boo. Two different things, honey child. You should know your terminology, man.
And they took off for how items?
They were gone. The GPS records show from September the 17th to the 21st, about 4 days. And I think that they were coming back. They didn't have the means to.
Anything for
Nothing.
right now? She will listen to the defendant. Does have one. We'll wait for 6 months before she comes back to that another bond. I think she is a flight risk and a danger.
Thank you. Yes.
So, unfortunately, this is very typical. Very typical that these young women get caught up with these men and then they become victims and then they commit crimes, and it's just a horrible, vicious cycle. Our poll: if you were a juror, would you find her guilty or not guilty? 89% guilty, 11% not guilty. I was on another live and it was a strongly 72% not guilty. I was floored. June, if you want to put up another poll, you may. Thank you very much. Tell her, Angela, tell her we are so proud of her. I'm going to end the poll. Let's see if we can do a poll for a verdict run. Congratulations on meeting the requirements. Oh no. She gets an 80 on her grade. That is freaking awesome. Absolutely awesome. Soft.
Okay. Mr. Horvath, any follow-up based on your question?
I don't understand why they ended the live. That's frustrating to me. Why would you end your live? They got to go to closing arguments. So why are you ending your live? Dude, don't do that to us. That's not the way this goes. That's not the way it is. That's not the way things go here, boo. So we're going to go somewhere else. Both of them, she had 2 and passed both classes, geography and history. That's amazing. I am so happy for you, boo. So we've only been lunch for 18 minutes. Oh my gosh. Y'all. I am going to take a courtroom break. I'm going to run down the street. I got to grab something. I have no food in the house and I'm starving. And then I got to finish this hat today because I got to wear it tomorrow. So why don't we do this? Why don't we have a stretch break, everybody? We will be back in about 30 minutes. Everybody stretch, get your food, get your hydration, get your comfort break in, and meet us back here in about 30 minutes. Okay, everybody. I was just talking to my fabulous mod and quick myself on a little early. I hope you had a great lunch. I did. I had me some turkey and dressing. I had a little lunch thing from the store. I love turkey. I could eat turkey and dressing and potatoes and gravy and cranberry every day of the week, y'all. I gotta get out of there. Okay. I could do it every day of the week. I really could. I love turkey and dressing, but I too can burn out just like everybody else can. So we are waiting for court to come back. Let me get back over here. I know, I think I'm going to switch to, okay. So June, do I still have that problem? I need a pick. June was telling me we had a little problem. Welcome back. I love that welcome back Cotter song, but I can't do it because it's copyrighted. Welcome back, honey, Angela, Amy. Thank you guys for all being here. All you beautiful lurkers. Thank you guys for staying. We had some new people hop in the chat today. I want to give a shout out to some of the new people we had. Let me scroll. We had NECU67. I may not be able to scroll back far enough to get everybody. We, of course, had Trace on the case. Little Debbie Swiss rolls. Yum. Trace on the case. If you're lurking, I need to talk to you in Discord. Yep. Yes, I do Trace on the case. Wow. I can't see all the 17 Susie Q. Welcome, welcome, welcome. Thanks for hopping in. Catted 71. Thank you for hopping in. Of course, we have case one. We got a lot. We've had some new, just fan one. We haven't seen you. Well, you coming in and out. XO Nicole. Thank you so much for hopping in. Thank you, thank you, thank you. Glad that you joined us. I hope you will come back. All of the newbies, I hope you come back. And thank you to all of our regulars for being here every single day. I appreciate you. I don't know what you typed no for. Okay. So, Joe, does that mean no, there's not a problem? Was this the thumbnail? Was this the banner, the whatever border you were talking about, or was it another one? Let's see, which other one did I have? I may have already erased them all. Yeah, I erased them all. Yep. Erased them all. So that's that one. So we should be back in court any second. And of course, my computer wants to do a systematic shutdown, and I'm not going to let it. I'm having blueberry banana bread as a snack. Hubby came home with it when he went to get made. Yum, 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 yummy. Well, I love blueberry muffins. Give me blueberry muffins anytime. Y'all be in prayer for me. I got to finish the rest of this during court today and then put the sequins trim on. I am getting there. And I'm actually quite proud of my corners. Corners are hard to do. So I'm going to be working on that for the rest of the day. I got to get it done. And then I also have a homework assignment I got to get done by midnight. So here we go. Such is our life around here. So we had a poll, and if you were the juror in this case, would you find her guilty or not guilty? 11% not guilty, 89% guilty. In another live stream, hers was 53 guilty, and oh, I can't fix that, June. I see what you mean. Yes. Does that stay up permanently, or do you have to click off of it? Yes, I can't. Remember we talked about program. Remember we talked about allowing the program to put that up. Those are our two featured items in our shop. It is transparent. allowing that to happen or we don't. We're back. Woo! Um,
He murdered Jonathan Millett. The crime charged in this case is murder with use of a deadly weapon. You heard from the judge, she did read that to you folks prior to our break. So what it is willful, unlawful, felonious, and with malice aforethought, the defendant killed Jonathan Millett, a human being, with use of a deadly weapon, be it a wooden stick and/or an unknown object, by striking the said Jonathan Millett with the said wooden stick and/or other unknown object, and/or through other unknown means. The said killing having been, 1, willful, deliberate, and premeditated, and/or 2nd, committed during the perpetration or attempted perpetration of a robbery. Let's start with the easy one, the deadly weapon. You heard from the defendant that she hit Jonathan Millett with a stick, and he died. So this is clearly showing that that stick that she described to you is a deadly weapon because it resulted in the death of Jonathan Millett. Now I want to point out something very important that's in your instructions, and it's not something to gloss over. The state is not required to have recovered the deadly weapon used in the crime in this case. So keep that in the back of your mind that we are not required to do that. However, we have the confession from the defendant that that is what she used. So that being said, you'll have your verdict form when you go back to deliberate. So I think it's helpful to sort of walk through that. So based on knowing that there was a deadly weapon used, beyond reasonable doubt, we're able then to eliminate guilty of first degree without, use of a deadly weapon, and also guilty of second degree murder, and guilty of voluntary manslaughter. So all that we are left are those charges with use of a deadly weapon. Let's talk about murder. Your instructions tell you that murder is the unlawful killing of a human being with malice aforethought. Whether express or implied, the unlawful killing may be effected by any of the various means by which death may be occasioned. So let's talk about malice aforethought. What does that mean? That is the intentional doing of a wrongful act. So I don't think anyone is going to get up here and say that this was not a brutal first-degree murder. Knowing that, defendant's actions were not voluntary manslaughter. Voluntary manslaughter is the unlawful killing of a human being without malice aforethought, without deliberation or premeditation. It is a killing upon a sudden quarrel or heat of passion caused by a provocation sufficient to make the passion irresistible. That is not what we have in this case. The defendant said in her statement to the police, told the police, that she was giving Jonathan a back massage while he was laying face down on his bed. She was next to him. She got up off the bed, made the conscious decision to then walk over to that fireplace that we all saw, grab what she described as a candlestick, an object, right? Walks over, makes the conscious decision to then walk over, goes to the bed, and while Jonathan is still face down, with his head facing away from her, as she told us, she took that stick and bashed the victim in the head. He had no clue that this was coming. Conscious decisions every step of the way. His body goes limp. This is not voluntary manslaughter. The instruction also tells you if there should appear to have been sufficient time for a cool head to prevail and the voice of reason to be heard, the killing shall be attributed to deliberate revenge and determined by you to be murder. The defendant did mention that the victim, Jonathan Willett, had rubbed on her leg. And then she kind of just shooed it off. It was like, okay. And then after that, he seemed happy, right? His face was turned away, he thought he was getting more of a massage. But instead, the defendant made those conscious decisions that I just went over and bashed him in the head. This is not voluntary manslaughter. So that being said, when you go back to deliberate, you'll have this form again. We've already crossed off the ones that don't apply, so let's cross off the other one. Voluntary manslaughter with use of deadly weapon, because no one's gonna get up here with reasonableness and say that this was voluntary manslaughter. So then what are we left with? First degree murder. You were instructed that murder of the first degree is murder which is perpetrated by means of any kind of willful, deliberate, and premeditated killing. What are those three elements? Willfulness, deliberation, and premeditation. And I do have a graphic photo here, so I just want to warn everyone, including in the gallery, that there will be a graphic photo. This is first degree murder. What is willfulness? Willfulness is the intent to kill. There need be no appreciable space of time between formation of the intent to kill and the act of killing. What is deliberation? Deliberation is the process of determining upon the course of action to kill as a result of thought, including weighing the reasons for and against the action and considering the consequences of those actions. This is very important, and I am going to spend some time on this. A deliberate determination may be arrived at in a short period of time. The best way to illustrate this is the stoplight example. So all of us drive to work, we're on our way to work, and there's a stoplight. Sometimes that stoplight turns yellow. And when it's yellow, you're making some conscious decisions at that point, right? Either you're taking the decision to press on the brakes, but during that you're deciding, well, is someone going to rear end me, right? If I just stop on my brakes, right? Is my coffee that I just bought from Starbucks going to fly all over the car and I'm not going to have coffee at work if I slam on my brakes? Is my purse going to fly off the seat and I'm already running late for work? So how am I going to have time to put all the items back in my purse so I can walk into work? If I press on the brakes, I'm going to then potentially be late for work. And I've already been written up a couple of times, so this may be the time of fire. All of this is going on in your head when you're faced with that yellow light. You're also thinking, well, I obviously can't press on my brakes, right? So I'm gonna have to blow through this light. But what are you thinking about when you're going, making the decision to run that yellow light that's about to turn red? You're hoping there's no pop, right? You're hoping that a motorcycle doesn't come out from nowhere and you hurt someone. There's no bicyclist
She looks so young, y'all. I just had to say it.
that's just somehow hoping that you're gonna stop at the red light because they see that it's yellow. All of these are conscious decisions that you're weighing, and that is all deliberation in a short period of time. We do it every day. Again, it need not be for a day, an hour, or even a minute, this premeditation, this decision making. It may be as instantaneous as successive thoughts of the mind. The stoplight example. No matter how rapidly the act follows, the premeditation, it is premeditated. That is what happened in this case. When the defendant made each conscious decision ending Jonathan Willette's life. We also have another theory of first-degree murder. That's called felony murder. There are certain kinds of murder which carry with them conclusive evidence of malice aforethought. Therefore, a killing which is committed in the perpetration or attempted perpetration of a robbery is deemed to be murder of the first degree. So what is a robbery? You are instructed that robbery is the unlawful taking of personal property from the person of another, or in his presence against his will, by means of force or violence or fear of injury, immediate or future to his person or property, or the person or person or property of a member of his family. Such force or fear must be used to 1, obtain or retain possession of the property, 2, to prevent or overcome resistance to the taking of the property, or 3, to facilitate escape with the property. We heard a lot of evidence over the past 2 weeks, which is why I'm slowly going through this today. We have evidence that the defendant took multiple items of Jonathan's belongings. Social security card, a wallet, his only set of car keys. Why did she want those things? How is she gonna enroll the girls at school without having Jonathan's documentation? This all goes into her motive. The defendant obtained Jonathan's property by means of force or violence, i.e., she killed him, and took his wallet, his only set of keys, and his social security card. This is another easy one. That being said, you'll have your verdict form. And between both theories of murder, we are confident that you'll be able to check that first box and at this point eliminate the second-degree murder. But that being said, any way you look at this case, this is first-degree murder. And this is important to note, because when you go back there, you're doing an important thing. But what is also important is that while a guilty verdict must be unanimous, you need not be unanimous on the means or the theory of first-degree murder in arriving at your verdict. What do all those words mean? That means when you go back there and you're carefully weighing the evidence in this case, if 6 of you decide that the state has proven beyond reasonable doubt the felony murder theory, and 6 of you decide that it's the premeditated deliberate, that doesn't matter. The verdict would be guilty of first-degree murder. You need not be unanimous on the theory of first-degree murder. So there's been a lot of talk over the past 2 weeks about Devier, and we're not shying away from this. You saw him testify on the witness stand. There is overwhelming evidence beyond what he told you that Devier did not murder his father. Let's go through that. We'll start with Devier's testimony under oath. He tells you that he saw his father, Jonathan Willett, at that Porcupine Rim address, the house that he and Devin shared, briefly on August 6th. You'll recall that he saw his dad in the garage and just went right back inside. They never had a discussion. And he was home at the Porcupine Rim address on August 6th. He told you that he was helping the girls, his sisters, Devin's daughters, with homework. The defendant, Devin, tells him that she's going to help John move some things. He goes on about his night. He stays at the house, he watches a movie with the girls, he puts them to sleep. This is what he's telling us. He goes to sleep around 10 p.m. He woke up, he recalls around 2 a.m. to see Devin getting in bed, which they shared at that time, and he just went back to sleep. He woke up at 6 a.m. the next morning on August 7th. He gets dressed, he goes to work. Even if you don't want to take his word for it, which we believe you should, we also have other evidence to corroborate what Devier told you. This is a text message that Debbie sent to the defendant, Devin Michaels, where he texted her, "See you when you get back. I'm going to sleep. Girls are in the living room." Corroborating that he put the girls to sleep and he was going to sleep as well. This was on August 6th, 2023 at 10:36 p.m. We also have video surveillance to corroborate this. No video surveillance shows Devier's vehicles in Paladura's neighborhood. Paladura being the murder house neighborhood. No vehicles belonging to Devier are seen. And we spent a lot of time going through that video surveillance on that lengthier day of trial, showing you that there is no indication that Devier's vehicles are in that neighborhood on the night of the murder. There's no video surveillance showing Devier's vehicles entering or exiting Porcupine Rim neighborhood, the neighborhood he lives in with Devin. Remember that fixed camera? There was no indication that his vehicles left that evening. Or entered, for that matter. Devier's vehicle was in the same position overnight. You recall there was sort of that catty corner home that had that footage showing the daytime and the nighttime, and the van, Devier's van, remaining in the same position, to a T. There's also no video surveillance showing Devier jumping a back wall to get in another vehicle. There is no evidence of that. What we do have is Devier leaving in his work van at 7:31 a.m. on August 7th, because that's what happened. We also have the CDR mapping, which also rules Devier out, beyond his work. If you recall, there was that Detective Good testified pretty in depth. He had color-coded the different phones so that you could see with ease which phones were popping up at which times. You recall Devier's was green. We see green popping up at that Porcupine Rim Street, which is his home, throughout the night, and more importantly, during the time period of the murder, which we'll talk about later, because we are able to narrow that down. At no point do we see Devier at the murder house the night of the murder, and even more importantly, during the murder. Again, I explained this, I just want to show it. This is that footage of the nighttime. We see, if you recall, up in that top right hand corner, we see the victim's truck, Jonathan Willette's truck. We also see right next to it, Devier's work van. This is the night of August 6th. This is the next morning of August 7th. There's that same work van, Devier's work van, in the same position. Nighttime, daytime, nighttime, daytime. Never changing. Physics also ruled Devier out. A lot of discussion about how he jumped the back wall, he took the road that's one house over that, not the road, but the little dirt path, right, to get all the way across town. 7.5 hours? No. That's not common sense. I also think it's important to highlight Devier and the defendant's relationship, Devin's relationship. Devin is a master manipulator, and that is shown through the evidence. This is a woman in her late 30s that decided to begin a sexual relationship with her 19-year-old stepson, who had just lost his virginity. I'm not going to get up here and say that the 19-year-old teenage boy, this wasn't his dream to be with Devin Michaels, who was an older, more sexually experienced woman. But what I am going to say is that the defendant is the one running the show here. This was her fantasy, and he went along with it. For a while, though. Because remember, he tried to move away to California on multiple occasions, and somehow she was able to spin her web and bring him back. The most glaring portion being when she uses a supposed pregnancy against Devier to bring him back to Las Vegas. When she threatened him, I will have this baby and tell everyone whose baby it is if you don't move back to Las Vegas. So what does young Devier do? He moves back to Las Vegas. He doesn't want a kid at his young age and even complicate his relationship with his family that doesn't know about their relationship or their sexual engagements. There's also messages that show that Devin was in charge of this relationship. He tried to get out multiple times. So now that we've talked about this could not be Devier, let's talk about who's on trial today. Devin Michaels, the defendant, and how there is overwhelming evidence that she committed first-degree murder. I'm going to go over a roadmap of all the different evidence that you heard in the past 2 weeks and sum it up as much as I can. We'll start with Yoko and Yoshida's testimony, Devin's inconsistent statements, so her own words, the scene, the DNA, the burlap, which we heard about today again, CDR mapping, video surveillance, the phone contents, and we'll also talk about the custody case and those witnesses we heard yesterday. I think it's very important to start with the timeline because, as Mr. Giordani said, this one's a wild ride and we have to buckle up. So let me start with the timeline here. The timeline starts August 6th, 2023. Devin, John, the girls, they're all shopping for the girls' first day of school. At 8 p.m., Devin arrives at the murder house in her vehicle, and Yoko confirms this. At 8:42 p.m., Devin, the defendant, and John drive to Devin's home. At 9:40 p.m., Devin and John drive back toward the murder home. 10:04 p.m., Devin and John they get to Chevron. They're there for a few minutes, as we saw, and then return back to the Paladura neighborhood at 10:12 p.m. And that's even confirmed by Yoko saying that she saw Devin and John, and that's when John began to prepare a meal for himself. At 11 p.m., a person places something in the Nissan Armada, Devin's Nissan Armada, moves the Armada in front of the murder house. And what's notable about that, and I think it's important to highlight, is it went from being in front of the camera to being out of the camera, but more importantly, closer to the house, right in front of the driveway, and nose to nose with Jonathan's truck, which we see was in the same position the next day based on the surveillance, as well as the testimony from the officers in this case. We then turn to August 7th, 2023. At 1 a.m., Yoko runs into Devin for about 15 minutes or so. At 2:04 a.m., Devin leaves the murder home in her Nissan Armada. At 2:39, she's at that CVS drive-thru that we saw the surveillance video for. And then at 8:40 a.m., there is that 911 call from Jonathan's mother when she discovers her son dead. We can then safely say on this timeline that the murder that Devin committed occurred between 10:12 p.m. and 2:04 a.m. So knowing this time frame, we're able to look at the corroborating evidence. Let's start with Yoshida's testimony. The day before the murder on August 6th, he sees Devin at the murder house. And more importantly, he also saw her vehicle at Paladura. We heard from Yoko. Again, around 8 p.m., Devin arrives at Paladura in her Nissan Armada. Devin and John then leave in John's truck. Around 10 p.m., Devin and John return to Paladura. Yoko sees them. After seeing them, she goes upstairs. At 1 a.m., she goes back downstairs. She runs into Devin, and what did she describe to you? Devin looks surprised. Why? Importantly, Yoko also says that the light was on in John's room. Of course, you also heard that the way the bed was situated, you would have to walk into the room, down, and go around to actually see the bed. But regardless, she sees that the light is on in the room. Devin tells her that John started drinking and he went to bed. Yoko told you that she didn't hear anything from John's room. The light was on. Didn't really think anything of it. And that she and Devin talked and washed dishes for about 15 minutes. Because that's when Devin told her that Jonathan the next morning was going to meet her with the girls, and they were going to go ahead and go enroll the girls at school, take them to school. She confirmed to you that there were only 4 people at the home. Yoko, Yoshida, Devin, and the victim, Jonathan. At 1:15, she goes upstairs, she goes to sleep after having that conversation with Devin. Around 2 a.m., she wakes to the dogs barking in the backyard, and if you'll remember, that was abnormal. The dogs, when John was asleep, or at night in general, were not in the backyard. So why were they in the backyard barking? She also heard a thud. She then goes back to sleep. At 8 a.m., she goes downstairs, sees John's truck is outside, which is a little weird because Devin had told her that the plan was for him to already be gone by that time in the morning to go enroll the girls. So her antennas were up a little bit. She calls him, calls John, he doesn't pick up. Prepares her coffee, goes back upstairs. She called him again, no answer. So now her senses are heightened even more. So she goes back downstairs. She looks around John's room, couldn't see him, because again, the bed is sort of around that corner, as you saw in the photos. She then goes upstairs again. After going upstairs, again, feeling even more heightened concern, she goes back downstairs. And it's at this point she goes deeper into John's lower room, a makeshift bedroom. She sees the doggy door is down and the dogs are still outside, abnormal. She saw inside the garage door was half open, the one leading into the garage, abnormal. The big garage door was open as well, as you all saw in the photos. It had an opening there, abnormal. So then she investigates more. She goes to his bed, and she sees John wrapped in a blanket. She opens the blanket, and she saw feet. She then goes around to the other side of the bed and sees the amount of blood that's on the other side. Goes upstairs, tells Yoshida, they call 911. Devin also made several inconsistent statements. The truth is the truth, it should be changed. What were those inconsistent statements? The first one, Jonathan's engagement ring. If you recall in interview 1, Devin tells the officers, we threw his engagement ring in the trash last night. Okay. Interview 2, threw away John's engagement ring. We kind of made a joke of it, 2 points, threw it in the trash type thing. So it should be in the trash, right? We saw pictures of the trash, of multiple trashes in the Paladura address. Not just one, but multiple. 1, 2, 3, 4, 5. none of them containing a ring that were searched by officers. Ladies and gentlemen, there was no ring that was thrown in the trash. Inconsistency 2, her marriage to Debbie Air. We learned from interview number 2 that this was a marriage of convenience, not intimacy, which we know is not true based on other evidence in the case. Interview number 3, her marriage to Debbie Air is just on paper, rings aren't significant, me and Deb haven't been intimate in years. That's not true. Inconsistency 3, the gun safe. In interview number 1, Devin tells officers, we took the guns last night, but we didn't bring ammunition because there's no safe at my home for them. Ladies and gentlemen, we saw pictures of a safe. There was a gun safe in the home. There's a close-up of it there. And there's guns and ammunition. Gun safe in the home. No safe. Inconsistency 4, Jonathan's wallet. In interview number 2, she tells officers, John lost his wallet yesterday. He leaves stuff around a lot. Minimizing. Then we have interview number 3, which is after the search warrant of Porcupine Rim, where they start to confront her with the fact that there's Jonathan's items in there, more specifically his wallet. She tells them, at first, nothing of John's is in my house. John's wallet wasn't at his house, so do you know where it is? No, sir. I have all of his old driver's licenses. The license you found is an old one. We know that's not true. I tucked the wallet away in bags. I knew, but how would she know that the wallet was wrapped in bags in her underwear drawer? She wasn't confronted with that. Nothing of John's in my house. There was. His only set of car keys. His current driver's license. His wallet. And what was found inside her purse? Jonathan Willette's social security card. Why would she have those things? But nothing of John's at her house. Again, the license he found is an old one. And if we look here close up, it expired November 7th of 2025. The murder happened August 7th of 2023. This was his active driver's license. His old one. I tucked his wallet away in bags. Remember, ladies and gentlemen, this wasn't one bag. This was 8 bags, and you heard in the interview with Detective Weinoff that were tied over and over and over and over again. Not just one bag. What was she trying to hide? Also, how would she know? Inconsistency 5. Where was John? In interview 1, she tells officers that John was in the garage awake, smoking when she left. He was smoking when Yoko came down. But remember, Yoko said Devin told her John was sleeping off his alcohol. So which one is true? She says she said goodbye to him, pushed out a box under the garage, went out the front door. Then the next interview, last thing she did with John was pop his back. He went to smoke. She talked to Yoko, she finished loading, he told her what to take, and that was it. All inconsistent. And not the same story. Inconsistency 6. John's bloody phone found at Devin's home. There's a lot of discussion about this during the trial because it's important. And it shows that Devin committed the murder. And why? First of all, she told us in interview number 3, he told me he cut his hand. Okay? He said he was moving a table and one of the parts fell and took a chunk of his hand. She offers this to police. I didn't see it, but I do know he mentioned bleeding on his hand. Very descriptive. Then interview number 3. He must have been smoking and set his phone down. Again, no notifications are found on John's phone, as if someone manipulated it. Because as we know, John was called and texted multiple times, especially when people were trying to find him. Why would he have no notifications on his home screen? That's because the phone wasn't left by John. You know that his blood was on the phone. And we know that it arrived after the murder based on those CVRs. Based on that raw data, we know when John's phone made it to Devin's residence. And that's when she took it there because, as you know, it traveled with her after she committed the murder back to her home. This is also an important one. She tells detectives that it was dark in the room and she couldn't see when she committed the murder. In interview 4, we finally get her confession. She hit him. And that's when we get the details. But she tells us that she couldn't really see what she grabbed off the fireplace because it was dark, but she could see him breathing. She tells the detectives, because they're a little confused by that statement, because she can't describe the object in her very hand, but she's able to see Jonathan breathing. She tells him, well, your eyes can adjust. And remember, Yoko said the light was on in John's room when she came downstairs. It wasn't off. It's also important to note that he was wearing boxers. He had his boxer briefs on, she tells the police. And we know that's not true. The boxers were found at the foot, next to the side of the bed, as shown right here. She also can't really account for the time after seeing Yoko at 1 a.m. And this one's really important. In interview number 4, she initially tells detectives, well, I wasn't there for an hour after Yoko came down. That's not true. But then she's confronted that no, there is evidence that you were in fact there until 2:04 in the morning. So detectives trying to solve this case with the family is asking, what were you doing? What were you doing in that time frame? She remembers every detail before. She remembers every detail after you heard the interview. But she doesn't remember this time frame. Why? Because she did it. She was decapitating Jonathan. I can't remember. I remember talking to Yoko, getting my stuff, leaving, going to the pharmacy, and going home. But she doesn't remember the time frame that she was decapitating Jonathan. Why? She's told this has got to be eating you up. And this is why videos are so important. This is her response.
This has got to be eating you up. This has got to be eating you up.
She's nodding.
This has got to be eating you up.
This is eating her up.
This has got to be eating you up.
Ladies and gentlemen, she admitted to the murder. She said in her interview, when she confessed, that she took that object, the stick, the wooden stick, and bashed Jonathan in the head. That is the murder. But there was a head missing, and that was important to the detectives to give closure to the family. So what about the decapitation?
Well, you have to have something for the hour 4 minutes where you were in the house. That's it. That's the only time you don't remember.
I didn't know it was there that long.
It doesn't matter if you know.
Because that's what I'm saying, I don't remember being there that long, I didn't know I left.
Okay, so is it possible you did it, you don't remember?
Yes, sir, it is very possible.
Okay.
Yes, sir, it's very possible. The scene does not lie. Defendant can lie, but the scene can't. So what's the hard evidence as well, in addition to her statements that are inconsistent, other than the confession? As we know, John was found on this bed, and there was blanketing. And we also noticed that there were 2 blood spots specifically on that sheet that he was wrapped in. One on one side and one on the other, as you can see in that right-hand photo. She rolled him to the edge of the bed to complete the decapitation after she had realized she murdered him by hitting him, as evidenced by the 2 blood spots that we see there. In that last interview as well, there was a drawing, there was a diagram, there was a sort of a back and forth a little bit with the defense talking about that the detective was the one drawing, but I will leave it up to you to sort of see how that was going down. Devin drew that line there, and the detective told her multiple times, correct me if I'm wrong, is this where you were, where the X is? Yes, that's where I was. She drew him in the exact position she left him in. There's some truth. The DNA can't lie. We heard that Jonathan's cell phone was found at Devin's house during that search warrant of the Porcupine Run residence. And we heard from CSA Nicole Merriam, who testified twice, that she swabbed that blood spot right there on the phone, and the testing revealed presumptive positive for blood. It also revealed Jonathan's blood. It's also important to note that Jonathan's blood was found in the driveway of the residence. We have that marker A, which you can see there, the blood spots with the cone. And we also have marker B, which was that Jonathan's bed frame, where they saw those droplets of blood. All Jonathan's blood. It also is interesting where these blood spots are, because they're in the driveway in the same exact place Devin would have walked to go back to her vehicle to drive home, as we know occurred at 2:04 in the morning. Devin's DNA is on that knot of the plastic bag containing the wallet and John's only car keys. They also tested inside and outside of the wallet, including all the pocket openings. So the inside of the wallet also contained Devin's DNA. This wasn't Jonathan dropping it in a bag. Why would Devin's DNA be inside the wallet? Devin and John's DNA are on his social security card swab. Not shocking that Jonathan's DNA is on his social security swab, or social security card, I should say. But remember, this is Devin's bag. You see her wearing it in the surveillance video with the chevron. She also described it to police during one of her interviews. And what's found inside is that social security card belonging to Jonathan Millett. And not only is it found, but it's found with the defendant's DNA on it. She handled it. She wanted to enroll the girls at school and knew that she needed documentation because the father of the children was dead. We also heard from the coroner, Dr. Yagi. The cause of death, homicidal violence. The manner of death, homicide. The internal exam, and this is important, decapitation occurred post-mortem. Jonathan was decapitated by the defendant after she bashed him with the stick and killed him. Based on the science. No one's disputing that. Not even Dr. Sims today. This is also important. No bleeding injuries on John's hands were found. None. She did discuss slippage, which she explained what that was, where, after death, the skin tends to shed a bit in different areas. But again, no bleeding injuries on John's hands. Then we had testimony from Dr. Burns, who passed around those cool exhibits. Cass, I should say. And she explained that there were 2 implements used to decapitate the victim. As you can see in the picture there, this is her annotated version showing that there were 2 implements that were in fact used. A hand-powered serrated or non-serrated knife was the first. Then a mechanically powered.
I don't know who is doing it, but if whoever is clicking that damn pin, stop it. Do y'all hear it? I feel it. I can feel the driving me freaking crazy.
Saw, because it's very difficult to cut through human bone. Not only did Dr. Yagi and Dr. Sims agree today, but also Dr. Burns told you that the impacts that she saw on the neck were consistent with post-mortem dismemberment. Jonathan's head was decapitated after he was murdered. There's a lot of discussion during trial about whether it's possible for a woman to do this.
Yeah.
I think it's important to note, as Dr. Burns highlighted, a mechanical saw is made for anyone. Women can do anything, especially ones that have a clear motive. Moving on to the burla. Where was Devon's vehicle during all of this? Her Nissan Armada shows she's at Paladura during the time of the murder. We have at 11:05 p.m., there's that short activation that we saw on the burla, which I'll go ahead and play for you. And it is not very long. It's at 11:05 p.m. on that August 6th, 2023, which is corroborated by the video surveillance where we see her vehicle moving up right in front of the driveway of Paladura, nose to nose with Jonathan. Then we have 2:04 a.m. This is when Devon's Nissan Armada leaves. And we saw that in the burla. She goes from the Paladura address, she goes to CVS, then she returns home to the Porcupine Rim address. I won't play this all for you, you'll have this docket evidence. You've seen it during the trial. We also have that call detail record mapping. Where was everyone's phones during all of this? More importantly, where was Devin's phone during this? And we had Detective Good testify that the defendant's phone was at the murder scene when the murder was occurring. And what's also interesting to note, which you kind of have to get close to see, that there's sort of this blue dot that is now traveling with Devin's red device all the way back. And this was at 2:04 in the morning. So that's how we know that the victim's phone was taken by Devin back to her home, because we have that Google geofence highlighted by that blue dot there of Jonathan's phone, showing when it actually got to Porcupine Rim, and that's when Devin got it. We also heard phone content evidence, which demonstrates Devin's intent in this case. I worry as much as you probably won't believe. I miss us. I'm glad you appreciate what we once had. We will have it all again, Jonathan says. I want our family back. We gotta do as great as we can for the girls to have a good life. The walls were closing in. We have the video surveillance that was played for you in depth during trial. And there's some important notes from that. We saw how much video surveillance was canvassed in that Caladura neighborhood. There was a point where the detective even said he couldn't pinpoint the address that I needed him to because of all these contacts. Then we have that next door residence to the murder house, that 2696 Caladura Drive. Again, next door. And this is that video I talked about earlier where we do see the Nissan activated and we see it move in front of the driveway of the murder home, 2698 Caladura. We also see in this vantage point of the video when Devin and the victim returned home from that trip from Chevron. When they were coming from Porcupine Rim, stopped at the Chevron, got some items, then came back, and we actually saw those shadows of two figures, which would be Devin and Jonathan, getting out of his truck to go inside of the Caladura residence. This camera gives us that as well. And again, 11:05 p.m., we get that activation, and we see that the Nissan Armada is moved up closer to the residence. Why would she want to move it closer to the residence? She's concealing her crime. Then at 2:04 a.m., we also get from this residence that the Nissan Armada leaves, putting sort of a bookend on the timing of the murder. We then have the video surveillance from the Chevron. We've also called it the Terrible Herbs. And in there, I talked a little bit about this. We have that they're there at 10:10. That's Jonathan's truck pulled by a trailer. They then leave at 10:11 p.m. And we know that Yoko, as well as the video surveillance from the Caladura neighborhood, they're arriving into that neighborhood around 10:12 p.m. All corroborating, giving us our time frame. We have the video from the CVS pharmacy, the drive-through, 2:28 a.m. on August 7th of 2023. This is after the murder, where she's at CVS. Again, giving us a time frame. There's no one in that vehicle but Devin. You can see with your eyes. We then have the 6621 Gray Juniper surveillance video camera from Devin's neighborhood. This is that one that was fixed where you could see the only entrance and exit of the Porcupine Rim neighborhood, and it was constantly running. We were able to see different things from that. Remember, it was 3 minutes slow to real time, but accurate. At 8:57 p.m., we have John's truck entering the neighborhood. And this is on August 6th. Then at 9:29 p.m., John's truck leaving the neighborhood, further corroborating the timeline. Then importantly, at 2:39 a.m. on August 7th, after the murder, we see Devin's Armada and Devin returning back to her residence. At no point was Devin or Devier's work truck or that sedan seen entering or exiting. Very important. We don't see his work truck or any of his vehicles leaving until 7:31 a.m. on August 7th. So now let's talk about Devin's motive and intent, which is very important to consider. We heard from individuals that knew about the child custody case during this trial. And they told you that Jonathan had been given full primary physical custody of the two girls, Tamaya and Jamea. And this happened on October 27th of 2022. So at the time of the murder, Jonathan technically still had full physical custody of the girls. He had something he could hold over Devin's head. The walls were closing in on her. We also heard from Elizabeth Lemons Woods, who also had worked on the child custody case and sort of the placement of the girls after Devin was arrested. She meets with Devin on August 17th of 2023. She wants to tell the defendant, hey, heads up, I just want to notify you, the girls are being placed somewhere else because you're not there and their father is no longer around. And what Elizabeth Lemons Woods testified to is that defendant then started giving her more information, more than the scope of what the original conversation was supposed to be about. And what I think is notable is that Elizabeth says that throughout the conversation, Devin appeared that she was trying to cry. Why would you try to cry? Devin said during the same conversation, she had to do it. She had to do it. Now, ladies and gentlemen, it's very important, and you're in fact instructed on this, to use your everyday common sense and judgment as reasonable men and women. Do not check your life experience and what you know to be true at the door. Bring that with you when you deliberate. The evidence in this case is overwhelming. It's hard, and Mr. Giordani hit the nail on the head when he said, buckle up, this is a wild ride. This is unfathomable. But this is what happened. We are confident as the state that having all of this evidence in front of you, that you are going to go back to that jury room and you are going to check guilty of first-degree murder with the use of a deadly weapon, because the defendant committed first-degree murder under both theories: premeditation, deliberation, and also felony murder. Thank you.
All right, ladies and gentlemen, we need a moment to set up the technology for the defense's closing argument. We're going to take a brief recess. During this recess, you must not discuss or communicate with anyone including fellow jurors, in any way regarding this case or its merits, either by voice, phone, email, text, internet, or other means of communication or social media. You must not read, watch, listen to news, or read accounts or commentary about the case. You must not do any research, such as consulting dictionaries, using the internet, or using reference materials. You must not make any investigation, test, theories, case, recreate any aspect of the case, or any other way investigate or write about the case on your own. You must inform or trust anything regarding the case of the time sent to you. Ladies and gentlemen, it's 2 o'clock, we'll be in recess till 2:15. All rise for the jury.
Y'all. Y'all. That is just that woman. That woman talks so fast. I can't. So what do y'all think about that closing? I think it was a little bit too long in my her personal humble opinion. I got to anchor this down or I'll lose the thread. Got about 4 more hours at least to get the beadwork done, and then I got to put the sequins on. So I hate to say it, but that may be a glue gun. I don't want to have to glue it though. I don't like glue gunning materials. As a don't. Give me a second. Okay, y'all. We're getting there. I got to do this whole side here. From my finger, all of this. But I only got 1/4 to go. I think it'll be all right. Can't afford to spill the Oh, what you think, y'all? I'll probably wear it back a little bit. I don't know. I don't know, Joe. Where's Joe Schmo? But look at that. Where be Joe Schmo? Can anybody tell me where my Joe Schmo is? I could wear it like this and be kind of stylish. Hey, as my girlfriend would do. You know, I could kind of really wear it kind of purposefully, kind of like way over here on the side and be kind of like, y'all, look at that. This actually has the hardboard in it. I actually, the normal ones you get from school are kind of like a foam core. Pulling off my headband. I don't want to do that. They're kind of like a foam core. This is real mortarboard. Really? It's not too simple? Not too simple? Let me do it that way. Kind of simple. If I have time, I'm going to take these from the blue here and stair step them and bring them to a point. Otherwise, I don't know. Misha no sa. Misha no nada. All right, I'll take a break with y'all. Give me a break. Give me a break. Break me off a piece of that Kit-Kat bar. Who remembers all that? If you're old enough to remember that, I like you. If you're not, oh well. All right, y'all. So we are in court for a few minutes. I need a cookie. I don't need. I want something sweet. Kind of getting tired. My coffee gets cold too quick. Even in these thermal things. Ah. Going to LiveCom. Okay, I don't have the new bingo on LiveCom yet. Angela, congratulations. So, June, can you post a new? They did the jury instruction hearing already earlier today, June. So I got that. So we only have one bingo. They did show the defendant interview. They did mention an article of clothing. I'd be at the boxer shorts. I need to get my microphone a little closer. I'd be at the boxer shorts. And they did say something about where's the head. I don't know about that. What about that, June? Do we want to do where's the head? In a minute, I'll go get my feather because I'm going to have to attach it. I got to bring it in anyway. Now everybody's all bingo, 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 bingo. B-I-N-G-O, 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 and bingo was his name. What? What? I know, June. I'm just going to go ahead. Why don't we just go ahead and include the closing? Oh, okay. So, y'all, I tried. The boss lady has spoken. She spoke. I have to obey. Y'all. I'm sad. A bingo. Okay, bingo. Well, if you've bingoed in the game, you should have at least one or two. Miss June and I have the same card, so we both have two. So, yeah. Did you bingo? Okay. June set up an event today. We do have a event this evening. The event this evening is a Friday night movie. It's called The Cover Up. The story centers around a mysterious death of repeated drunk driving offender tracker and a discovery of his body in an alley behind the Marshalltown, Iowa Police Department after his latest DDUI arrest. So we got a movie tonight. It is 8 p.m. Central Standard Time, 6 p.m. West Coast, and 9 East Coast, 8 Central, 7 California time. Come join us for the movie. It's always a good thing. We always enjoy doing the movies for y'all. We love putting the movies out there for y'all. Yes, we do. We love movies. Movie. I need someone to come on and help me entertain y'all. It's hard. Where's Joe Schmo? Where's Mr. Joe? Hello, Wall. I'm saying hi to some people. We've got multiple things. By the way, if you haven't subbed, please sub. Do you know why we need subs? Do you know why we need subs? We are literally 6 away. Oh, that's that back there. We are literally 6 away from 3,500 subscribers. Come on now, y'all. Please help us get 6 more. No, excuse me, 8 more. Got the glasses on. We are 3,492. We need 8 more subs in order for us to be able to say we're a 3,500 club. Y'all, I was hoping to get to 5,000 by the end of the year. I'll be happy with 4. Y'all, we get to 4,000 at the end of the year, I'll dye my hair. Temporarily, that is. Get me to 4,000. That's 508 new subscribers. Are we watching for another trial to start tonight? No, honey, this is a movie, Friday night movie night. That was about the movie that we're going to be watching. Oh, good, glasses are clean. Don't look at my wrinkles. These bags, that's no sleep. This is the movie's called The Cover-Up. The story centers around a mysterious death of repeat drunk driving offender tracker and the discovery of his body in an alley behind Marshalltown, Iowa Police Department. Purple? I'll do some purple chunks or something. I did pink when I hit my 1,000. Oh, do I need to worry about EDB? Yeah, I was born before her. I liked purple before her. I liked these earrings before her. I wore baseball caps before her. I did everything before she did, except for this. Okay. I look like I'm haggard and exhausted and tired, so I'm going to use the help of a good old friend. Oh, that looks so much better, doesn't it, y'all? You love purple. I love purple. You love green. I love it. No. I'm just tired, y'all. I got to figure out and wash an outfit for tomorrow for my graduation pictures. I got to finish this cap. I've got to get ready to be out of town all day. I got to charge the batteries for the camera. Yeah, I know. I got a lot to do, you. It's always risky taking down that camera. Because if it don't work when I get back, this chick is in deep chite. I wonder. I wonder, as I wander out under the sky. Of course it is dead. Of course it is dead. And I need some cunt. I wonder how this camera would look, because it does video, instead of that little one. That might be cool. Mic. I got GPS, HDMI, AV in and out. But I got to charge these batteries. And all my batteries and everything are in the car. Everything's in the car. Okay, that's not what I need, but that's for that one. Oh, hallelujah. Maybe, maybe not. Nikon battery charger. But it's not fitting. Is this an... Oh, it's got to go in there like this. Oh, hallelujah, hallelujah, hallelujah. Oh, hallelujah. I got it. Yay. Yay! So we'll get the battery charger. Get them charged. And then I need to get memory cards to put in here. So I can get ready for my pictures tomorrow. My daughter has a friend of hers that's going to help me with my pictures, but I told him I would bring the camera. I told him I would bring my camera. Oh. I haven't used this camera in a long time. A very, 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 very. Okay, we're going to get back to closing arguments. They're just now starting. Very, very long time.
Please be seated. Your Honor, the jury is all present and accounted for.
We are going to go back on the record and see 377-239 State Development versus Judge Michael. Later, record reflect that Ms. Michael is present with her attorneys, deputy district attorneys on behalf of the state. We both parties speaking with the presence of our jury.
Yes, sir. Yes, Your Honor.
Okay, Mr. Justice, are you prepared for your closing argument?
Yes, Your Honor. Thank you.
Whenever you're ready.
Thank you. This case is entitled the State of Nevada versus Devin. Proof beyond a reasonable doubt is the highest standard in the American justice system. It shows an adoption of a belief that we took from the old common law from England, that it's better to let 10 guilty men go free than to wrongfully convict an innocent person. I would also submit to you that it shows a belief and an understanding from the founding fathers that very few people have the resources, the opportunity, or the ability to prove their innocence. You've seen that through the course of this trial. You have officers come in, collect evidence, and officers are people. I'm not going to stand before you and say this officer's a bad person. We talked about it through jury selection. But officers make mistakes. People are subject to biases, to confirmation bias, where they reach a conclusion first and then kind of work backwards. And I would submit to you that that is what happened in this case. And our founding fathers understood that. And that's why they placed the burden upon the state and the state alone to prove its case, each and every element of its case beyond a reasonable doubt. I'd like to talk a few minutes about the jury instructions. We had a few technical difficulties, but you all have the same packet. I'd like to discuss just a few of these instructions. I'm not going to tell you which boxes to check. You're smart. You paid attention, very close attention throughout the entirety of this trial. You are the sole judges of the facts. You alone will decide what will happen to Devin Michaels. Instruction number 3 talks about murder with use of a deadly weapon, and that's what the state wants you to convict her of, first degree with use. But the pleading document is telling. Instruction 3, it states murder with use of a deadly weapon. Did willfully and lawfully, feloniously, with malice aforethought, kill Jonathan Black, a human being, with use of a deadly weapon, to wit, a wooden stick and or other unknown object. By striking the said Jonathan Willett with said wooden stick and or other unknown object, and or through other unknown means. And then it lays out the mental state. It has to be deliberate, premeditated, or of all things committed during the perpetration or attempted perpetration of a robbery. The following instructions in this packet lay out, after you've assumed that Devin has killed somebody, her mental states. Instructions 6 through 16 talk about all the different mental states required. That's after you've determined that this person did the killing. There's even a number of instructions concerning robbery. It's instructions 17 through 20. You see, in the state of Nevada, we have what's called this felony murder rule. It's a shortcut. It's maybe basically getting to the shortest distance between 2 points to convict her of first-degree murder. There are, however, other instructions that I would like to spend a little more time on. And again, you are the sole judges of facts. You will review these instructions. But unlike us, who had this case for some time, this case is new. You were introduced to this case when we all met and began talking at the beginning of last week. There is an instruction concerning expert testimony, instruction 33. Please look at that. There's a common sense instruction. And I'm going to flip to that. It's kind of telling. Both parties generally point to this idea of common sense. Again, shows the wisdom. Instruction number 34. Although you are to consider only the evidence in the case in reaching a verdict, you must bring to the consideration of the evidence your everyday common sense and judgment as reasonable men and women. Thus, you are not limited solely to what you see and hear as the witnesses testify. You may draw reasonable inferences from the evidence which you feel are justified in light of common experience, keeping in mind that such inferences should not be based on speculation or guess. A verdict may never be influenced by sympathy, prejudice, or public opinion. Your decision should be the product of sincere judgment and sound discretion in accordance with these rules of law. As I go through my comments, and trust me, I'm going to leave things out. It's inherent in the process. Please use your common sense. You've taken good notes and you've paid attention. Please review the exhibits and don't take my word or that of the state of Nevada. Reach your own conclusions. Review the evidence. There is an instruction that I think is of paramount importance in this case, and it's instruction 32. It concerns the credibility or the believability of a witness should be determined by his manner upon the stand, his relationships to parties, his fears, motives, interests, or feelings, his opportunity to observe the matter to which he testified, the reasonableness of his statements, and the strength or weaknesses of his recollections. If you believe that a witness has lied about any material fact in the case, you may disregard the entire testimony of that witness or any portion of his testimony which is not proved by other evidence. I read this instruction to you with Deviere in mind. You know, we started this case talking about motivations. Motivations dictate actions. Deviere is not on trial. You know, this case is not going to be, well, did we prove our case against Deviere better than they proved their case against Devin? Devin is the only person that's on trial. We have gone through the evidence in good faith, and I'm going to discuss that a little bit with you today in my summation, that there is evidence to believe that Deviere committed this crime. But you don't have to believe that to acquit my client. But I would submit to you that you should take that into consideration. The ultimate determination that you will make is the sole judgment of the facts, whether the state has proven this case beyond a reasonable doubt. Through the course of this case, and as you know, when we talked about it, we wouldn't have to ask a single question, present a single line of testimony. State fails to prove their case, she's entitled to a verdict of not guilty. But as this evidence has unfolded, I would urge you to see that perhaps the detectives in this case, the Henderson Police Department, were basically trying to choose the shortest distance between 2 points. I mean, hey, we knew, and we all know, and we're not making issue that she was with him on the night in question. It's easy to reach a judgment like they did. She's guilty. But you, as jurors, must consider all of the evidence. Because unlike when you read in the paper, so-and-so's caught, oh, and you think, yeah, he's guilty, she's guilty, you determine whether a person is guilty, not the police and not the state of Nevada. I would urge you to read the reasonable doubt instruction. A defendant is presumed innocent until the contrary is proved. This presumption places upon the state the burden of proving beyond a reasonable doubt every element of the crime charged and that the defendant is the person who committed the offense. And again, this is why we have addressed what the evidence reasonably shows concerning Debbie Eyre. A reasonable doubt is one based on reason. It is not mere possible doubt, but is such a doubt as would govern or control a person in the more weighty affairs of life. And what more weighty affair of life do you have than to sit on this jury on this type of charge? If the minds of the jurors, after the entire comparison and consideration of all the evidence, are in such a condition that they say they feel an abiding conviction of the truth of the charge, there is not a reasonable doubt. Doubt to be reasonable must be actual, not mere possibility or speculation. If you have a reasonable doubt as to the guilt of the defendant, she is entitled to a verdict of not guilty. Since this is a charge of murder, I'd like to begin my comments, and I won't be long. I mean, we've been here a long time, but this is important. Let's begin at the autopsy. We had Dr. Sims. He was the lead coroner here in Clark County for 19 and a half years. You heard his testimony. It wasn't much of a cross because he didn't say much to be disagreed with. We did, however, hear from Dr. Yagi. Do you recall the question that was posed to her? Would you agree with me that a decapitation is difficult to effectuate? Remember her answer? I don't know, I've never done one. We heard from Dr. Sims that yes, it would be difficult. It takes a lot. It's involved. Dr. Yagi missed the tattoos. It was in the report. We had Oriental John. That kind of goes to the weight that you should give her testimony and the thoroughness of her examination of the body. The state's relying upon Dr. Yagi's statement, her testimony that there was no injury on the hand. You got to consider the source. Dr. Sims testified the cause of death cannot be determined without evidence of injury, and he was talking about standard practices. Obviously, these are very suspicious circumstances. In fact, if John was murdered, it's very reasonable to assume, common sense would dictate, that the person that killed him decapitated him. And through the course of this evidence, they have not shown a scintilla of evidence that she was involved with a decapitation. She didn't do it. Determination of homicidal violence cannot be used when in large part that fatty liver or drugs and alcohol are present. He was talking basically about the industry standards, what experts in this field collectively agreed upon. And we saw a variation in this case from Dr. Yagi. In this case, we did have a combination of all three. You heard the testimony about 20 times the level of THC, alcohol in the body. 0.02 was the alcohol in the blood, but Dr. Sims testified that that in conjunction with this high level of THC would cause a person to be intoxicated. That's important in this case because you will hear testimony concerning her concern, Devin's concern about not letting him drive. As you recall, we went through all those texts beginning back in 2018 concerning Yoko's concern. And again, I don't want to speak ill of the dead, and it was no showing of disrespect towards her, but it was an ongoing concern that she had. She didn't want her son driving drunk, and that concern was shared by Devin. She had his key. She took the key to the house. That's not evidence that she committed a murder. This is extremely important, and there's been a great deal of issue made concerning this video evidence. As you recall, through the course of Deviere's testimony, I read it to you at the beginning of the trial and read it to him, where basically we had a detective, it was the 12th of September, telling him, you're under the radar. We're here to clear you. I mean, when you look at the radar, when you look at this net that was cast, it has so many holes in it. The state would have you believe that both homes were under 24-hour surveillance. It's just not true. The evidence of Detective Lippish and the other detectives show that. The state expects you to accept representations made by Detective Lippish regarding the true time of the videos from this residence. And I want to start there. This concerns the state's timeline, which I would tell you flies in the face of common sense. But it's important to take into account how this evidence was gathered. You recall the list of times or the videos that were shown? He supposedly didn't, it was on a neighbor's cell phone. We saw no logs. We saw no indication of the veracity or the accuracy of those times. The state's basing this idea that she's pulling up in front of the Paladura residence and is somehow moving her car at 11:04 to avoid detection. You have to take this detective at his word. And again, I'm not necessarily saying he's lying, but he did a sloppy job of collecting that evidence. And this is the video evidence that I'm referring to. Remember, there was no embedded data here. We don't have time. He would have you believe that the vehicle is moved at 11:04. We don't know what time this is occurring. We do know that the vehicle perhaps was moved from the Burla, but we don't know the sequence of events. As you recall, and you will have the evidence, there was various blue lines showing triangles, and we heard that through the positioning of the GPS, you have movement, even if a vehicle is in one place. We don't have specific times, and we really don't know the order of how things occurred. We would urge you to believe and to consider that common sense would dictate that this was when Devin left the residence at 2:04. There's going to be a close-up here. You'll have a computer screen. Zoom in on it. Here you see the interior of the vehicle. You see Devin getting in. You see a bag on the passenger seat. And she leaves. Please pay close attention. And again, not that I'm trying to tell you to do, but we've had this case for much longer time than you have. Look at the video evidence from 6505 Taylor Creek. Detective Lippish testified several times that he could only speak to items that he canvassed for, but he was happy to testify concerning other detectives who went unnamed that collected this evidence. It's clear from the testimony of the forensic examiner O'Brien, whose credentials and whose testimony went unchallenged that we presented to you today. He testified that one of the 3 videos was compiled from a series of screenshots, which the Ring camera is set to capture by default in the absence of video activity. Where are the other screenshots? They only gave us 3. I'm not going to stand here and point the finger and say that this was done in bad faith. It was done out of sloppiness. Why weren't subpoenas issued? Why don't we get the complete record? This woman is on trial for murder. We heard nothing concerning them going to the third-party providers, Ring, Google, other parties. No, they're relying upon the cooperation of neighbors who are living their own lives and who very well may be indifferent to the gravity of this situation. Didn't give us the full picture, and that was the video that had constant, I mean, you got a good scene into or a good view of the residence. It's incomplete. We just have these 3. And again, this is at the new residence where it's been referred to. Porcupine here, we've got the truck. You know, there's been an argument made that Devier had to have been in the home the whole time. Based on what? Because the entrance to the neighborhood with the continuous camera doesn't show a vehicle. There's other ways to leave that residence. There's a walkway next to 1 house away. There's over the fence. This is something that's been discarded by the state, but again, I would submit to you that it goes to what Devin is thinking. It goes to her innocence. She starts trying to contact Jonathan on the morning of the 7th, starting about 4 a.m. She'd left him. She'd left him at the residence. The plan was that they were going to take the girls to school that morning, and we have evidence, and you've heard uncontradicted evidence that that's what she did. The message she leaves him is concerning the girls' school supplies. She's letting him know that their daughter was sick, because we know that she's at that pharmacy, and it's a 24-hour pharmacy at 2:28 a.m. That's what went on. She hadn't killed him and decapitated him. She was worried about getting her daughters to school that morning. She sends messages of concern when he doesn't respond. The state claims, and again, this is where common sense comes into question. The state claims that Devin was answering Jonathan's phone from the house the morning of 8/7/2023. You heard the argument concerning the notifications. We did hear from Detective Skinner that they didn't put it on airplane mode. Those notifications wouldn't have shown up. That evidence, like so many other pieces of evidence, were mishandled. But the state's going to have you believe that she purposely took the phone from Paladera to Porcupine Rim and leave it out on the driveway, and at the same time be calling it and answering it and leaving it on the driveway. That flies in the face of common sense. She took it and left it there, and then is answering it and calling it to provide some sort of an alibi. She's lucky that in this very slipshod investigation that she has as much evidence that she does to present to you that she didn't commit this crime. Crime scene, the footprints. There are footprints in the backyard. And we have, and I'll show you the photos, we marked them and had them admitted. We have this, the Henderson Police Department documenting these footprints, but then trying to basically throw shade on that, saying, well, they could have been there for some time. They weren't important. When you look at the photo, you can see that they're fresh. They wanted to argue that they're male or female. They didn't do any follow-up. There was no footprint comparisons to anybody's shoes in this case, much less Devier's. You recall Yoko's testimony, there were 4 dogs in the backyard. If that footprint had been there for very long, common sense would dictate that the dogs would have walked through it. They would have been sullied. They weren't. They were fresh. Again, they were not analyzed or tested. And there it is. And Detective Ozawa just kind of discounted that and said, well, we don't know how long they were there, but apparently no one really looked at Yoko's testimony and Yoko's statements. 4 dogs were out there for most of the night. This was a big point of contention. And again, these aren't red herrings. These go right to the very heart of the case. There was no blood cast off in the bedroom. In spite of evidence, uncontroverted evidence, the mechanical powered saw was being used to decapitate Jonathan. You recall, Coroner Yagi went so far as to try and compare a beheading by a mechanical tool there at a crime scene, and Dr. Sims took issue with this. She tried to compare that. These crime scene analysts tried to compare that to the dismemberment of a body under controlled conditions by specialized tools in the morgue, bodies that have been refrigerated. But nonetheless, she testified that they still wear protective goggles and aprons to protect themselves from this cast-off. Luminol, we heard no testimony whatsoever that luminol was used by the crime scene analysts. That would show indications of blood or attempts to wipe it up. Nothing. What's clear, and it was kind of laborious at the beginning of this trial, was Yoko's testimony, because her testimony was so crucial to the timing of this case. There were some difficulties with the interpreter. However, I'd submit to you, she speaks pretty good English. It was important to memorialize what she told officers the morning of in the 40-minute conversation, as well as what she testified to the grand jury. She testified that she saw Devin at 1 a.m. and Devin didn't have any blood on her. If you follow the state's timeline, it's sometime around then, and it's unclear, she's involved in this murder and decapitation. She stated that no gloves were worn by Devin when she met her at 1 a.m. And you recall the testimony concerning the dishes and the alcohol bottles. And there were some issues concerning Jonathan's level of drinking. 15 minutes. She testified that the light was on. That brings to question the veracity and the reliability of the statements through her multiple interviews that Devin made to the detectives. There is no blood visible on Devin's shirt at the CVS drive-thru pharmacy. And thank God that she stopped there, because again, we have real time. We have real evidence that shows that she didn't commit this crime, and not some detective's opinion. There's another issue concerning this, the mixture of ammonia, bleach, the stench. Remember that? We heard that the first responders, that they said that the smell got worse the longer they were there. If we're to believe the state's timeline, this is smoking for 9 hours. That flies in the face of common sense. Ammonia evaporates quickly. And again, your common experiences. The state never, and one of you posed a question to Dr. Sims. Again, it's the state and the state alone that bears this burden. Where was the expert to talk about that? That was important. This case was out of the ordinary. It's clearly gruesome, but because it's gruesome doesn't make that woman guilty. It isn't evidence that she committed this crime. Here we are, 2:27 in the 24-hour pharmacy, and you'll have this. Look at her. She's sipping her water. Apparently this is after she's murdered a man and decapitated him. She's reaching out of the vehicle. No marks, no blood, nothing. And Sims testified that this would have been messy. So she's just decapitated, she's murdered and decapitated Jonathan, and she's making sure that she picks up her daughter's medications on her way home. There was a very good question that was asked concerning, was there any stops? There wasn't. There were no, her vehicle didn't go to any isolated areas, to any trash bins. There's been times when I've gone through moves and I've gone behind the bonds and dumped trash out in their dumpsters. There's no evidence of that because it didn't happen. You know, the state will have you believe that there's this bucket of blood that's the reciprocal of all this blood that's squirting out when she's sawing his head off. What did she do with that? If she did, the car didn't go anywhere. She went home. There's no rags. There's nothing in that vehicle. We do know that they recovered, and this is based in part of the video that we saw from the terrible herps. You know, again, I don't want to point fingers, but her life is on the line. They didn't do their job. There was no direction of what to get and when to get it. We heard from Detective Lippish that he got that video evidencing her clothes around the 11th of August. That warrant was served on the 7th. We didn't hear much about what they picked up on the 15th. They made a big deal about the shoes, the swoosh, but we showed you evidence in the photographs, and it's in evidence of the black shoes with the white soles. I mean, she gets arrested on the 15th. Game over. It's done. According to Yoko, and this is important, and I read the statement to her because it was so dispositive. She said Jonathan's room was a mess. And there's this kind of a feigning of not understanding. And I said, man, these are your own words. And I read her own words to her. During her initial interview, she stated that there were 2 chairs flipped upside down. That's evidence of a struggle. But then we don't see that on the body cam. What happened? We don't have that in any diagrams of the crime scene. But when she spoke to police and thank goodness it was recorded, she talked about 2 chairs being flipped upside down. And obviously her memory would have been far better at that time than it would be now. But again, you know, there were some questions by the state. You were traumatized, things were terrible. I'm sure it was. But the veracity of the statements and the accuracy of the statements shine through. She was trying to help law enforcement and give them clues concerning who committed this murder. There's no reference made in Devin's statements about chairs, about a struggle. Jonathan was killed after she left. What's kind of weird is that there were 2 belts tied together on the ground near the bed. There's been no explanation by the state, and we can't give you one, but something's going on in here. Crime scene GPS. Devin's car is trackable. We know that she didn't stop. You know, she was there that night, and that's why she was charged. Her phone is trackable clearly. No deviation is made to some remote location. She went to the pharmacy and went home. There's no anomalous stops, and this was brought up by you. She gets the medication and gets home because her girls have school early the next morning. The timing, and this is obviously where timing is very, very important. We do know when they leave the terrible herps. You see 22:11. We know that when they got home, they spoke to Yoko. We don't know how long they spoke, but do you recall Yoko's testimony? Her words were, it was a very good day. She'd known for months that they were getting together. They were trying to unite the family. And you know what? No union is perfect. Hey, we all know that. There are ups and downs, but she and Jonathan had a union. You know, the state in their first closing, they're going to get a second one, try and paint her as this devious, manipulative, conniving temptress. But think about that. The flip side, a 19-year-old. You know, when we talk about motive, what drives a person to murder? Is it not passion of a young man? His first love? His first love that's coming to an end when dad's coming in and moving him, the dad that he said was never there for him. You know, it's kind of an archetype, you know, the father that's killed by his son. I mean, it's in, I believe it's Isaiah 38:18. We've got these Greek stories of it, Oedipus. I mean, there's various variations of that, but it's an archetype. Saturn. It's known, and it's as old as the human condition. Fathers are sometimes killed by their sons, and that's why we wanted to underscore, and we spent a great deal of time in our opening statement, because we didn't know where it was going to go with Devier, but we knew that they'd had a relationship that had been kept clandestine. Devier covered for Devier, and Devin covered for Devier. This is important. I would submit to you that this is a more accurate and a more reasonable timeline. Yoko was awake. 10:58. There's a 44-second call to Devier from her phone. You recall, we get the text, and you want to talk about an alibi type text, putting the girls to sleep. It's 10:36. I'm going to bed. That has been refuted by facts. He testified here that, well, maybe he woke up at 2. That was the first time. Previously, he had testified before a grand jury that he got home, put the girls to bed, went to sleep, woke up, Devin was there. That is a lie. Why would he lie? What motivation would he have to lie? He's a fairly smart young man. I mean, he was kind of catatonic here, and understandably so in the witness chair. But again, we need to look at motivations, because motivations, they author actions. At any rate, we knew the night before that Devin had been there late with Jonathan. But after we were to believe that he's asleep at 10:36, we've got a 44-second call from Devin's phone to Devier. 8 minutes pass. 11:05, we get that 10-second burla in the Nissan Armada. It may have been moved. You're to determine that, because I'll tell you, we really don't know. The evidence is not reliable. Whether it pulled up and stopped, or what we saw there was Devin leaving, we don't know. States to provide that to you, the timeline. They haven't done that due to this slipping through the cracks in the slipshod investigative work. Now, an hour and 55 minutes pass. Yoko is awake. There's no suspicious noises or activities. And we have a 15-minute timeline. Because you recall, Yoko's into time. She corrected me. She looks at the clock. They talked for 15 minutes. And it was kind of like pulling teeth. She admitted about the dishes and the alcohol. They talked for 15 minutes. We're to believe that, and again, this goes to Devin's statement and reliability after she's subjected to interview after interview. Yoko says the lights are on. The state would have you believe, apparently, that Jonathan's dead. She struck him in the head and he's dead. Meanwhile, she has this 15-minute communication. Again, no blood, gloves, chemical smell, any of that on Devin. At 1:15, Yoko goes back upstairs. And you recall yesterday, that was kind of rebutted Lana's testimony. They kept hitting her with that hour and 4 minutes. That's why you don't talk to the police. That's why you have a right to remain silent. One thing that we have learned is don't talk to the cops, especially if you're the target, because they're going to take what you say and they're going to twist it. Yoko was equivocal in her testimony when she testified before us. This time, and she's just testified once before a grand jury, she's equivocal. She was awake the whole time. She looked at YouTube. She went to sleep. It's equivocal. But at 2 a.m., for the first time here, she says she hears the bang. And I think we had the prosecutor bang his hand. She never talked about that before. But still, may have happened. 2:04, Devin's leaving. Maybe it was the door closing. We don't know. That's her testimony. But you have to evaluate her testimony. But again, this is really kind of shedding light on this timeline. She previously testified that she heard dogs at 3 a.m. She brought it up 3 times during her police interview. Apparently she felt it was noteworthy, and she testified to that September 14th before the grand jury. Yeah, the dogs are barking. It's 3 a.m. Someone's put the dogs outside. The facts, taken as a whole, and not this little piece here and this little piece there, show that this murder, and you know, it's silly to say a murder didn't occur. Obviously it did. It happened after Devin left. The facts, taken as a whole, bear that out. Again, you've heard, and it's uncontroverted, Devin leaves at 2:04. You know, what's of note is that presumably Yoko went to sleep after she went upstairs. Part of her testimony previously is that she was awake during this whole time. Where's the testimony of a mechanically powered saw? It happened. It's more reasonable to believe that that happened after 3 a.m. We don't know when it happened. She didn't do it. The dogs were outside barking. Somebody's in that house. Somebody has killed Jonathan and somebody is cutting his head off. Again, what kind of passion does that take? Not an on-again, off-again relationship that Devin had with him. It's a person that's enraged. You know, well, watch the TV, the police stories. They talk about stabbings are personal versus a shooting. What's it going to take to cut a head off? And what kind of anger and what kind of resentment is that going to cause to for someone to do that? You know, there's been a great deal of argument made and points attempted to be scored that Devin did that because she'd do anything to get her kids. It was uncontroverted that regardless of what was going on with family workers, she had those girls from May 27th on. She had them all summer. And when we talk about motivations, we know that Jonathan was moving in. There was talk of marriage. And, you know, they want you to believe that the rings weren't there. Look at this investigation. Look at the photographs of the trash cans. I believe one was Exhibit 68. We have no evidence and nothing to show that they emptied that. And no, why would they take a picture or preserve a ring? They didn't preserve anything else in those trash cans. It's easy for them to come in years later and say, I didn't see a ring. There was no notations, and they go through hundreds of crime scenes. When they were there, you know, when Miss Wilson was there, they were looking for weapons. They were looking for evidence of a murder. They weren't looking for rings, and they're asking you to convict her on this shoddy police work and have you believe that Devin's lying about these rings when there is no indication that they were looking for rings. This is the state's only evidence that she committed this murder and this decapitation, because you got to put them together. Common sense would dictate whoever did one did the other. The interviews of Devin Michaels. I'm gonna focus on the third interview.
And then have you guys ever had a sexual relationship?
Yeah, we had.
Okay. But it's not there now?
No, I can't even have sex now.
This is important. This isn't something that Devin is making up. You have her medical records. The time, 12/5/22, vaginal hysterectomy. She's had surgery. She's not having sex. She's telling the detectives the truth.
We've got that. Is there any reason why Joshua or anything DNA related would be in your vehicle? Because that, I'm sure back to our station, our CSA, they're gonna thoroughly look for everything in that vehicle.
I couldn't tell you. If he was bleeding from when he was doing the thing, he helped load up the truck. So if he was bleeding, it might be
Or your
my Armada. Like, he was putting the things in the car, like anything else
Sure,
he had.
there's gonna be obvious areas where blood doesn't belong even if you're loading. So I'm just asking you directly, because if you find any DNA evidence in that vehicle, obviously we wanna make sure we ask you if there would be a reason.
No, the only thing I knew he said was his hand that he hit on the table. That's the only time he ever said he was bleeding, and he said it got a pretty good gash.
But you didn't see that.
No, I did not, so I can't really speak on it. But he was still loading everything up, so I don't think it was really bothering him that much.
This is the inside of the Armada. With the testimony from Ozawa, it appeared the vehicle had just been washed. That's been disproven. The burla shows that that didn't happen. The location coordinates show that that didn't happen. Look at the inside of this vehicle. I know my partner, Mr. Horvath, had asked Detective Spangler, well, was it very clean inside? I think he made a reference to teenage kids, something along those lines. This isn't well kept. I've seen much worse, but it's not well kept. The important point is we're to believe that there's buckets of blood in here. There's bloody rags. There's a head, a murder weapon, a saw. There's nothing in there. They sealed this vehicle and they took it off. If you're to believe that she murdered and decapitated Jonathan, you're to believe, common sense would dictate that there's going to be some indicia of a crime in here. Taking buckets of blood because they weren't at that residence. This made reference, and again, nobody understood the significance at the time. Miss Miriam didn't, but there's the table that she talked about. It was a moving day. Injuries do happen. We're to believe, again, Dr. Yagi's, the reliability of her testimony. She said there was no bleeding injury. Well, we've got an injury right there. Whether it's bleeding or not, we don't know. But that's sign of an injury. And remember, this is the same doctor, the same coroner that said John didn't have tattoos on his arms. Big point was made about the telephone. And we're to believe that Devin is so sophisticated and so cool and so cunning and so informed that she can murder this guy, decapitate him, not leave any evidence, and then drop his phone in the driveway. More reasonable explanation, it's tired. She's got girls that are going to school in the morning. She's been carrying things, it's late. She obviously brought the phone, whether it was knowing or not, we don't know. It appeared that it had fallen on the side. She tries to give an explanation. You recall about the cigarette butts? She didn't know the phone was there. That's why she was calling the phone, following up with Jonathan. She knew he wasn't dead because she didn't kill him. Another thing that was a big point of contention, sometimes little things can have very large implications. Remember the issue about the blood on the screen? Papakostas, the DNA expert, testified that she couldn't confirm that it was blood. There was a presumptive test, but the confirmatory test, and some of you are far more knowledgeable than I am, it was not She couldn't confirm that it was blood. So then the state recalls crime scene analyst Miriam to apparently discredit their DNA expert in reference to the blood. And this is the entity that's charged with proving this case beyond a reasonable doubt. They're calling a crime scene analyst on a presumptive test to discredit the DNA expert who gave testimony, uncontroverted testimony, concerning the lack of a confirmation for this blood. We know that John's DNA is on the phone. I would submit that it is somewhat significant in determining whether the state's proven this case. Devin's isn't. It was handled. Maybe there weren't epithelial cells left from Devin. Clearly, Devin took the phone, knowing or not, and I would submit to you that given the circumstances and the chaos of a move, she didn't know she had the phone. It's not evidence that she killed him. Just like the key, it's not evidence that she killed him or the wallet. She's going to go through all this work to leave this, this crime scene spotless or clean and not leave anything behind, no blood, nothing in her car. That she's going to drop the phone and then make calls to it. This is what the state is relying upon, this interview. And you recall the tenor of this interview? Please don't just look at one part or another. Listen to the whole thing. The power dynamic. You've got two large men. You've got a woman who they had said, we Mirandized you earlier today. You have to ask yourself what went on. What happened before this interview?
John? That was John there when you last saw him? Yeah, but he had his boxers on. Okay, he had his boxers on. I don't know, he had his boxers on. His boxers were black boxer briefs. He had boxer briefs on. That's what I'm talking about. This shit's getting real. Keep looking at that. Take another look at this.
This was into the interview, and it was a fairly lengthy interview. She'd had multiple interviews before. We heard in this interview that they had told her previously that day about the decapitation. So there's more going on. She knew. You know, it's at 16:01, and it's interesting that the state showed you the exhibit, the one that she supposedly wrote. When you look at the original exhibit, it says handwritten by Devin Michaels. It wasn't. She drew a line, and that's significant. It was Detective Christopher that wrote that. And again, this is in the crises, in the crucible of a very confrontational interview. She didn't author that. And I'm assuming that Mr. Giordani is going to stand up when I sit down because he gets the last word. He's going to say that somehow, how could she have known that? She hadn't been shown the photos. This gentleman had seen the photos, and he filled in those details. And she's sitting there having been arrested previous to this interview and facing the horror of being accused of a crime, a murder that she didn't commit. Here's the boxers. Why lie? Why lie? When she left, he was wearing those boxer shorts. She was consistent in that. Why choose that hill to die on? She was telling the truth.
Have you had moments in the past where you have been stuff where
Yes.
this happened?
Yes, there's things in my past where I cannot remember. And yes, I have talked to my doctor about it. Yes, they're trying to figure out what's going on with me. Yes.
Okay, you don't have to tell me if you don't want to, but what is wrong with you that you say that
I
you're trying
don't
to be
know,
right?
they're testing me now. I went yesterday, for whatever reason, my brain tingled and I blacked out. And I literally have it on documentation from the doctor, and they're trying to figure out what's going on with me.
This interview was on August 15th of 2023. This condition that she's talking about It's documented 6/7/2023. New patient established her patient she feels like tingling, vibrating in the back of head, comes and goes, denies headache, has dizziness. This isn't some ploy. I mean, she's in this high pressure, confrontational interview, and she's trying to give as truthful information as possible. She's had some problems. This isn't some defense where, oh, she blacked out and didn't know what she did. She didn't commit this crime. She didn't commit this decapitation. She's had some issues that she's been trying to address. And again, she's being truthful to these detectives. It's confirmed.
Absolutely. You're and everything you can't even have the audacity to give them closure. Shame on you. That's terrible. Yeah, you know, the children the other day. Also, there's some anger now, huh? I told you from the beginning I didn't. Is that how you feel against him? No! It's not how I feel against him.
She's pushing back. She's been interviewed over and over again. She's telling him, I've told you I haven't done this. What we're dealing with now is a woman that's denying that she committed this murder. You know, it'll be up for you to determine whether she hit him in the head when he was grabbing her leg. She was consistent that he was alive. He was breathing. There's no evidence that she hit him in the head. And again, given this, we know that when people are confronted, they'll try and give something to appease the other party, this power dynamic. She was trying to give. In this interview, you'll read, they threaten. What you do here is going to determine what happens with you and your daughters. She gives a little, but then snaps back and says, I didn't do this. And she's expecting, through all these interviews, for them to pick this up and do their job. But they'd already made their minds up. You heard from Lanai yesterday. In their minds, she was guilty. That's it. And we're dealing with this investigation that you heard from Sean O'Brien, 3%. We're dealing with 3% of the information that was available on those devices. But still, in that 3%, we've been piecing together what really happened. We do know, and it's clear, incomplete Celebrite reader files. Critical database files are missing from the phones. Now, years later, we're trying to piece together a defense to defend a woman that didn't commit this murder. There's artifacts which would indicate a need for further investigation. And Sean O'Brien testified that generally, as he's been a forensic analyst, he's been involved in law enforcement. There's supposed to be this back and forth. Hey, get us this. You know, as this investigation develops, we need more information. There was no indication that that occurred in this case. She's at the house. She's the low-hanging fruit. She's guilty. The end. All investigation stopped. Image of Devin and Deviere. And again, we would like to have more, but we can show you this image. Now, all the images that are available on a cell phone, I think I probably have 4,000. You know, it's going to be the state's position. Well, this is just randomly popping up. Devin had said that he was asleep, or Deviere had said that he was asleep at this time. He testified under oath. He lied under oath. Look, there's a Discord chat application, 231. This is telling. You know, the state can play 3 phone calls from the girls who are adorable. Those were all after 11 o'clock. We have no proof where Deviere is. But we have 2 indications of 2 artifacts at 2:12 a.m. and 2:31 a.m. that he's up and he is engaged. There's a deliberately deleted file. This is the image. 2:12:38 a.m. This is after there's been 3 calls from the home phone that night to Devin. 3 of them were the girls. What about the other 8? But of all images, at 2:12:38 a.m., this is being looked at on Devier's phone. Game box. Again, and this is important, this was not preserved, this was overlooked. There's photos, he was a gamer, they had issues. Gamers are on their game platforms and they talk to other people. We have a Discord file, there's a remnant of that. He's using that at 2:31 a.m. in the morning. He's up. He didn't drive his car over there, and again, I can't tell you for certain if he committed this murder. But he could have easily gotten out of the house, and he's not going to walk. He's going to talk to a fellow gamer. We now know that he's up, and he's lied. He's lied under oath. What does he have to lose? I mean, he was able to avoid the motives through the course of this investigation concerning getting kicked out of his house and losing his wife, who he, based upon all the photos, and we didn't have to go through those, you saw them, he was in love with her. But we do, in this 3% that's available to us, we can show you that he was up. Not 1 indication, but 2. And given the nature of that photograph, the multiple phone calls that were made earlier, and now we have this Discord, we have a remnant that he's on an app. It's not too hard to imagine that he went there. Those are the facts. And the timelines, you recall the detectives that for the Henderson Police Department that testified, they set out timelines, but they didn't do a more in-depth analysis. And this is what our analysis, with only 3%, we were able to show he was awake. This was deleted, it's there. I'm not saying that was that night, but that's something that should be taken into account, headed there now. He's there in this area, and you'll have the exhibit. He's next to a remote area. Don't know if he had a job there or not. This is the morning after 8/7/10/25. You know, when detectives interviewed him, he'd said, hey, I've been drinking. We don't know if he'd been drinking all night. We don't. He's a drinker. He's in a remote area where, and obviously there's been no testimony, there's been no investigation in those wash areas. We know he was over there. We know he was up. We know that he was looking at a picture of him and Devin. You know, it's, you see on the crime TV shows about motive, means, and opportunity. He had all 3. He had the motive. He had the means. He didn't walk there, but he was talking to somebody. Clearly, he had the opportunity given the timeline. But again, I'm not going to stand before you and say he did it. We don't know. She didn't. These were texts that were between him and his father. You have nothing to tell me, WTH or TF. I thought you were my seed. If what I can know, I can't fuck with you, or that's true. Devil shit. It was clear, and he tried to smooth things over through the course of his testimony, but Devier did not like his dad. He had an affair with his dad's girlfriend. You know, these things don't reflect too good on her, okay? They reflect poorly on Devin. But Devin's not here for good moral character. You can despise the choices that she made, but you can't convict her for murder, for a murder that she didn't commit. This is their home. The home that he's being kicked out of. Again, there's the walkway down the side. There's a way to get out the back. There's no cameras that were pulled on Rebecca. We don't know. The police did a slipshod investigation. We can't show you him walking away. They didn't collect the evidence, but the motive would point to Devier. This gun there was an issue made concerning that. That gun was looked at the afternoon of, I'm sorry, that's another gun. There's guns in his possession. We don't know if that person was shot or not. Jonathan was. The swords, again, we're not trying to throw these things out, but this just shows a conscious indifference on the part of law enforcement in collecting evidence that could exculpate her. Their minds were made up. She was guilty. There's so much evidence here that you can go through and look. Again, thank you for your patience. Thank you for your attentiveness. You know, this is the last chance that we'll have to speak. There's going to be things that I have overlooked, things that I missed. Don't hold them against her. Hold it against me. You remember the movie 12 Angry Men? The jury went through and exonerated that young man. I'm going to ask you to do that, to look at the facts. You may not be comfortable with a verdict of not guilty. She's done some bad things. She didn't commit this murder. She didn't kill him and cut his head off, because those two things are combined. Common sense would dictate that they are. She's not guilty of this charge. Thank you.
State, are you prepared to give your rebuttal argument? Ladies and gentlemen, because the state has the burden of proof, they are allowed to open and close the closing argument.
Let's talk about reality. I want to commend my colleagues over here who represented Ms. Michaels first, because they've done an exceptional job. And Ms. Michaels is entitled to a fair trial, like we talked about in jury selection. They've done a good job of coming through and poking as many holes as they can in the evidence, and I commend them on that. But make absolutely no mistake, that woman is guilty as sin. That family deserves justice. Those girls deserve justice. Do not take this lightly just because a real polished defense attorney gets up here and spins a yarn for you. Do not take this lightly. Those people deserve justice. If I were to tell you that a defendant confessed to a crime, described how she did it, everything she said matches the crime scene, except for the part where she minimizes or potentially blacks out the aftermath, you would say, well, that's pretty damn obvious. And some of you were probably sitting there when we played that confession the other day, yesterday maybe it was, or the day before, and go, why didn't you guys play this 2 weeks ago? We could have kind of sped this process up. Maybe you're thinking that. Because we have to show you that the cops did their job and she is overwhelmingly guilty. We wouldn't be doing justice to that family right there if we just played that confession and walked. And we didn't. We put 2 weeks worth of evidence up here to show you Debbie Ersher didn't do it and she did. There is no reasonable doubt in this case whatsoever. And I want to address kind of an elephant in the room. You know, Mr. Draskovich just got up here at the very end and he told you those two things, common sense dictates those two things go together. And I kind of agree with that, right? The person who killed him probably decapitated. But make no mistake, she's not on trial for decapitation. She's on trial for murder. She told you she did the murder. Now, she minimized it. She told the detectives that she hit him over the head and he was still breathing. Of course she did. But she admitted to the act that caused his death. Are we really, as reasonable men and women, going to believe this was a fatty liver or a marijuana overdose? Are you kidding me? That guy was murdered, and then his head was chopped off. And here's the elephant in the room. I don't care if you, for some reason, believe Devier somehow snuck out of his home like a ninja, crossed town, and cleaned up the job. I don't care. She's not charged with decapitation. Look at the pleading document. She's charged with killing John. That is it. That is your job. Did she kill him or not? And the answer is absolutely yes. I need to show you a couple instructions because they're important. Bear with me. I know you're probably tired because we all are. But this is too important to just gloss over. This is a beyond a reasonable doubt instruction. Mr. Draskovich addressed it. I want to tie this into another instruction. Doubt to be reasonable must be actual, not mere possibility or speculation. Instruction 31, direct versus circumstantial evidence. The top part is really important. I'm going to address that in a minute, but this one down here that's underlined is also important. You must not speculate to be true any insinuations suggested by a question asked the witness. So a question is not evidence and may be considered only if it supplies meaning to the answer. So everything Mr. Draskovich said through the course of this trial was a question, right? It was a question. That ain't evidence. So you tell me what piece of evidence, what single piece of evidence suggests Devier did this? Not one. Not a one. And when you start accusing an innocent guy of murder, Devier, you got to think about this for a second. That young man was taken advantage of. And like Miss Griffith said, it's not like he wasn't enjoying it and liking it and into it. No doubt. Mr. Draskovich in his opening statements suggested that Miss Michaels has a history in the adult film industry. Did you ever hear me ask that? No. Did you ever hear me or her mention that? No. Because Mr. Draskovich is right. She's not on trial for having doesn't matter. The only reason that does matter is because it dictates that relationship with Devier a little bit, colors it. She is an experienced woman, much older than Devier. He's a young knucklehead, and I would submit to you that when you heard from him, no disrespect, but that guy's not a criminal mastermind. He's not somebody who snuck out the back of the house, evaded all cameras, left his phone behind because he was thinking ahead to what he was going to do, somehow made it all the way across town, even though he didn't have his phone to contact anyone. There's no Uber notifications or pickups or anything suggested. There's no calls, no texts, nothing after 11 o'clock. So who did he contact and when? There's no evidence that Devier was involved in this. None. There's actually evidence to clearly refute it. You heard those voicemails, and we can agree those little girls they're precious, they're adorable. Those voicemails eliminate this alternative suspect, which I will refer to as a scapegoat, because that's what's happening to him. He's being scapegoated, and it's not right. Those little girls said on those voicemails what Devier was doing. He was knocked out, probably passed out, if we're being honest. And you didn't hear any other voicemails afterwards. You saw more calls from the landline. If Devier had got up and snuck out, because we know the one little girl is awake and panicking and like scared, and where's mommy? She should have been home a long time ago. Where's mommy? Wouldn't there be another voicemail where they're calling going, Devier left us? Like, really, Mom, where are you? Of course there would. Of course there would be. And there isn't. That's because Devier was home. And you know that because he texted and he said, I'm going to sleep. He's no criminal mastermind. His phone is at home. There's no evidence his vehicle's left. There's zero evidence that Devier is involved in any way. Zero. And so Mr. Draskovich brought up a good point with the instruction that Miss Michaels is the only one on trial. That's instruction number 36. I want you to think about this for a second before you let a guilty person walk. Okay? Think about this. Imagine if I were to stand in front of a bunch of jurors and try to prove Devier's guilt. Imagine that. That's not what we're doing here. That's not what this is about, but imagine that for a second. Can you think of a single piece of evidence I could, with a straight face, present to a jury and say Devier did this? A single piece? other than speculation and really good questions by a really polished defense attorney, there is not a piece of evidence. I would be laughed out of the courtroom if I tried to prosecute Devier for this homicide, because he didn't do it. He had no reason to do it. Go look at the text messages between him and his dad. We included a bunch of them. Did he worship the guy? No. Did he hate him? Who cares? He didn't kill him. There's no evidence to suggest it. He says throughout the text messages to his dad, hey, what's up? You'll see it. There's like years of it. There's 2 years of it. And then those texts that Mr. Draskovich just showed you with the devil shit, I would submit that's a reasonable thing when you learn that your son is having sex with your ex or is married to her. That's reasonable. But then, you know, they left out a text that's right after that where dad is reaching out to Devier like months later saying, hey, this wasn't some big, you know, homicidal relationship between dad and son. Now, when you're thinking about motive like that, you've got to think about this defendant. She told you in that interview with Detective Lina and Christopher why she did it. She said it clear as day. I didn't think he was really going to move in. The walls were closing in on her, and she made a real horrible decision. A real bad decision. She said that she very specifically got up. He was down on the bed getting a massage. Got up because she was a little pissed off, I think were her words. Maybe don't quote me on that. Something like that. Walked across the room, grabbed this heavy blunt object, bashed him over the head, and he went limp. That's a confession to homicide. Okay. On top of that, she told a DFS worker, when you're thinking about motive, in the context of losing her children and homicide specifically, which she brought up, she said she had to do it. She had to do it because that's how she felt. And I'm going to answer or try to answer a couple of unanswered questions for you. We all get this evidence before trial. You know, we're all obviously somewhat prepared. I'm not like tooting our horns, but we're prepared. We know the evidence when we come into this case. There were clearly going to be unanswered questions in this case, right? There's a missing head. There's a missing murder weapon. There's missing implements, no doubt. But think big picture, forest from the trees. Think about reality, right? Criminals ditch murder weapons all the time. Criminals try to cover up what they've done all the time. Just because she ditched the head and therefore the doctors can't confidently say what injury did it, does that mean she gets a reward? Like, does she get to benefit from the actions she took to cover up? Of course not. Does that mean we can't convict her of murder? Of course not. And that is why I asked Dr. Sims those questions earlier. I didn't challenge his credentials. Like I've dealt with him on cases before, as you probably noticed, and he's a smart enough guy. He's very educated, but he's not disputing that a blunt blow could kill a man, right? He is saying exactly what Dr. Yagi said, the decapitation is post-mortem. And you know what he didn't say, which should be very notable for you, that there were other bleeding injuries on the body, including the hand, right? Because there weren't. He didn't say that because there weren't any bleeding injuries to the body except for up here. And that's how we know she did it. That droplet of blood, you can go back and forth about the DNA analyst not confirming it's blood. Well, DNA analysts actually look at DNA profiles. And DNA is in every single cell of your body, including your blood. And so, no, a DNA analyst is not going to come in here and say, John's blood was on the phone. She's going to say, John's DNA was on the phone because she's a DNA analyst. That's what that is. John's droplet of blood being on that phone convicts the defendant even without her confession. Set those, two confessions actually, because she told the DFS worker she had to do it. But set those aside for a minute. There are no bleeding injuries on his body, except for up here. The phone left at 2:04 with a droplet of blood on it. That means the murder happened before 2:04. It had to. Nothing
Rolling, rolling, rolling. Man, that head went rolling. Hi ho.
else would make sense. Nothing else would make sense. She, the defendant, traveled with that phone. Okay. So then you got this other big glaring unanswered question. How could someone be capable of doing that? That question, I can't answer. Okay. This is reality. It happened. I would submit to you that there is a chance that what she said about that hour and 4 minutes is true. Maybe our psychology major could talk about this. But I would submit to you that she may have been genuinely telling those detectives the truth, that she didn't remember chopping John's head off. Because this is beyond anyone's wildest dreams. Violent beyond all imagination. And there is a good chance she blocked it out. That doesn't mean that she walks out the door because she says she can't remember. It convicts her. There is no way she didn't do this. The evidence is absolutely overwhelming. And I need to address a few points because I just can't leave them unsaid, so please bear with me. Mr. Draskevich called into question Devier's testimony, and I want to bring this back for a minute. I think Devier is pretty well excluded. He walked into this courtroom, and I want you to remember that I asked him the question, did we bring you back? We didn't have to arrest you or anything. He came back willingly. He flew here, right? He brought his girlfriend, a little more age appropriate now. I guess he's learned his lesson, but walked in the courtroom willingly with that big old camera and all you strange faces to him. And he sat on this witness stand. He swore an oath to tell the truth. He got up here. He testified. He looked at his wife. He looked at all of you. He looked at me. He looked at the marshal with the gun and the badge. And he testified to the best of his ability. Now, I am not and will not endorse his character. I don't know the guy. I've met him a couple of times because he's a witness. But you got to see him tell you the most intimate details of his life. And I asked him straight up for a reason, and I did this early in the trial because we just learned he's the defense. Put him up early, and I asked him, did you kill your dad? And he said no. Now, I know he's a stranger to you, and you can't just accept his word, but you've got to consider the circumstances and what it took for him to do that, to put himself in front of the world, and testify about all this. Willingly. He came back. We flew him back from California, and he came in here and he answered questions from a very skilled defense attorney for however long he was on the stand. Think back to that. Did that kid strike you as someone who snuck out of his home, plotted this big old thing, and killed his dad and then somehow covered it up? Or did he strike you as someone who got himself in a bad spot, his words, tried to fill some shoes he had no business filling, and made a series of mistakes in relationships? That his testimony from the stand has to be considered in context. And it's all corroborated. Now, I would submit to you that if he came up here and he said every word consistent, precise with everything he said over the last 2 years, then you might rightfully be a little suspicious, like, oh, what is he studying for this? He had some inconsistencies. We don't shy away from that. He's not perfect. I asked him a question. I think the word I used was tumultuous, and he's like, what does that mean, sir? I don't know what that means. He's not a criminal mastermind. No disrespect to Devier, but he's not a criminal mastermind. He's a scapegoat. Don't let that happen. Need to address our pleading document. Mr. Draskovich brought this up, so I just have to address it. So you heard in the beyond a reasonable doubt instruction, it says the state must prove every element of the offense beyond a reasonable doubt. This is a legal pleading in Nevada. We are permitted to use unknown means and manner of death and unknown deadly weapon. This goes back to what I was saying earlier and what Ms. Griffith said about the deadly weapon instruction, where it says the state is not required to recover the deadly weapon used and present it in trial. There's a reason for that, because like I said earlier, this happens all the time. We don't reward criminals who are smart enough to get rid of the weapon. In addition, we don't reward criminals who are smart enough to get rid of the head after they crush it. That's why we are legally permitted to do this. Unknown object, unknown cause. Only question is it murder? Is it not? Did she do it? That's it. And it's absolutely first-degree murder. Mr. Draskovich brought up the robbery instruction, or the robbery pleading felony murder stuff. So I need to address that as well. Instruction 18. So when you first heard the charge read by the clerk, I'm sure you're like, what do you mean by robbery? This doesn't really, it doesn't really make sense. This doesn't really seem like a robbery, but bear with me a second. Taking property by means of force is a crime. The motive and reason behind it is separate. So yes, she took his wallet, his keys, and his social. We're not saying she took that for its value, right? It's not like the traditional robbery. The evidence says she took that for a reason, and it all comes down to one thing, and that's the girls. She took the Social Security card because she knew she had John out of the way, and she was going to make some changes and live the life that she wanted to live. So it is by law a robbery what she did. She killed someone, took their property, but we're not saying that she took the property to take the property. She took it because she wanted the girls and she wanted John out of her life. Instruction 29 is the motive instruction, or we call it the motive instruction. Motive is not an element of the offense or the crime charged. We're not ever required to prove motive, but you're permitted to use it to color kind of the facts of the case and determine whether there was a motive that could lead you to convicting on the crime. I've addressed motive a little bit. I just want to kind of wrap up that idea with this. John and Yoko and his side, they had a very different understanding of the moving situation than the defendant. Okay. She didn't want it to happen. Go look at the text, especially the ones that Ms. Griffith showed in her closing. John is continually saying, I miss my girls. I miss my girls. I want you girls back. We need to put this family back together for the sake of the girls. And go look at the defendant's responses. Those ones that Ms. Griffith showed. One was, I'm glad you appreciate what we had or how it was back then. And then that last text she put up where John is saying, we need to do this, we need to have them under the same roof, she doesn't respond. So go look at those when you're thinking about motive and tie it in with the last statement, the confession. There is no doubt that both sides have been aware of this potential for a move. What I would suggest to you, the evidence says, is that she didn't want John moving in, and John did. John wanted that. And it didn't become real until that night. And you know that because of the conversations with Devier. He's still there. He's literally still living there. So if he was going to be moving out for John to move in, why isn't he moved out already? That's because no one expected John to try to make the move that night. And that's when the walls started closing in on her. She's thinking in her head, I want my girls back. I want my girls. That's it. This guy can't move into my house. That's not what I want. She wanted him out of the way. And she did what most reasonable people wouldn't do. She made the decision to take a blunt object and bash him in the head and kill him. I want to address a few things with the defense expert. Mr. Draskovich showed a couple of cameras and a couple of texts or activity, 212 and 230. One's a Discord, one's a photograph. Remember what their own expert said. That wasn't active activity. That could have been background activity. It could have been active. He can't say that. So whether Devier woke up and activated his phone at 212 or 230, well, that just tells you he's still at home. And if it's just background activity, then who cares? Either way, it's not good for the defendant because it rules out Devier. It's either with his phone or it's a nothing burger. Mr. Draskovich talked about the boxer shorts being off, and I already mentioned this. The defendant may very well have blocked out what she did after she killed him. And whether she took the boxers off or not doesn't really matter. It's probably very likely that he was naked when they were having this massage situation, but the boxers being on scene have no real import in this case. Mr. Draskovich talked about the CVS pickup, and I got to address that. So he said, and he showed you the video, there's no blood on the defendant in that drive-through. Now, we all watched it together. I don't see any blood from here up from what you can see. But do not forget, that shirt was never recovered. Neither were the shoes. Now, I'm not arguing to you or suggesting that I know what the defendant was wearing when she decapitated him. She could have been naked. She could have put John's shirt on. She could have changed her clothes, a number of things. But what I am telling you is that white shirt, from here up, maybe no blood on it, but it's never recovered. So we don't know if there's actual blood on. Mr. Draskovich asked you a question and I need to provide an answer. He said, is that a woman picking up this medication for her girls that's just done this, has the wherewithal to have just done this and go pick up medication? Yes. Yeah, that's reality. You heard the voicemails. The little girl was saying, you were going to get my medication. I'm not saying that the defendant is a bad mother. I will not say that. That ain't right. She took her children's father away. That's a bad thing she did. But did she care about her girls? Obviously. She stopped to get medication? Obviously. That doesn't exonerate her in any possible way. And neither does the post-homicide messages she sent to the victim's phone in the early morning hours. There's two very real explanations for those messages. Number one, you already know the extremes she went to cover up what she did to his head. She took it. That's extreme. She poured chemicals. She took a bunch of stuff from the scene, probably a towel too that was on top of him when she did the chopping, it's not outside the realm of possibility that she sent a text and made it look like she thought he was alive. That's certainly not unreasonable. The other explanation, as I've intimated to and pretty much said directly, is that she doesn't remember the real bad stuff. And legitimately, in her mind, he was still alive after she hit him. Because from then on, she blocked it out. So take those text messages for what they are. They're either she's alibying herself or covering up, or she genuinely doesn't remember the wet work. That's what that is. I have to mention the timing of the big confession, not the one to the DFS person, but the big confession. If this is all, there's no evidence to say this, but according to Mr. Draskovich, this is the defendant covering up for Debbie here. If that is true, why does she confess after she's arrested? Right? She's already been arrested. Debbie has gotten away with it. Why does she confess after? Unless it's what happened. Mr. Draskovich showed a couple of videos, the small movement off screen. Remember the 2696 video? He showed the small movement off screen, and I believe he said, I'm sure it was just misspeaking, but I want to make sure it's clear, that was the 204 movement. That was not. That, according to the detective, that was the 11 p.m. movement when it goes off screen. And we know that for a fact because the Burla shows that exact movement at 11, or it's 11 or 11:04, I can't remember. The 204 footage on that video is when you can't see the car, it's already out of frame, but you can see the lights turn on and it leaves. And then that is also consistent with the Burla, so just needed to clarify that. I want to briefly address the girls. So you didn't hear from them in this trial. You can probably imagine why we wouldn't want to put them through anything more than what they've been through. I would just ask you to, that's my decision. I live with that decision to not call them. But I would submit to you that you heard everything you needed to hear from the girls in those voicemails. Devier was home. Devier was asleep. That's it. I need to briefly address this DNA stuff. So Mr. Draskovich made a point about the swords, the shower earlier in the trial, not an argument, but no blood being in the Nissan Armada and the footprints. And I just want to take this to its logical conclusion. So say we swab the swords and any one of the three's DNA is on it. What question does that answer for you that hasn't already been answered? If Devier's DNA is on it, it's, well, he's handled the swords before. If the defendant's DNA is on the sword, it's, well, she lives in the home, of course her DNA is on the sword. If John's DNA is on the sword, it's, well, yeah, those are his swords and they were just moved from his house in the move, right? That doesn't answer an actual question in the case. DNA being in the shower. The defendant's been to the home many times. Have we found her DNA in the shower? What is that going to change for you? Absolutely not. No blood in the Nissan Armada. There is so much evidence of her covering up her acts at the crime scene. It should not be shocking to you that she could have wiped up some blood if there was any in the Nissan Armada. We know from the patterning at the scene, and you look at it for yourself, the blood on the ground, there is something she used to collect that head. There is a very straight, clear line on the border of that blood that suggests that something caught that head. And whatever that was, she took it with her. And when the defense says there's no stops along the way, we agree. But what they can't say, no one can say, is what she did when she got home. And you may remember that many times, different witnesses talked about it being trash day. It is not very hard to walk over 2 homes or 3 homes and dump a bag or basket or whatever it is in a trash can. And, you know, I got to address the investigation. Now, the detectives are all learning this stuff as the investigation goes along. They didn't have the burla and all that stuff when they go to Porcupine Rim on August 7th. Should they, because of they did know there was a head missing, should they have checked every trash can in the neighborhood? Yeah, probably. But they didn't. Okay. That doesn't mean that she didn't dump the head in the trash can. And that doesn't mean that this investigation gets the case thrown out or the defendant acquitted. These detectives actually did a pretty darn good job of follow-up investigation. When they suggested that she was the convenient shortest distance between 2 lines, I disagree with that. Because remember, they found all that stuff in her home on August 7th. All that stuff, highly suspicious, blood on the phone. Did they arrest her then? No. Could they have? Yep. They didn't. They went and did mountains of follow-up investigation. All of that confirmed the suspicions. And then she confesses after she's arrested. It's too important to miss anything, so bear with me. I know it's getting late. Almost. Instruction number 35 is important. In arriving at a verdict in this case as to whether the defendant is guilty or not, the subject of penalty or punishment is not to be discussed or considered by you and should in no way influence your verdict. I want you to take that to heart. There's a phrase that's commonly thrown around in this courthouse. It goes, admit what you can't deny, deny what you can't admit. I'll say it again. Admit what you can't deny, deny what you can't admit. I want you to think big picture, forest from the trees, just one more time. When there is a confession and DNA and mountains of phone evidence and video surveillance, what could the defense possibly do? She's covering up. The only thing that these very skilled defense attorneys could say in this case. We, luckily, have a mountain of evidence to disprove that. Admit what you can't deny, deny what you can't admit. They were painted into a corner. I commend them on their job, but what they did is they blamed an innocent person for a homicide he didn't commit. And I don't want you to blame the defendant, Miss Michaels. I don't want you to judge her based on whatever her past. No one's asking you to do that. I also don't want you to take into account whether she's a good person or a bad person. She seems like she has some good qualities about her. seems like she's trying, to be a good mom. You must not make this decision based on sympathy or a popularity contest. Mr. Draskovich, very likable. We're not here to do a popularity contest. This is real stuff. Okay? Real stuff.
He wanted to
Do
say.
not think about whether you think she deserves a little leniency or redemption, or this is a one-off. She lost it. None of that matters for you. That matters for the judge, Judge Jones, who in her wisdom will sentence the defendant, not you. That is not your calculus. Your job is simple. Did the defendant do it or not? That's it. Please remember your oath to follow the law. It's my understanding the judge is going to let you stay a little bit after to deliberate tonight. I'm sure you might get instruction on that, but please don't take this lightly. This is important to more people than just the defendant. She is guilty beyond a reasonable doubt. Guilty of homicide. Thank you for your time and attention these 2 weeks. We really appreciate it.
I'm now going to ask the clerk to swear in the officers to take charge of the jury and the alternate jurors.
You do solemnly swear that you will keep this jury together in some private and convenient place, that you will not permit any person to speak to them, nor speak to them yourself, unless it be by order of the court, except to ask them whether they have agreed upon a verdict, and that you will return them into court when they have so agreed, so help you God.
All right, ladies and gentlemen of the jury, as you know, a criminal jury is composed of 12 members, and there are 14 of you who are here. That is because 2 of you will serve as our alternate jurors. This means you are not discharged from your service as a juror. Your service may still be needed if one of the other jurors is no longer able to participate in deliberations. In this case, our alternate jurors are juror number 13, Ms. Fitzpatrick. Jurors 1,
All right, let's see what they have to say. Let's give it a minute.
may the record reflect we are outside the presence of our jury. Do you guys have any further matters?
Okie dokie. Okie dokie, Oklahoma. Y'all, I am so close to being done with this, and I've got to get it done tonight. I can sort of tolerate it not having bling for my pictures, but I have got to get that last bit corner done. I am so close. Then I've got to work on a paper, get my clothes together. Yeah, I got some stuff to do, but we're going to do it. They are deliberating. Let me get on my mic. My back is hurting, y'all. Oh, my back is hurting. Okay, so they're deliberating. June, you did a fabulous poll. The results of it, if you were on the jury, who had the most believable closing? State 71%, neither 29. Defense 0. Poll closed with 7 votes. It's sealed. Sign, seal, deliver. It's yours. Let's see. I'm going to see what they do. Let's give Court TV a little a little opportunity here. I've got to keep beating. I'm literally, just got to get a corner. I would say 20, 30 minutes at most, and I'll be done with the most difficult part of this job. I've been working on this for what, 3 days now, y'all? Been 3 days? Been working on it quite a bit. People don't realize how long it takes to do this. What people don't realize is you can't just push a needle through this. And yeah, it looks like, oh, I can do that in a day. No. And I got to tell you, my back is screaming. So I may have to get up and take a little muscle relaxer to get through the rest of the day and the night. What's for dinner, y'all? Wouldn't it be, oh my gosh, wouldn't it be interesting if they came back today with a verdict? I see. A new poll is up. I see, Miss June. Just give me a second to anchor my oh, snap it. Oh, that's where I was. See, June, you get me off my beating train and put me on the YouTube train, and, well, I forget where I is. Okay. The new poll is, how's long before verdict? You got to do HOS. How's long before the verdict? 1 to 2, 2 to 3. 1 to 2, 3 to 4, or 5 plus. It's 50-50 split at the moment. This is the moment. This is the hour. Anybody want to come on and chat with me a little bit? Have some fun? Because we got some time to kill. Anything on you, y'all can find anything on YouTube, let me know. I'm surprised we have Court TV hadn't popped over to something. I can always do some members only stuff with Court TV, I think. I've done them before. They haven't gotten upset with me. There we go. Y'all, I'm getting a little tired of these hot flashes. Making roasted chicken, roasted potatoes, and vegetables. June, you sound like you are a good cook. I want to come eat with you. Your meals always sound so good. Can I come eat with you, June? I'm thinking spaghetti and chicken. I am probably just going to have an egg. When I do trials like this and I'm this busy and it's just me and my son, I don't plan. I don't. It's just me and him, and he's, oh, snap it. Wrong side. That would have been nasty. That would have been horrible. Wrong. Punch the wrong hole. Let's see. I had a nice salad with Ritz. Yeah. Angela, what's your husband making for dinner? Is that it? Salad and Ritz? You got a chef. Yes, dear. Can you just send me the link, please, June? Yes, I did. Let me get this corner done, which will take only a few more minutes. June, I'll get the corner done. Give me a few more minutes to get this done. And then I saw it, I have it up. I'm gonna talk about it. But I need to get this done because I also have a paper to do later tonight. I think I'll do one more row here. Corners are not super hard if you just figure it out. I'm not a good cook. Don't even come here. Well, your hubby could cook. Oh, that's Amy. I thought you were Angela. I'm sorry, boo. I used to be a horrible cook because my mama taught me nothing. She didn't teach me. Only thing I could make was maybe it's a salad that has Cool Whip. She always had me. That was Ada's recipe. I'm like, I don't care about this crap. I didn't really. I mean, I liked it when other people made it, but after I had to start making it for every family event, I was like, I'm done. It was you get a tub of Cool Whip, evaporated milk or condensed milk, which is evaporated milk. Then you get a can of cherry pie filling. Then you get pineapple and sometimes pecan, which I was not a fan of. And you mix it all together. And that was my little thing I always end up doing. And I have to tell you, it was, I mean, as a kid, I liked it, but now it's kind of like, eh. Go to my Discord. Life come, ba-dum bum bum. Boy, those are mug shots, y'all. Look at these mug shots. Oh my Lord, have mercy. When does it premiere? What time? 2 minutes. Okay. Benny Politan, we got a date with you, dear, tonight. He made garlic cheese bread on the side. Oh. No, I've had eggs this morning. I'll have eggs this evening. I had me about 2 ounces of chicken breast and about a cup of potatoes, about a fourth of a cup of dressing, and a bunch of cranberry sauce. So y'all, I can just eat a whole can of cranberry sauce. From my local grocer. They do these pre-made meals that are like home cooked pre-made meals, and they're really reasonably priced. So yes, ma'am. I'm gonna get tired of that train. The premiere is tied to the Stampin' Up case. Oh no! Don't you do the gong. The gong actually hurts my ears, boo. It actually hurts. That's why I don't like it. It's like, ow. Because it's so sharp on my earbuds, y'all. My eardrums. All right. I'll do the, all right, guys. Gosh. There y'all go. Someone wanted to see how I did the corners. It's not like I can get close enough for you to see it. Because that hurts holding it like that, y'all. I got to find the hole. I have to find the hole. There it is. There's the hole. Hole in one. I'll try and move it over here like this. It's hard to see because it's blue on black. Oh. Yeah, I used to do Stampin' Up. I loved making cards and homemade boxes, and I love crafts in general, but I loved paper craft. And I was a Stampin' Up demonstrator for years. Years, y'all. And so I know the owners of Stampin' Up. And I really did enjoy it. I would still be doing it because I used to make all of my own Christmas cards and everything. But my problem is I have no place. I mean, I don't even have a room to be doing what I'm doing in this particular room. And so it's getting a little bit tight here, y'all. So I can't do what I want to do. Okay, somebody asked me, I've had people ask me questions all week, so I'm going to answer a few questions. I don't know if y'all can see what I'm doing, but I have put the pin through the bead. I don't know if you can see that. And then I take my pliers and I pinch the bead up against the needle and it breaks the bead. Why would I do that? Because I got one too many beads. It's called bead popping. However, you got to be careful because you can potentially bust the thread. And I've done that about 3 times on this hat already. So you got to be careful, but you can pop out beads because when you get too many, it bunches up. All right, 8, 7, 6, 5. All right, I don't want to get in trouble with the music. I'm going to let him have his. I'm going to let Mr. Vinnie Politan have his music. All right, now he is here. We're going to be hearing about several cases.
Just dropped his twins off at his ex's house. A murder witnessed by a very young child.
Oh.
Here's the story. On the night of February 16th, 2022, loving father Jared Bridegan was ambushed in a dimly lit Jacksonville Beach neighborhood after dropping off his twins. A tire mysteriously placed in the road forced him to stop. Seconds later, he was gunned down at close range in front of his terrified 2-year-old daughter. The hit appeared calculated, timed for maximum terror and devastation. Investigators tied the plot to Jared's bitter custody battle with his ex-wife, Shauna Gardner, alleging she orchestrated the murder with her current husband, Mario.
Shanna Gardner is the daughter of the Stampin' Up mogul owners.
Fernandez Saldana, who recruited hitman Henry Tenon for a $150,000 fee. Tenon pleaded guilty to second-degree murder and is supposed to cooperate with prosecutors. In August of 2023, both Shauna and Mario were indicted on first-degree murder, conspiracy, solicitation of a capital felony, and child abuse charges. Prosecutors are seeking the death penalty against both defendants. Everything's at stake in this case. It's a death penalty case in Florida. Everything's lined up for next summer to take place. It's not going to be a quick trial. It's going to take some time. They're supposed to have 2 different juries involved here in one case. One trial, 2 juries, one for each of the 2 co-defendants. And the third co-defendant pleaded guilty, took a deal for second degree, was supposed to cooperate and be the star witness in the case. Let's bring in Court TV field reporter Cody Thomas. There have been some developments recently involving this co-defendant, Henry's tenant, the alleged hitman in all of this. And this could really shake up the case here.
Absolutely, Vinny. It's a development that we've been following for a little while now, and it's also a development that we are still awaiting to see what comes of it. Now, Henry Tennant, of course, we know is the gunman who pulled the trigger and actually killed Jared Bridegan back in 2022 when this shooting happened. Now, his connection to all of this, Tennant was renting a house from co-defendant Mario Fernandez Saldana. That's his connection. Mario was his landlord in all of this. Now, Vinny, dating back to March 15th, 2023, after his arrest, that's when Tennant provided a sworn statement implicating Mario Fernandez Saldana in the shooting. He pretty much, like you said, struck a plea deal where he pleaded guilty to second-degree murder and agreed to testify against Shanna Gardner and Mario Fernandez. Now, there was this status hearing, Vinny. This is where the development comes in. There was a status hearing for Tennant in January of 2025, and it wasn't until the next month in February when Fernandez's attorney filed a motion requesting discovery that they learned in that hearing Tennant told the judge his testimony against Gardner and Fernandez was false. He pretty much lied under oath, Benny, and this is a transcript of that hearing with his interaction with the judge. Now he says, it starts off, Mr. Tennant says, quote, "Your Honor, may I say something?" The court, the judge says, "Talk to Mr. Chipperfield first." Mr. Chipperfield being Tennant's defense attorney. "Tell him what you want to tell me, okay?" Mr. Tennant replies, "I just want to bring to your attention that my testimony," judge replies, "No, no, no." Tennant says, "False testimony." The court goes, "Hold on." Mr. Chipperfield, the defense attorney, chimes in and says, "Mr. Tennant, we need to talk about that." Tennant says, "I need another attorney." Judge says, "Okay, let me pass it temporarily. Have a conversation with Mr. Chipperfield, and then I'll have a conversation with you, Mr. Tennant, okay?" Tennant replies, "Okay," and then he exits that courtroom, Benny. And according to the document filed, Tennant never came back in that courtroom to address the court at all about this whatsoever. The case was postponed for months, and prosecutors were concerned that somebody had reached out to Tennant to influence him, surprising his attorney in court that day and essentially withdrawing his initial plea. But Tennant went on to deny any threats, deny any harassments, and deny any payments. So this was of his own accord, Benny.
Yeah, this puts a wrinkle, perhaps a really bad wrinkle in the prosecution's case and the way we are going forward in all this. Cody Thomas is going to stay with us all night on this. So he's saying false testimony. Is this going to be another case like we just had in Las Vegas with Devin Michaels, who pleaded guilty, was at her sentencing, and then said, "I'm innocent." And then everyone was like, whoa, 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 whoa. That's it. You're going to trial. We're going to pull the plea. This case is interesting because he's not only pleading guilty, but supposed to cooperate with prosecutors and be perhaps the star witness for them in putting all the pieces together, which brings us to the first question in our investigation. And this is an important one for the trial of Shanna Gardner and her husband. If Henry Tennant withdraws his plea, can prosecutors win the case? And I'm talking about the case against the ex-wife, Shanna Gardner, the one who hired Jose Baez to defend her. Here to help answer this question, Florida attorney Brian Silver and Florida criminal defense attorney Michael Gottlieb. Great to have you both here. This is messy. This is really messy. I'm a former prosecutor. If I've got a cooperating witness who's the hitman, I want that testimony coming in clean. Now he's reneging. He's saying it's false testimony. What's going on here, Brian?
Well, good evening, Vinny. Good evening, Mr. Gottlieb. I hope everybody's doing great. I'm sure the prosecutors are not having that good of an evening. You don't want to hear that one of your star witnesses is throwing around the words false and testimony, and there's discussion about withdrawing a plea, because if he does that, that means all bets are off and they lose a very important witness. I don't think it necessarily means that their case is over. There's a lot of other very strong circumstantial evidence, such as the connection that these two defendants have to this gentleman. But it definitely throws a monkey wrench in the situation. And let's face it, she is represented by a very capable lawyer who absolutely will delve very deeply on this subject.
Yeah, very deeply. Michael, here's the here's the way I'm looking at this. Like, to prove this case, right? Because Henry Tenon is the one, like he's the gunman. He is the one who actually takes the life of Jared Bridegan. But you've got to connect him all the way to Shanna Gardner, because everyone's looking at this case and saying, okay, Shanna Gardner's the mother of the children. She's the ex-wife. Like, she's like the one potentially, according to prosecutors, pulling the strings here. But if Tenon's not going to admit it and connect himself at least to her husband, now you've got to prove all of that. Can they, though? Can they make the connection all the way back to Shanna?
Y'all, this is...
Yeah, first of all, thanks for having me on, Vinny. Hey, Brian, how are you? Of course, I think they can make that connection. There's a couple ways in which you do that. There's a paper trail. There's money. There's a connection as a renter to Fernanda Saldana and Mr. Tenon. Plus, Mr. Tenon, even though he's claiming now that he gave false testimony, he already gave testimony. So you can use that prior testimony to impeach him. Maybe he's got buyer's remorse. He's sitting in jail for 15 years. Maybe somebody did get to him. He pled guilty to murder too. There's other evidence as well. His truck was found at or seen at or near the scene. The tire that was placed in the roadway matches a tire that was found at Fernanda Saldana's residence. So, and then there's a connection between Shanna Gardner. She was in a very difficult divorce situation. She has a motive. That's a beautiful thing for a prosecutor, something they never need to prove, but they have in this case. And so when you can tie all three of them together, even without Tenon's statements, I think the prosecution can easily get a guilty verdict in this case.
Well, I don't think anything's easy when Baez is on the other side. He has a way, with especially with Florida juries, right? So Brian, what does it do to the case now? Right now, there's two defendants. If he withdraws his plea, do we now put three defendants on trial at once? Do we have separate trials for him and for the other two? Does that change the dynamic of the way this is going to look in front of the juries? We already have two juries. Are we going to put a third jury inside the courtroom?
So first of all, I don't think it's such a foregone conclusion that he's going to withdraw his plea, because it's not up to him. It's going to be up to his judge. And when a person pleads guilty to a charge in criminal court, and anybody who's ever actually observed the process, you know, that judge goes through a whole slew of questions to make sure that the person knows what they're doing. They're aware of the consequences. I mean, they even ask them, you know, things like, have you used any medications that might impair your judgment today? So for him to get past the hurdle of reopening his case, it's not automatic. It's going to be difficult. But the fallout to the prosecutors, they definitely are going to have to reevaluate how they go about things, because now instead of him being a friendly force in their case, he's now an enemy. He's now someone that they need to battle with. It's just another hurdle. And frankly, you know, I don't know how wise it is for this gentleman to trade a murder 2 conviction for murder 1, where the state is seeking the death penalty. He might be making a very, very big mistake. Guilty or innocent, he might be putting himself on the chopping block. I hate to say it. I don't know how wise of a decision it would be for him to reopen his case, because if he reopens his case, he's back to square zero. He's now in the crosshairs. But the prosecutors will definitely have to take it from square one. But the way I see it is as follows. They arrested.
Just FYI, a little background. Let me give y'all a little background. I am almost done with this corner, y'all. This corner is being the vein of my existence. Of course, it's the last one. That's why. A little background. It's my understanding that you heard them talk about how Garner has a really good attorney. Well, yeah, her family is like million upon million upon million upon million upon millionaires. The two sisters in this company started this Stampin' Up business together, and they have raised their children through all this. They have done all this wonderful stuff, and they are the stamp moguls of the U.S. And when you can become a consultant or a Stampin' Up person and you sell it. Damn it! Yep, Nala heard that. Let me back away carefully because I got a bunch of beads that are now all over the place. Where's the tool? Nala, stop it. Oh, this sucks, y'all. Ah! This sucks a duck. I'm about ready to go scream at my monkey. June, do you want to go scream at my monkey for me? She heard me and now she's rattling. Nala! She's rattling and shaking her cage. Nala! Don't make me come in there. Mama will have a can of whoop ass. Not really. So, damn it. Y'all get to watch the tedious process of me salvaging beads. Nala? This is not when I need my monkey to go monk shit. Well, I guess I'm doing okay. This is not, like I said, it's not on the carpet. It's just so frustrating. Nala, when I get frustrated and she hears that tone in my voice, she triggers. And it's like, dang it. It's worse than having it's like having a 2-year-old. Come on. This is old paper. This certificate is from 2001. This certificate is 24 years old. I found it in my stuff. I was taking photography in college. Just took a photography class. Even though I already knew it, I thought I'd get a degree in photography, and then life happened. Okay, now the next trick. Drum roll, please. Ta-da! I'm going to go shut my door because I don't want to hear her all night. Now that said, I feel some in the carpet. I'll have to get I use a lint roller to get it off the carpet. All right. Back to this story. So anyway, from what is understood, from what I understand, I gotta fill that in. Nabbit. From what I understand, the parents of this young girl who is being accused of unaliving, let me put this back. The parents of the girl that's accused of unaliving, I gotta do that. They have distanced themselves from her, of course, but they did hire a kick-ass attorney. So when he's talking about an attorney, that's who he's talking about. She herself could not afford it, but boy, her mama and daddy could. So anyway, it's a great company. It's a wonderful thing if you like arts and crafts and card making. It's great quality. I love them.
Him and charge him with the crime because they thought they could win. It's just going to mean more work for them. I don't know that it necessarily translates into a weaker case.
Let me ask you this, Michael. What happens if he doesn't withdraw, but testifies, gets called by the state, and all of a sudden he's telling a different story on the witness stand? Can prosecutors overcome
It
that?
certainly wouldn't be the first time that's happened. It wouldn't be the first time that's happened, right? But he's already given a statement under oath. So again, a good prosecutor is going to go through that statement line by line and say you were telling the truth when you gave that statement. And they'll go through the evidence of the crime scene. There are things that he's been able to say that only he, as the shooter, would know. Where he shot from, how he placed the tire in the roadway.
Well, I think the story's going to change, though, relative to the involvement of the other two. Like that's where I think the change is going to be. He may not change his testimony about actually pulling the trigger, but he may suddenly say, well, you know, Shanna didn't know anything. It was just Mario or something like that.
Right, and that's incredibly plausible, and I think Shanna's probably the easiest one, you know, to exculpate in a case like this because she doesn't have the same connections that Saldana Fernandez does or Fernandez Saldana does, and the money transfers aren't from Shanna; they're from Fernandez Saldana to Tenon, and he had a relationship there. So she's certainly the easiest person for him to say, look, she had nothing to do with this, and she may walk. Anything's possible.
Well, that brings us
interesting.
Yeah. All right, guests are staying with us. Coming up next, this is exactly what we're going to talk about. I mentioned Jose Baez is representing Shanna, right? Is this case easier to defend than that woman from Orange County?
We are here for Raymond and Shanna Gardner's case.
We would enter a plea of not guilty and then discover this time.
All right.
Mama tried. Now my daddy's crying because I'm in here.
You are the common denominator that led to JD and Big Doug shooting each other in the dark of night.
All right, help party, I'm dying.
Don't you have the blood of both these men on your hands?
I feel guilty for that.
You felt guilty because, frankly, you were guilty.
Interview with a Killer. New episode Saturday night at 8 Eastern and Pacific. Only on Court TV.
They want you to follow the money, Your Honor. But they want you to follow their path to the money, which clearly is false and absolutely misleading and has no place before this court.
High-profile attorney Jose Baez representing Shanna Gardner. She comes from a lot of money. The family has money to pay him to bring him into the case. And yeah, we all remember what he did. He did what many believed was the impossible down in Central Florida years ago, before I started dyeing my hair silver. Take a look. Jose Baez down in Orange County.
When you go back home and you're back in Clearwater, and you're sitting around the dinner table, and someone says to you, why did you find Casey Anthony not guilty? You're going to say, well, I was fed a wealth of information, like a V. All this information came, but it all boiled down to one thing. They couldn't tell me how she died.
It's the defense's position and theory of the case that this was an accident. This is a detective currently investigating a missing persons case, but yet he considers it akin to a murder investigation without a body.
What information, Mr. Baez, of record evidence that would be introduced that shows this was an accident?
The fact that Mrs. Anthony had informed him within 24 hours of him being involved in the case that they had accidentally, or that she had noticed that the ladder was left up on the pool. There are also multiple statements from both George and Cindy Anthony where they have clearly advised this officer that, in their opinion, this could have been an accident that was covered up, and that accident would have centered around the pool of this case.
When everything is said and done, the one question will never be answered. The key question in this case will never be answered. It can never be proven. And that is, how did Kaylee die? They're hoping they throw enough against the wall and see what sticks. That's what they're doing here. Let's throw it all against the wall and see what sticks. I'm not proud of the way Casey behaved. I don't think anybody here can justify her actions, but they do not constitute murder.
As to the charge of first-degree murder, verdict as to count 1, we, the jury, find the defendant not guilty.
She didn't report her daughter missing for 30 days. She lied about everything. Her 12 people testified about the smell of death coming from the trunk of her car. The body was discarded. There was duct tape over her mouth and in her hair. And he said it was an accident. Like, there was no evidence of an accident. Didn't matter. Jury found her not guilty. That brings us to the next question in our investigation. Is this case easier to defend than Casey Anthony? I said it. Sorry, but I did. Is it easier? She didn't pull the trigger. Henry Tennant did. Here to help with our investigation, still with us, Brian Silver and Michael Gottlieb. Michael, is this one easier?
It's a very different case. So in Casey Anthony, she lied over and over and over again. But the medical examiner couldn't put a date or a time on the death. And there was virtually no direct evidence. There was some circumstantial evidence.
There was duct tape on a dead baby. There was duct tape on a dead baby.
Right, but duct tape doesn't tell you who put it there. There was no.
Right, but they said it was an accident.
There was no fingerprint.
The defense said exactly what happened. Like they said that it was an accidental drowning.
The jury might not buy that, but they still have to believe beyond a reasonable doubt that Casey Anthony was guilty of murdering her old child, and the state didn't have that evidence there. The child was dead. It was a horrific scene. The entire state, the entire country was talking about it. She was guilty in the court of public opinion. But jurors take an oath, and they follow that oath. And that oath is to hold the state to a burden of proving their case beyond and to the exclusion of every reasonable doubt. And there was reasonable doubt in that case that she was the party that was guilty of murdering her own child. So I think this case is much harder because if Tennant sticks to his guns, to his original statement, you've got a guy who says, I was there, who says he killed, who talks about the motive, talks about the plan, talks about the relationship. So I think Tennant is a much more difficult defense case.
Brian, what do you think? Is this case easier or more difficult?
I got to take Mr. Gottlieb's side on this one, Vinny. I got to tell you, the thing with Casey Anthony is as follows, all right? The duct tape, you're right. It's glaring evidence, and it's something that resonates with homicide. But the truth is, it's also used to dispose of bodies. It doesn't speak to the cause of death. All it speaks to is someone is trying to hide something. But the big question is, what are they trying to hide? Are they trying to hide child neglect that resulted in a death? Or are they trying to hide a premeditated murder? Those are two very different things. And that was the big question. And here's the ultimate issue. But she was found
not guilty of all of them.
I understand that. And that was the right verdict because the prosecution had a lack of evidence. The medical examiner couldn't even tell that jury how the baby died. And by the way, let's not mistake the horror of that case with the verdict. Okay. When prosecutors ask for a murder conviction and the death penalty, it's the ultimate ask. Okay. They're asking for the biggest thing possible.
A lot of lesser included there, though. There was a whole list of lesser includeds that the jury could have landed on.
Yes, but they couldn't. This is the problem. Even the lesser includeds are some very serious offenses. And before a jury's going to feel comfortable sending someone to a cage for the rest of their life or to go get a needle in their arm, the prosecution has to live up to their case.
I have another question.
They gotta pay with evidence.
Yeah. All right. Michael Gottlieb, is this case easier than the Aaron Hernandez case? He was representing a convicted murderer in another murder case.
Yeah. So, that one's difficult. You had individuals who testified against Hernandez, but they were gang types, not really credible, not really believable. Hernandez had this thing about him, you were drawn to him. He I still think that this one is more difficult.
More difficult?
Given, yeah, it's a more difficult case to defend than Hernandez.
All right. Michael Gottlieb, Brian Silver, two great attorneys down in Florida. They know those juries down there. Thank you so much. All right, still to come. Why would you ever want your children's other parent dead? I'm Vinny Politan. We continue our investigation of the murder of Jared Bridegan, a young father raising his family with his new wife years after starting a family with his first wife. Now that first wife is charged with his murder. Here's the story. Shauna Gardner was born into Utah privilege. The daughter of Shelley and Sterling Gardner, co-founders of the very successful craft company Stampin' Up. Her lavish trust income funded a luxurious lifestyle and included a monthly stipend. But beneath the glamour, a darker story unfolded. In 2022, Shauna's ex, Jared Bridegan, was ambushed and executed in Jacksonville Beach after stepping out of his SUV to move a tire in the road. His 2-year-old child watched from the back seat. Prosecutors allege Shauna helped orchestrate the plot, allegedly texting as far back as 2015 that she wanted Jared gone and soliciting a hitman via her then-husband, Mario Fernandez Saldana, for $150,000. Now charged with first-degree murder, conspiracy, solicitation to commit a capital felony, and child abuse, which carry the death penalty, Gardner vehemently denies the charges. Death penalty case, a battle for years between these exes about raising those children. Let's bring in Court TV field reporter Cody Thomas to help us better understand this case, and let's get to the why of it, Cody. What is the alleged motive here?
Well, Vinny, like plenty of cases that we see here at Court TV, prosecutors say the motive had to do with a bitter legal custody battle after a nasty divorce over the two children, the twin children that Bridegan and Gardner shared together. Now, these two were married for 5 years before Gardner filed for divorce in 2015. Of course, Bridegan went on, got him a new family, got married, had 2 new kids with his new wife. Gardner went on to marry her now co-defendant, Mario Fernandez Saldana. But in the midst of all this, Shanna wanted full custody of the twins that she shared with Bridegan, which started this whole legal battle here. And Vinny, this is where the kicker comes in. According to some local reporting, their court file over the course of all this contains around 300 different entries and motions. 300, Vinny. So she was really going at it. I mean, she's represented by Jose Baez, so I mean, they're taking it all the way. Gardner accused Bridegan of having this abusive behavior. He accused her of spying on him and treating him bad in front of the kids. It's just not a good situation, Vinny. But in a hearing, Gardner's attorney, Jose Baez, of course, is heard questioning a detective with the Jacksonville Beach Police Department about Shanna's state of mind. Take a listen to this.
All the witnesses who told you about these alleged statements made by Ms. Gardner were referring back to 2015 up to 17, correct?
That's correct.
So fair to say too that that was when the tension between Ms. Gardner and Mr. Bridegan were at its peak, correct?
I can't speak to her state of mind.
But based on what you saw from the text messages, from the investigation, from all the people you talked to, it was pretty bad early on, right?
I would assume that would be the truth, but I would also argue that there are sprinkles of comments made throughout the entire time period that would indicate that she had issue with sharing custody with Mr. Bridegan, or that there were things that she would be frustrated over.
And Vinny, we've also heard from Bridegan's brother, Adam, and his wife after Shanna, a woman named Kirsten Bridegan, about the state of the relationship between Bridegan and Shanna and their relationship and their divorce. Take a listen to this.
What I can say is that Jared was broken, right? He really wanted to stay together for the kids. I think that was his top priority, was raising the children. And the divorce really took an emotional toll on him. And we were so happy as a family to see Kirsten come into Jared's life.
The relationship between us and his ex-wife was not cordial. Our communications were always in writing because there was not mutual trust between the two households. Unfortunately, are kind of stuck in the middle of that. Jared and I tried so hard not to involve them, not to use them as messengers, not to talk poorly about their mother in front of them. And unfortunately, that favor was not returned. And that was really hard on Jared. He sent so many messages just pleading, like, leave the kids out of it, because his priority was his kids. And that is what mattered to him.
So, Vinny, based on that testimony from the man with the Jacksonville Police Department, Bridegan's brother, Bridegan's wife at the time of his death, there's no doubt that things were rocky between Jared and Shanna.
Absolutely. And it continued over the course of so many years. It wasn't just like, oh, we're getting divorced. It was like, we're getting divorced, and then constantly filing motion, hundreds of motions. Thanks so much, Cody. So I get it. And I understand things get bitter. You may even talk badly, right? There are allegations of that, and you don't get along. You do everything in writing. But let's get to my next question in my investigation, because this is next level, right? This is the next level. This is what I don't understand. Why would you ever want your children's other parent dead? Because at that point, you're not just being vengeful against your ex. You are punishing your children. You're taking out, whether it's the mother or the father, you're taking out one of their parents. They're not going to grow up with one less parent. Why would you ever do that? All right, here to help us answer that question, author, clinical forensic neuropsychologist, Dr. Judy Ho, and Sharonda Brown, author and nationally certified mental health clinician who specializes in trauma, child abuse, and neglect. Thank you both. And this reminds me, right? I was thinking, the Adelsons. The Adelson case was a custody case as well. Another case involving the hiring or the alleged hiring in this case, but in that case, they hired a hitman. They hired two hitmen to take out Dan. Wendy hasn't been charged. We know that. But you're having your nephews or your grandchildren grow up without a parent. Why would it ever get to this, Dr. Judy Ho? Because you're not punishing your ex. You're punishing your own children. You're damaging your own children. Why would anyone do that?
It's a really good point, Vinny. And I don't think that clearly in these situations, people are thinking solely about their children or even primarily about their children. Their need for revenge or to take something out on their ex is so huge that they've just gone way over the top, and they're not even thinking about the fact that they are traumatizing their children for life, right? What was the best case scenario? And I understand that these are just allegations at this moment, but what was the best case scenario if this was actually the plot? Best case scenario is your children lose a parent. And we know the extremely negative and deleterious effects of that on children and their attachment development. But worst case scenario is kind of what's unfolding right now, Vinny, where you've lost one parent and the other parent is now embroiled in this huge legal battle. They may potentially lose their life because a death penalty is on the table. And now your children may be orphans. I mean, clearly they were not thinking this through, Vinny.
Sharonda Brown, you talk about, there's two things. There's something else that Jared Bridegan and Dan Markell have in common. These were two guys who wanted to be there for their children. And that's what children want. They want a dad. Obviously, they want the mom, but they want a dad also to be in their lives. What does it do, Sharonda, when a child loses a parent? They've gone through a divorce and now they lose a father or they lose a mother.
It's really hard on the kids in general. And when you have cases like this, usually co-parenting is difficult when you have at least one selfish parent who wants it all their way. So you usually have a safe parent where they have normal traditions, and then you have maybe an unsafe, maybe unorthodox parent where things are a little chaotic. And typically the household that's more chaotic usually wants to get rid of the household that's a little bit more peaceful and structured. And when one of the parents is gone, typically those kids lose the safer parent. They lose the parent who wants more structure and organization. So when that interferes with the chaotic household, it becomes a threat to that chaotic household. So you want to get rid of the other parent because they're disrupting your lack of organization and the way you like to do things. So there's an extra set of eyes on you who wants to make sure that the kids get to bed on time or that no one's cursing in front of them, no one's mistreating them. So they become a disruption at some point. And so now, because they're in the way, they have to go. And so these kids lose out on that safety. They lose out on the routine. They lose out on the structure. And it really takes a toll on them for their entire lives for the most part, because they're fighting for that structure and organization and that safety. So I definitely believe it's going to have a huge impact on them, especially if the safe parent is no longer there.
And Dr. Judy Ho, the other thing is there's so many parents, and let's look at it, in this scenario, moms, right? There's a divorce, dad meets another woman, starts another family, and then all of a sudden kind of forgets about his kids from his first marriage, right? And that, a lot of scenarios, and I know people, those mothers get so angry because they see what it's doing to their children to not have dad there. And then this is the opposite of that. This is a dad who wanted to be there despite the fact that he started another family. He was blending everyone together. I don't understand how you could look at that and see, okay, it's working. It's working. Yeah, there's another family, but dad is still in our children's lives. Why would you not want that?
Right. Well, when you're a decent parent, then you can have your personal feelings. You may even be a little jealous that your ex seems to be living his best life without you, carrying on with his new wife, and also some younger children that are not birthed by you, but yet people seem to be getting along, and you're saying, I will put my personal feelings aside and just tolerate this and deal with it the best that I can. Nobody's saying that you have to be happy about such a situation. Divorces are hard and people have really deep feelings about it. But this is just clearly a person who, if she actually did what has been alleged, is someone who says, well, you know what? I can't stand the fact that my ex is so happy. I can't stand the fact that my children love my ex. Maybe they even prefer him, to Miss Brown's point, and bringing those feelings and essentially as a parent, not being able to take a step back and saying, well, what is best for the children? Even if I have my own issues with it. She's basically letting herself get carried away with her hatred, her feelings, her inability to see her ex happy, and her inability to tolerate her children being happy with her ex.
All right, big thanks to Sharonda Brown. Dr. Judy Ho is going to stick around. Coming up next, how much difference will Shanna Gardner's family's millions make?
I'm here, Shanna. I'm outside. Oh, they're going to call you.
A former porn actor caught in a deadly father-son love triangle.
I'm not going to stop fighting to prove my innocence.
The Love Triangle beheading trial. Live coverage weekday mornings, 8, 7 Central on Court TV.
Sunday nights on Court TV. Join us for a night of food, friends, and our favorite legal dramas. It's Order in the Court. And this week, we're binge watching Bull. Sundays on Court TV.
What direction does this come?
Okay, I know. I'm working on this diligently. Thank you guys for watching and hanging in there. Thank you for being with us today. It has been a long day. Oh, I got to have my glasses. I am just got to glue this down, and this glue is not the easiest glue to work with, by the way. Not in these situations anyway. And then I'm done with this, and I'm I'll show you all the pictures when we get them in. When all the pictures get done. I want to give out a special shout out to someone very kind and special. My mods. Oh. My glorious, my amazing, my mods. Y'all are just so awesome. And I know I don't say it enough, but thank you so much for all that you do. June, did you open up that birthday section in Discord by any chance? I know we talked about it, but I don't know if you actually got it, if you got it done or what the deal is. Do you know if you got that done? Because I wanted to share with y'all, if anybody has a birthday, yeah, I'm going right now. If anybody has a birthday, we want to celebrate you and your birthday. So I'm going to get off at that, and I'm going to go here, here. Come on, get rid of the ads. Close that. I hate these dang ads. We'll look at that in a second. I'll read both of those back in a minute. I just need to get this glued down so I can get this behind me. I just have to get this done. I don't want to go all the way to San Angelo, which is 2 hours away, 2.5 hour drive away from me, and not have this done and not be able to get, you know, I've got my graduation pictures tomorrow. And guys, it's the first time I've had pictures taken of me in a long time, so I really want to look good as best I can for a lard ass. You know, what can I say? I think the glue is drying up. I hate this glue is really good, but I hate it. But I can clean it. Anyway. So I will read through all that in just a minute. Give me about 5 minutes is all I need. This glue sets up quick. I mean, it's already setting up. And it's getting harder for me to spread it because it's clumping. I feel like I waste more than this glue than I actually use. It's so frustrating. I mean, it's great stuff, but God damn it! See what I mean? All right, we're good. Anybody else have anybody that they know in their family that's graduating this December? I was talking to a friend of mine and I told her, I said, no offense, but all of people who graduate in December seem to be forgotten. I mean, everybody that's graduating college, they all get celebrated in May. Everybody seems to celebrate graduations in May. But people forget that you got fall graduations in college too. And you know, your churches, they'll have a special little graduation Sunday where they honor all the graduating people and they talk about who's got what and where they're going to college or what they're doing after college. And churches do that in May, but nobody does it in December, which I think is kind of a bummer. Because not everybody graduates at that point. Not everybody graduates, Dan. I know, I'm going to have to get new sewing scissors. My sewing scissors. Pretty gnarly. All right, one more row and I'm done. There's going to be more things I want to do to this eventually if I have the time. But I've got two more cowboy hats to do for Christmas for one of my viewers. She's ordered cowboy hats. Y'all seen me do one. And then I've got to do several baseball caps in amongst all of that. And then I'm supposed to be going to powwow, but I don't know if I'm going to make it. I love powwow, but they're having it on the 22nd this year, which to me is just so freaking close to Thanksgiving that I don't know if I'm going to be able to make it. I'm sorry I have to get this done, y'all. When we started this week, we only had one trial. And I thought, okay, that's going to leave me plenty of time to get this done. One trial. What happened? We freaking ended up with 3 trials, which I guess is good. That's good. But we ended up with 3 trials. And so that's a little bit difficult. I am hoping that this trial here will, I would like to see the jury come back tonight. I'd rather stay late tonight and come back with a verdict than hang this up over the weekend. June, do we have any trials starting next week? My wonderful research mod, June. And mod boss. She's everything mod. Do we have a trial coming up on Monday? Gotta get more glue. This stuff dries so fast. I'm dropping everything, y'all. Let me get up to the comments so I can see y'all. See what I mean? I drop things. My hands get tired. Thank you for loving my channel, y'all. Yep. Go join the Discord, honey. Everybody go join Discord, guy. Because we got movie tonight. Hopefully we have a movie. We'll have a movie tonight. I will keep everything going here. Without finally worked the way I wanted on the very last stretch. On the very last stretch, it worked. But I have to use my good scissors to cut it, unfortunately. And I don't like that. And I cut 1 too short. Damn it. Hallelujah. Okay, we're going to fix you. And then what I like to do if I have a really loose section of beads for some whatever reason. Wow, Nala. Really, boo. That's getting to be a little bit ridiculous, honey bun. Oh, sunny day. Dun, dun, dun. There it is. Got it all done. I'm a happy girl. Thank you guys so much for your patience. My monkey ain't being so patient, but got the hat done. I got to let the glue dry and clean up, but we're good. Oh, I love it when things finally come together. I got to be honest, my back and hands are screaming at me going, don't do any more. So I ain't going to do no more. I am going to fold this over and bead in the front. I'll find where I want, and then I'll just bead something. I'll just bead something here. But for now, for pictures, it's done. Do y'all hear that little monkey butt? Can y'all not hear her? Oh my God. She's like, Nala! Witch, please. You got fed. That monkey got fed good. Okay, so no, can't do that. I can do this. So much better. Okay, so we have multiple things to talk about while we're waiting. And I'm going to go through some of those things y'all posted. Yeah, we have the Ian Mitchum trial, and more will come down from that. So hold on a minute. Okay, y'all, you won't believe this. The cat is sitting in front of the cage about 5 feet away, taunting the poor monkey. The cat is taunting the monkey is what's going down, y'all. Okay, so what I need to do is I'm going to put me here. I'm going to read a few things. We need to get back over. Need to keep an eye on court and make sure that we hop in. So I'm going to turn the volume. Okay, so we're going to put that on pause. So what I'm going to do is I'm going to read this because some of this is really cool. This is about Cardi B. Cardi B's attorney fires back at accuser. Lawyer admits inexperience. Los Angeles Court TV. A woman who lost her lawsuit against Cardi B is asking the judge to give her another chance as her attorney faces fallout from his behavior during the trial. Cardi B, whatever her name is, successfully defended herself against a lawsuit brought against her by the security guard, Imani Ellis, who accused the WAP rapper of assault and battery following an incident in Beverly Hills doctor's office. While Cardi B was pregnant, by the way. Both Ellis and Cardi B testified, but after a 4-day trial, the jury sided with Cardi B and denied Ellis's claim. In her motion for new trial, Ellis focused less on what happened inside the courtroom and more what happened in the hallway of the courtroom steps. In an incident caught on camera, Cardi B threw a pen on the courtroom steps. In motion for a new trial, Ellis attorney Rod A. Rosen Jafanza suggested the behavior should merit new trial. Yeah, no. The incident happened while she was at lunch break during the trial. The incident caused another individual to get pushed and injured. It was also completely unlawful and disrespectful to the defendant to injure others during the trial on the Alabama courthouse property, which she did on September 2nd of 25. Additional time is needed to determine if the defendant's actions of throwing a pin at a man outside of the Alabama courthouse was witnessed by the jury. Quote, end quote. In response of calling a motion of a new trial, Cardi B's attorney, Peter Anderson, questions why any juror would have been standing outside the courthouse with gaggling of press. The tension in the case extends beyond Cardi B and Ellis as their attorneys now have filed dueling requests for sanctions, each accusing each other of unethical behavior during a trial. Zanfanza, in the motion for new trial, accused Anderson of threatening him to obtain an unfair advantage. Yeah, I'm going to take something from my back. An unfair advantage and also assaulting him in the hallway of the courthouse during the trial. When did that happen? Did any of y'all hear about him of one attorney assaulting another attorney in the hallway? Is that BS or what? Anderson dismissed the claim in Cardi B's response, noting that sheriff deputies were present at all times in the hallway and never reported any assault, shouting, or any other incident. Meanwhile, Anderson files a motion for an order to show cause compelling Juan Frenza, I'm sorry, I keep calling it Zan, it's Juan Frenza, to provide proof as to why he should not be held in contempt and sanctioned for his behavior during the trial. Really? The issue is Anderson focused on his motion included Juan Frenza asking questions as to where previously deemed to be outside of the scope of acceptable evidence and violating court orders during the trial. Juan Frenza pinned an exhaustive report on the motion, pleading with the judge to give the plaintiff's counsel the benefit of the doubt. He explained that he wasn't a seasoned trial attorney like Anderson, and any mistakes were purely accidental. You are finally sitting here and confessing that you were in over your head like all of us were claiming. You guys remember that? We were all like, boo, you're way in over your head. Quote, plaintiff counsel law license is most important thing to him, which she never sacrificed for any reason. Juan Frenza explained, if I'm saying it right, if not, oh well, explains that he had only ever gone to trial in 10 cases before plaintiff's counsel took his case on from another firm for whom sole reason of giving the plaintiff an opportunity to be heard. Quoted, Juan Frenza wrote, plaintiff's counsel has already lost thousands of dollars in a pursuit, even though he struggled financially. Plaintiff counsel future career path is to be a judge in efforts to help people by administering justice. Go for it, boo. I can't see that flying. You may have that aspiration, but boo, there are a lot of people who want to be a judge. A judge is not something you can just walk out and get. That's voted for or appointed, and you got to be, yeah, okay, we'll see. I'm not trying to say you can't do what you want to do, boo, because guess what? I'm in college. At my age, I'm doing what I want to do, and people said I couldn't do it. So I ain't going to tell you, boo, that you can't do it. But honey, be careful. You maybe I would not laugh at you say be a lawyer. That I would be, yeah, go boo. But for you to sit there and say that you want to be a judge, oh, my bad. I'm tired. Anyway, to better understand how to proceed to trial, a hearing is scheduled on the order to show cause and the motion for a new trial December 5th of 2025. Oh, y'all, I'm getting the Google Calendar out. I am. We'll be in another trial at that point, but that's okay. I just added you to the mix, boo. I just did. You were in. We got you on the calendar. I just had to do it. I had to do it, y'all. So that is that. That's insane. Come on now. Really? She hired the attorney. I don't understand why she's struggling if she hired the attorney. I got so many windows open now. I don't know if I'm heads or tails. What is this? I think that's closed. We'll close that. We'll keep that open. We got that. We got that. Get that over there. It's a lot of, oh shoot, close the wrong one. I've got a lot of windows open, so I've got a lot of stuff. So let me get the Court TV thing open again. Okay. So let me read this one. Leon County, Michigan. John Skelton, the father of 3 brothers who went missing in Leon County 2010, has been charged with Red Room. Skelton 53 was charged Thursday in Leon County court with 3 counts of open Red Room and 3 counts of tampering with evidence. Earlier this year, judge ruled that the 3 brothers, Andrew, Alexander, and Tanner, were legally deceased. It came after a request from the boys' mother, Tana. Their date was set November 26 of 2010. In this case, a terrible and long-standing impact on the community of Linwinney County Judge Catherine Salzla said that no condolences will ever be enough for such a loss suffered. Oh, the truth. 3 of your kids. Well, yeah, it's horrible. Skelton was set to be released from prison later this month after serving 15 years for his failure to return the boys to the mother. Skelton and the mother were having problems and living apart in Morency. The boys were supposed to go back to their mom, and the next day, instead, they were gone. They have not been found despite numerous searches in the woods and the waters of Michigan and Ohio, as well as tips from across the county. Police said Skelton fed them a long string of lies about the boys' whereabouts, sending investigators an old school house in Knuckle, Ohio, and a dumpster in Holiday City, Ohio. Police said claims that the boys were handed to other people for their safety also turned out to be false. He also declined to participate in the hearing, saying anything I have isn't going to make any difference. Wow. So we've got some interesting stuff starting to stir. This is the dead time of year. This is when a lot of cases are off. Courts kind of quiet down a whole lot. Hi, Amy. Hi, honey. Hi, everybody. See what kind of case I want to get into? Not Red Room, just fighting. Well, June, I did see your comments. Is your family member going to be able to give us information? Will we get behind the slammer information? I'm going to end the poll. Here's the poll. It ended. How long will it be before the verdict? 1 to 2 hours, 56%. 3 to 4 hours, 33%. 5+ hours, 11%. Poll completed now. Thank you guys so much for joining us. I am currently waiting for Court TV. I'm going to roll back the beautiful bean footage and share. Look, did he just say that? Listen again.
Cameras and a couple of texts or activity, 212 and 230. One's a Discord, one's a photograph. Remember what their own experts said. That wasn't active activity. That could have been background activity. It could have been active. He can't say that. So whether Devier woke up and activated his phone at 212 or 230, well, that just tells you he's still at home. And if it's just background activity, then who cares? Either way, it's not good for the defendant because it rules out Devier. He's either with his phone or it's a nothing burger.
Nothing burger. Boy, that should have been on the bingo card.
Mr. Draskovich talked about the boxer shorts being off, and I already mentioned this. The defendant may very well have blocked out what she did after she killed him.
I would have never thought to do a nothing burger.
Whether she took the boxers off or not doesn't really matter. It's probably very likely that he was naked when they were having this massage situation, but the boxers being on scene have no real import in this case. Mr. Draskovich talked about the CVS pickup, and I got to address that. So he said and he showed you the video, there's no blood on the defendant in that drive-through. Now, we all watched it together. I don't see any blood from here up from what you can see. But do not forget, that shirt was never recovered. Neither were the shoes. Now, I'm not arguing to you or suggesting that I know what the defendant was wearing when she decapitated him. She could have been naked. She could have put John's shirt on. She could have changed her clothes, a number of things. But what I am telling you is that white shirt, from here up, maybe no blood on it, but it's never recovered. So we don't know if there's actual blood on it. Mr. Drastic asked you a question and I need to provide an answer. He said, is that a woman picking up this medication for her girls that's just done this, has the wherewithal to have just done this and go pick up medication? Yes. Yeah, that's reality. You heard the voicemails. The little girl was saying, you were going to get my medication. I'm not saying that the defendant is a bad mother. I will not say that. That ain't right. She took her children's father away. That's a bad thing she did. But did she care about her girls? Obviously. She stopped to get medication? Obviously. That doesn't exonerate her in any possible way. And neither does the post-homicide messages she sent to the victim's phone in the early morning hours. There's two very real explanations for those messages. Number one, you already know the extremes she went to cover up what she did to his head. She took it. That's extreme. She poured chemicals. I commend them on that. But make absolutely no mistake. That woman is guilty as sin. That family deserves justice. Those girls deserve justice. Do not take this lightly just because a real polished defense attorney gets up here and spins a yarn for you. Do not take this lightly. Those people deserve justice. If I were to tell you that a defendant confessed to a crime, described how she did it, everything she said matches the crime scene, except for the part where she minimizes or potentially blacks out the aftermath. You would say, well, that's
show that Van Patten and Louisma bought gloves and 2 machetes. And to add that, to a growing list of evidence, Hoffman's eyeglasses were found at Van Patten's home, and Van Patten was seen wearing those glasses in Snapchat pictures after her death. Now, the judge listened to impact statements from the victim's parents before issuing his sentence, so let's take a listen.
When an individual commits an act so cruel and devoid of empathy that it extinguishes not only life but the future of generations, society has a moral duty to remove that individual permanently from it. Justice in such cases has to be done. Human beings are defined by empathy, compassion, and the capacity to value life. These qualities distinguish us from the cruelty of nature and the chaos of violence. When someone deliberately chooses to destroy innocent life, especially one that is nurturing new life, they reject the essence of humanity itself. To act without empathy is to abandon what makes one human. Therefore, such an individual cannot be regarded as part of the same moral order. I don't know if you want me to forgive you, but I'm not sure that'll ever happen. But if it does, it's only for her and not you. You've taken so much from me, my family, friends, and even complete strangers that never had the chance to meet her. Melody will live on forever in each and every one of us. She will be remembered for the kind, caring, loving, organized, silly, artistic, music-loving, slime-making, selfie-taking, video-making, supper-cooking, animal-loving girl we all remember. I don't believe for 1 minute that McKinley made you do it, or that you made him do it.
I believe that you're both 100% guilty of murdering Melody. Our daughter and their loved one. You're both cowards. Neither one of you had to stand up to each other and do the right thing. I also know that you two are the most naive, stupidest criminals that ever walked this planet. Every time you lie down on that cold-hard bed, every time you wake up to the concrete walls and iron bars, every birthday, holiday that you don't get to celebrate, every time you have to ask to use the restroom, every time you step out of line, every time you have a nightmare. Melody is providing for you. She will forever provide those scars that have structured you for the rest of your life. And I hope she haunts you forever.
The sentence in this case for murder and kidnapping charge is a mandatory sentence of life in prison, which is the sentence the court will be imposing. While the sentence is mandatory, it's also the sentence that is appropriate for these violent, incredibly cruel, and completely senseless acts. Your offense cuts beyond the short and deprived Melody Hoffman's family and friends from having her in their lives, which is understandably devastating to them, but also undercuts the safety and feelings of security in the community. A sentence of life in prison with no possibility of parole is the appropriate sentence for these crimes and is necessary for the protection of the community. The maximum sentence for the offense of conspiracy to commit forcible felony is a 10-year indeterminate prison term. While it is largely symbolic in this case, given the sentence of life in prison for the other offenses, the court does find that the maximum sentence of 10 years in prison is the appropriate sentence based on the level of training involved and the fact that the forcible felony involved is less safe. So at this time, the court adjudicates the defendant to be guilty of the offense of murder in first degree in violation of Iowa Code Sections 707.1 and 707.2(1)(b). As a sanction for this offense, the defendant is committed to the custody of the director of the Iowa Department of Corrections for the rest of his life. The court further adjudicates the defendant to be guilty of the offense of kidnapping in first degree in violation of Iowa Code Sections 710.1 and 710.2. As a sanction for this offense, the defendant is committed to the custody of the director of the Iowa Department of Corrections for the rest of his life. As to each of these offenses, the defendant shall not be released on parole unless the governor relieves the sentence to a term of years. The court further adjudicates the defendant to be guilty of the offense of conspiracy to commit a forcible felony in violation of Iowa Code Sections 706.1 sub B and 706.3 sub 1. As a sanction for this offense, the defendant is committed to the custody of the director of the Iowa Department of Corrections for an indeterminate term not to exceed 10 years in order to avoid finding the amount of $1,370. The defendant is given credit for all qualifying time previously served on this offense. The term of incarceration after this offense only may be reduced because of good time for credits and program credits, and the defendant may be eligible for parole before the sentence is discharged. While largely symbolic, count 1 and count 2 will run consecutive to each other. The reason for the consecutive sentences is that the kidnapping included separate planning and represented an entirely separate cruelty to Melody Hoffman as she was picked up, no idea what was coming, or all planned, separate torture associated with taken, confined, and moved, all of which occurred before the separate act of murder. The court finds that because of that, based on all the facts and circumstances of the two offenses, that they should run consecutive to each other. The sentence in count 3 will run concurrent to counts 1 and 2.
So unless the governor steps in and commutes his sentence, he's gone forever. ever at this point. Let's bring back in National Trial Attorney Michael Jaffer. Michael Jaffer, your reaction. It was mandatory. It was a first-degree murder conviction along with a couple of other things, as you heard laid out by the judge. But he really wanted to make sure to highlight some of the real heinousness of this crime. Particularly, this was a young lady who had some developmental issues. And, they planned this thing out. They pick her up. She had no idea what was going on. And it was just a particularly ugly crime.
You mentioned the amount of time he's going away. This kid is 19, 20 years old. People who are alive to know, were there when JFK was assassinated. The amount of time that JFK was assassinated till today, this kid will be in jail longer if he lives into his 80s. So he's going away for a long time. I just think we go a little bit too far in our country with these video game number sentences. It was grotesque. I hope her family don't hear me say what I'm about to say, but I just feel like it's just too far. Because he was not the axe man. He definitely, the jury got it right. I just think Iowa law is a little bit too extreme with situations like this.
All right, Mike, I'm with you on kind of some of the draconian sentences in this country, but I will say this, in this particular case, again, the heinousness of the crime, the fact that she was developmentally disabled on some level, the prosecutors made the point in their closing argument that the killer, her boyfriend, Luisma, couldn't have done this without the help of this guy. So you got that aspect of it, right? Then there's this whole planning aspect. He's all involved in that. Really doesn't have a whole lot to do with this thing, but he's more than happy to go along with the planning of this, the helping. Apparently he helped tie her up. And then, Mike, here's the worst part. Tells me a little bit about who this kid might be and the character of this young man. He has a memento, which is her glasses, which he doesn't keep in his place. You know what he does? He puts it on and he goes on socials and kind of celebrates with it, Mike. So in this particular instance, while he was an accomplice, I'm okay with the sentence.
I'm okay with it. I'll tell you why. You said about her developmental disability. When they were showing pictures of her, I find myself looking away because I don't want to ruin my weekend. Like it really is depressing to see that they did it to this girl, because I know kids who are developmentally disabled. She was lured into a trap. So I'm with you. I just feel like, man, 19 years old, his prefrontal cortex is not fully developed. I feel like when he's 25 years old, when his brain stops to develop. Right now, a young man, 19, his brain is a raging storm. I just feel like, hey, 50 years, I'm with it all day. It's just, man, life without parole. For a 19-year-old guy, he made a devastating mistake. He should be punished for decades. Just, man, it's just a tragedy all the way, no matter what happens.
All right, looks like we lost Mike there. Okay, Mike, thank you so much for being with me tonight. Truly appreciate it. Again, I'm Michael Ayala. It's been a pleasure being with you tonight. Folks, I want you to stick around because coming up next, it's closing arguments with Vinnie Politan. It's going to take a look at new charges filed against John Skelton after his three sons
good. No, that was all good. All right, I'll say it again. I was wondering why I didn't have a response. Thank you, Miss June. I pushed the unmute button, y'all. I don't know why it muted. It shouldn't be. Okay, so question is this. Do you believe, like with this young kid we just had, that if a 19-year-old commits this big crime, heinous crime, kills his parents, like this one did, do you believe they should go away for life without the possibility of parole because their frontal cortex is not developed? Do you believe that? Do you believe that they deserve another chance? What are your thoughts? What are your humble opinions? That's a good discussion Vinny Pulligan had. That's a very good discussion. I have sound now. I got my sound now. But do you or do you not believe that they should have a cap on the punishment?
You left him there. You hit him in the head. He's unconscious, not moving.
Do you believe they should have a cap on the punishment if these young kids are committing these crimes because their frontal cortex is not developed? And it is true, especially in young men with the testosterone surges and all of that, they can get pretty physical. They can get pretty out of control. I remember my brother, my gosh, he hit a certain age and that testosterone, he would flare up. He would scare me. It would scare me tremendously. So I guess my question to you is do you think that they need to relook at all this, or do you think they got it right? Put your opinion in the comments. I would like to know. I truly am interested in what you think. I am. Don't do adult crime. Do adult crime, do adult time. Okay. True. Are there any mitigating circumstances for you on that? Where do you stand on that? How far do you stand on that, honey? Do you have mitigating circumstances? If so, what would that be? Something that one reason why I want to go into the criminal justice with disabled people is there are disabled people with very low intellect. And they're so low that even in school, they are put in special needs classes and they commit crimes not fully understanding what they're doing. And yes, they can use in different things like not guilty by reason of insanity or diminished capacity, disabled mind, but they're treated like every other criminal, and it's just horrible. In my humble, I think it depends on the crime. So give me some examples. What crime do you believe would warrant a DP? Because we got a young girl that's getting ready to go to DP, and she's going to be put to death in 26. She was like 14 or something when she committed the crime. She was very young. We're going to do a deep dive on it. And her execution has been set. Her execution has been set. And so, y'all, that's a good question. Mitigating circumstance would have to come case by case. Okay. Thank you, Miss June. See, you're so good. I got all excited, y'all, and I forgot to do the underbelly. So I got one more row to glue down and then we're done. I was going to hand sew this, but I figure I'm only wearing this once. I mean, I'm not going to sew every little thing on it. Well, I'll probably wear other ones. I don't know. I'm not going to have a graduation party. I've always had throw my own party, so I'm not going to do one for myself on this one. So, but I'm going to wear it for an event with some people. Wearing it for pictures. I still have the one I had when I got my associate's degree. It doesn't look very good compared to what it looked like before. I'll show it to you because I'm wondering if I should do some. I need y'all's opinion. Y'all are opinionated. I need y'all's opinion. Okay, let me turn on the volume.
In this case, if not more. And yet we are missing a head, but it was taken off the body post-mortem, right? So luckily that wasn't the cause of death. Otherwise, it would be even more gruesome than we know.
I'm zero expertise in any of this, and this is not laughable, but it is laughable because I feel like I'm just gonna say Occam's razor on this one. The simplest answer is usually the correct answer. This feels like a murder mystery movie situation scenario. It makes zero sense to me personally as an observer of all of this. And I don't know how that's even possible to say. I'm sorry. I don't even know what else to say, Vinny, to be honest with you, because it was the most ridiculous statement I've ever heard from someone that is supposed to be an expert on this. And I'm going to leave that there.
Yeah, it's difficult.
That he had just as much of a motive to patricide, to kill his father, as the defendant did in this case, if not more. And yet we are missing a head, but it was taken off the body post-mortem, right? So luckily that wasn't the cause of death. Otherwise, it would be even more gruesome than we know.
I'm zero expertise in any of this, and this is not laughable, but it is laughable because I feel like I'm just gonna say Occam's razor on this one. The simplest answer is usually the correct answer. This feels like a murder mystery movie situation scenario. It makes zero sense to me personally as an observer of all of this. And I don't know how that's even possible to say. I'm sorry. I don't even know what else to say, Vinny, to be honest with you, because it was the most ridiculous statement I've ever heard from someone that is supposed to be an expert on this. And I'm going to leave that there.
Yeah, it's difficult. Does anyone think, we have about a minute and a half left here. Does anyone think the fact that she married her stepson married his, I don't know, stepmom, does that confuse the jury in trying to get to the bottom of what happened here? Does anyone think it's going to make it more difficult?
Is this the Oedipus complex syndrome?
Yeah, kind of.
Go ahead, Claudia.
Mm-hmm. Oh, yeah, I think it makes them look worse, honestly. And, I actually agree with what Josh was saying with the husband, stepson, whatever he is. I think they actually did it together. So, maybe the jury will have trouble with that and they'll have a hung jury with her. But I think they both did it. And it reminds me of that song, I'm My Own Grandpa. That would be perfect for this situation.
All right. We are out of time for tonight, but a big thank you. Josh Colesrue, Claudia King, Holland Reed, great to see you. All right, folks, before we take a break, a quick programming note. A brutal beheading and a twisted love triangle. Two rival theories emerge in week one of the Devin Michaels trial. Was it a jealous ex or a vengeful son? Watch the latest episode of On the Record with Cody Thomas. Deception, Desire, and Decapitation. It's all available right now at courttv.com, courttv.com under the shows tab, or on Court TV's YouTube channel. And that jury's deliberating right now. When we return, something else you need to know tonight, plus coming up next hour. Tonight on Vinnie Politan Investigates, she arrived with her husband, keys in hand, ready to work. But a single shot changed everything. Maria Perez de Velasquez is dead, and investigators are now weighing Indiana's castle doctrine laws. Can a fatal error like this ever be justified? Tonight, we investigate.
Join Court TV's Vinnie Politan with the latest and breaking true crime stories.
Now, let's look at the other side of all of that.
Vinnie Politan Investigates.
Okay, guys, so I did forget about the inside, so I blinged the inside. It's not much. It just gives a little finish. I'm sorry. It's not much, but it gives a finish line to the work. I hope my daughter likes it. Wouldn't it be cool if my daughter wore it when she graduates next May? It's confusing but funny. The girl here in Florida who offed her parents was aw. I just wish there was something else for these youngins who commit these heinous crimes, because something went wrong for them to go there. You know, they're not born that way. There's something that happens. It's not inherent. It isn't. I'm trying to find something for us to watch, y'all. It's a long day. I'm sorry. We are waiting for verdict. I'd look at, there's nothing on live right now. It is like, oh, a Vulcan sues YouTuber over review of fitness products. Ah! Don't ask a YouTuber to review something. You may not like what you get. If you listen to I'm My Own Grandpa, make sure you have notepad to take notes or look up the lyrics because it's hard to follow. I would look up the lyrics. Okay, why don't we just have some fun? Let's see. I'm My Own Grandpa is a novelty tune by Dwight Lytham and Mo Jaffe in the 1940s. But it is copyrighted. Because it's copyright, I can't provide the full lyrics verbatim. But I can give you detailed summary and the taste of a couple of lines so you can get a flavor. Well, guess what? I think I might be able to go somewhere else to get that. Oh, scratch itch. I'm My Own Grandpa lyrics released in okay, here it is. All right. It sounds funny, I know, but I really is so. Oh, I'm my own grandpa. I'm my own grandpa. I'm my own grandpa. It sounds funny, I know, but it really is so. I'm my own grandpa. Now, many, many years ago when I was 23, oh, I got to move it over here. My neck doesn't like that. Okay. Many, many years ago when I was 23, I was married to a widow who was pretty as could be. Ha! This window had a grown-up daughter who had hair of red. My father fell in love with her, and soon they two were wed. This made my dad my son-in-law and changed my very life. My daughter was my mother because she was my father's wife. Okay. I'm reading that again. To complicate the matter, even though it brought me joy, I soon became a father of a bouncing baby boy. My little baby then became a brother-in-law to dad, and so became my uncle through it, though it made me very sad. For if he was my uncle, then that also made him brother of the widow's grown-up daughter, who, of course, is my stepmother. Father's wife then had a son who kept him on the run and became my grandkid, and he became a grandchild, for he was my daughter's son. My wife is now my mother's mother, and it makes me blue because although she's my wife, she's my grandmother too. Now, if my wife is my grandmother and I'm her grandchild, every time I think about it, it nearly drives me wild. For now I have become the strangest case you ever saw. As a husband of my grandmother, I'm my own grandpa. I'm my own grandpa. I'm my own grandpa. Sounds funny, I know, but it really is so. I'm going to get that stuck in my head, and I'm not going to get it out when I go to bed. Y'all.
I know that the defense requested that. We have a unique and clearly a special life in Jennifer Tower as well. I spoke about that earlier. I'm going to adjudicate you guilty of count 2, first degree premeditated murder on Jennifer Tower. I will run this sentence consecutive to count 1. I will sentence you, Mr. Tower, to life in prison without the possibility of parole. Count 3, the fleeing or attempting to elude law enforcement with lights and sirens. I'll adjudicate you guilty. Let's see, this is what degree felony? State third. Sentence you to the maximum of 5 years in prison to run concurrent with count 2. All right, Mr. Tower, you have 30 days to appeal the judgment and sentence of this court. If you cannot afford an attorney for that appeal, one will be appointed to represent you.
What about the truth?
Good luck to everyone. Court will be adjourned.
Life without parole. He never had a life, but he took 2 very special lives, and that is the tragedy of this case. All right, folks, take a look at your screens. We have a missing child who needs your help tonight. This is Micaiah Neal. Micaiah is 16 years old, missing out of O'Fallon, Illinois since the 12th of November, earlier this week. If you see Micaiah, pick up the phone, make a call, make a difference. You can call 911, 1-800-THE-LOST, or you can call the O'Fallon Police Department in Illinois. That phone number's on your screen right now. Take a look at the picture. Let's see if we can get Micaiah to a safe place tonight. Don't go anywhere. We have another hour of live true crime. Vinnie Politan Investigates is next. In the meantime, please don't forget to hug the kids.
Y'all, that is really hard for me to see. I hate seeing those. Those really bother me. June, I guess I'm going to have to demonetize. Guys, we are up to 3,492 subscribers. Come on, help us get to 3,500. We would love to get to 3,500. We need to get there. Yeah, I need a cork board and tacks with yarn to try to figure out that song. Ain't that the truth? Oh, my ankles are swelling. I got to get them up. Yeah, I will have to listen to it. I will try and listen to it. I can't always hear music, so we'll have to wait and see. we'll see if I get a copy or get a thing on monetization because of all the court TV stuff. We'll see what happens.